to take a short adjournment. I should be around 2 hours. That's the agreed time I'll have with her, so that we can change the batting order, and she can. I can move to my chambers, and she can move in with your permission.
Yes. We'll just time ourselves during the course of the day, as we indicated yesterday. We're going to try and finish today, so we might have to sit late again.
Yes.
We are prepared to do that, as long as you just take into account that we've got administrative staff that we have to accommodate.
Indeed.
We're trying our best in the background to arrange everything. Yes, Ms. Pillay?
Sorry, judges, we're struggling to hear online. I don't know if there's a problem with the technology, but it seems to be breaking in and out.
Can you hear me well now?
Yes, now I can, perfectly. Right. Thanks,
and
Treasurer.
Mr. Breitenbach, can you just test the microphones?
Can you hear me?
Yes, much better. Thank you. Thanks very much.
We're adjusting the device that we use for the recording of the voice and to transmit online, and hopefully it will work better. Yes, Mr. Breitenbach.
Thank you. Members of the bench, I followed the argument yesterday, and in the light of that and the fact that I have prepared a note of the argument, I intend moving more swiftly than you might have anticipated, having had a look at what it is that I intend doing today. So firstly, we'll deal briefly with the interlocutory applications. Then I wish to spend a couple of minutes, no more than that, on what we contend are the 6 key events, factual events. Then we'll outline the relief which the applicant is seeking against the Section 194 Committee and the Speaker. In other words, the relief against the National Assembly. And when doing that, we will explain the implications for that relief of the dismissal by the Constitutional Court on the 6th of May of her 11 March rescission application. That was her first application for rescission of parts of the order of the and judgment of the Constitutional Court on the constitutionality of the new rules, which was handed down on the 4th of February this year. So we're going to deal up front with the implications of the failure of the rescission application. What we shall also then do in limine is deal with our submission, why raise judicata, or issue estoppel, or our law on repeat interlocutory applications preclude her application for interim interdict pendente lita aimed at prohibiting the National Assembly from continuing with the impeachment process. If the court is with us on that, then the relief against the National Assembly need not be considered on its merits. However, we must cater for the contingency that the court is against us. And so in the alternative, we will deal very briefly with the outer requirements. The reason being, we understood our learned friend yesterday to concede, contrary to his client's position in the affidavits, that outer applies. He preferred the refinement in the Gordon case of outer, but it's essentially the same line of decisions, and the principles on which we rely are indistinguishable as between those two sets of cases. Having done that, we shall explain why in our submission the application for an interim interdict pendente lite prohibiting the Assembly from carrying on with the impeachment process does not meet those requirements. While dealing with that, we shall also deal with the reliance on Rule 89, the sub judice rule, which is one of the grounds for the interdict which is sought. As my learned friend Mr. Masuku developed the argument, that in his submission stands separately from the outer requirements.
Let me just check. I don't see, I didn't call on Advocate Masuku. Just check whether he's online.
My Lord, yes, he indicated to me that he was going to assign Mr. Simelane for the first part. I don't know if he is online.
Mr. Simelane is on.
Thank you, my Lord.
Thank you.
Then we shall deal with the alternative claim, the claim in Pred 2 of Part A. That's the claim for an order suspending the Constitutional Court's dismissal of her challenge to NA Rule 129V, the one providing for the appointment of a judge to the independent panel. Our contention is that that's a non-starter for reasons that we shall explain.
Can I just ask you on that point, when we deal with that, it's just to take us to the page in the record where the application is to be found, the new application in the Constitution.
Could I do that right away, just to...
Yeah, because when we left here last night, I left all my documents here.
Yes.
And I tried on my laptop in the course of the night to trace the document, and it was difficult.
Needle in a haystack. The reason is it's Annexure PN12 to Annexure PCA1 to Advocate Mkhwebane's latest affidavit. It's in Volume 2 of what is now referred to as the supplementary record, or the interlocutory applications record at page 108.
Thank you.
So, in the alternative to a conventional interim interdict pendente lite, she has this application under paragraph 2 for an order suspending the Constitutional Court's dismissal of her challenge to Rule 129V. And that's based on, in the first instance, Uniform Rule 45A, alternatively Section 172(1)(b) of the Constitution. Our contention is that the application is a non-starter. In other words, it's incompetent with respect. Alternatively, it should fail for the same reasons her claim for an interim interdict pendente lite should be dismissed. Then there is a discrete order sought against the Speaker, which is an order directing that she withdraw her 10 March 22 letter to the President. We'll deal with that. And lastly, and somewhat unusually with respect, we will deal with her claim for personal punitive costs against the Speaker. Why I say somewhat unusually is my learned friend didn't argue the point yesterday. And he seemed to reserve the right to address argument to your lordships in reply for the first time. That puts us at something of a disadvantage. What we will do, however, is we will focus on the case made out in the papers, the founding affidavit, and in my learned friend's heads of argument. If something else arises, we may seek your lordship's leave just to file a note afterwards. If, in other words, he raises something else which is not on the papers. We'll also deal with the proper costs order to be made if the present application against the NA is dismissed, as we submit it should be. Your lordships will appreciate from what I've said that, save to the extent that it is relevant to the claim for an order directing the Speaker to withdraw her 10 March letter to the President,
there seemed to be a problem with the in-house recording. Because we are recording on Teams platform as well. And customarily, arguments are not recorded on the official system. So in the meantime, we're going to continue. We will record on the Teams platform. And if you can ask for them to reset on that side, because we'll have a backup recording on Teams.
Thank
so
you.
You may proceed, Mr.
Thank you, my lord. I was making one final observation, and that is that the issue of whether the inquiry has commenced for purposes of Section 194(3)A is not directly relevant to the case against my client. It's indirectly relevant because the contention that it hasn't commenced goes to this order directing the Speaker to withdraw the 10 March letter to the President. I shan't accordingly dwell excessively on that. My learned friend Ms. Pillay obviously has to deal with that, and I don't wish to duplicate the argument that
She
she...
developed a number of alternatives
Yes.
in her head.
Indeed.
That's all.
That then brings me to the interlocutory applications, and as I understand the situation there, it's in my note pages 3 to 5. There is no opposition to the interlocutory applications by any of the parties to have further affidavits admitted in evidence. There were affidavits, for instance, in the run-up to the hearing, or the initial scheduled hearing date, and in the run-up to this, and there's no opposition. There wasn't a formal ruling yesterday. I'm going to argue the case.
Speaking for myself, and I'll just check with my colleagues, I don't think we need to hear any argument on the admission of the affidavits. It's a striking out that might be relevant for some of the parties.
Thank you.
There's agreement with the bench that all the applications for further affidavits that is filed, that should be condoned, and we can proceed.
Thank you very much. That leaves one interlocutory application which affects my client, which wasn't argued yesterday, and it's part of the application brought in Advocate Mkhwebane's replying papers to strike out portions of the papers, the answering papers. In the case of my client, it is about 10 paragraphs 30 to 40 of her answering affidavit. My learned friend didn't argue that yesterday. It's addressed in paragraph 5 of the note on page 3 with reference to the argument in our heads, which is more detailed. We stand by that and have nothing to add.
And Mr. Mpofu also argued in his heads, so he indicated yesterday abandoning any of the arguments that's been taken place, and we'll deal with them on that basis.
Thank you. That brings me to the 6 key facts. I identified 4 in the note, and I wish to add 2 very briefly to that. Could I ask the court to turn to page 11 of the note? It's part of the in limine section, page 11. These are put up as 4 factual building blocks of the in limine points, res judicata, etc., but the facts are cross-cutting. There's 6 of them. So the first one is that on the 4th of February 2020, Advocate Mkhwebane launched case number 2107 of 2020 in this court. Now, like the present, it was an application in which she sought 2-part relief. In Part A, she sought to restrain the National Assembly from continuing with the impeachment process, initiated by the same motion of Ms. Mazzoni MP, which is currently before the Section 194 Committee. And she wanted that order until her challenge in Part B to, amongst other things, the constitutional validity of the new rules had been finally determined. One of the grounds on which she sought to interdict the impeachment process, which was supported by the ATM, the 16th respondent in that case, was its continuation would breach National Assembly Rule 89. In other words, the sub judice rule, which provides...
now the 11th respondent
in this matter.
Represented by Mr. Masuku before us.
That is correct.
Just for completeness sake.
But the important thing, for purposes of res judicata, is that all political parties represented in the Assembly, all of them, were respondents in that case, as they are in the present matter. So Advocate Mkhwebane was there, the Speaker was there, the Section 194 Committee Chair wasn't there because that committee had not been established yet. The President was there, and all the parties represented in the NA were there.
And the President abided the decision according to the judgment.
That is correct. I would ask the court, you don't have to do so now, to compare what one finds in the judgment of His Lordship Mr. Justice Saldanha, being the quotation from the notice of motion at page 589 in the bundle of authorities, paragraph 3.
I have in fact done the comparison last night.
With the relief sought in this matter. And essentially, as far as the interdictory relief is concerned, the interdict pendente lite, there is no practical difference between the order interdicting and prohibiting the first respondent, that's the Speaker, from taking any further steps in the implementation of the process envisaged in Section 194 of the Constitution under the rules, and the relief sought in paragraphs 1.2 and 1.6. Why do I say that? When the first case was brought, my learned friends referred to a 17-step process. That was the analysis that was done in the answering affidavit. We were some way down the track, if I can call it that. What had happened at that stage was that the Speaker had certified that the notice of motion was in order. That was under Rule 129S. What had to happen next was that a committee, the independent panel, had to be appointed to consider whether there was prima facie evidence supporting the charges and to advise the Assembly. So the next step that had to be taken was a step by the Speaker, which would be the appointment of the independent panel, which would then do its work, and there are certain rules relating to how it had to work, 129X, 129V, and then its report would be considered by the Assembly, which, if it decided that a Section 194 committee had to be established, would then so resolve, and then I'll come in a moment to the parts of the rules regulating how that committee must function. So we were at the point before the appointment of the independent panel. That's why the relief was directed at stopping the process there. The Speaker can't take the next step. But the idea was to stop the process there. Now we're further down the track. The Assembly has established the committee. The committee has met. The facts of common cause, they set out in the Speaker's affidavit. There's a factual chronology, and I'll give you the references later on to the facts, the paragraphs in the answering affidavits which you can accept as not being disputed as far as the facts are concerned. Interpretation of those facts is another matter. I'll give those references to the court if it will assist. But we're further down the track. Now the focus is on, obviously, an attempt to stop the committee. But the point is it's still stopping the process. So we see references here to 1.2, prohibiting the Speaker or the Assembly from authorizing the commencement or performance of any functions of the committee established in terms of 194. And para 1.6, the first to third respondents prohibited from taking any further steps or performing any acts aimed at commencing or proceeding with the process envisaged in 194.
So that's the issue.
That's the issue. It's the same. They just wanted to stop it at an earlier stage, and they failed. And now they want to stop it again. And in a moment we will be addressing submissions to the court saying you can't do that. You've tried. Pending what? It's pending the outcome of the Part B challenge, and as I shall demonstrate in a moment, these current rescission proceedings in the constitutional courts are aimed at trying to keep alive an aspect of that challenge, the Part B challenge, the challenge to Rule 129V. We're in the same boat as we were before. A full bench, differently constituted, considering the same question. And the question is that legally permissible? And
I'll ask you this. There was some debate with your colleagues, yesterday. Are you in agreement with me, my understanding, that issue is stopped has been fully assimilated into our law?
Yes, it's undoubtedly so.
I don't think there's any question about that.
Undoubtedly.
But there are some judgments that say the court may come to the rescue of a party where issue is stopped is raised under certain circumstances and it will be grossly unfair.
Unfair, yes.
That's how I understand it.
And I respectfully agree with that proposition. So what's grossly unfair about allowing the process to continue? I ask rhetorically. After the Public Protector has had her day up to the Constitutional Court on her challenge to not just the constitutionality of the rules, but the Speaker's application of the rules, which is what some of her counter-application was, and the cross-appeal was considered with. Fundamentally,
so I understand it properly, is your view also that issue estoppel is essentially concentrates on the sameness of the issue it's irrespective really of the remedy and course of action or the relief that businesses.
Yes. The parties must be the same and the issue must be the same. And we've identified what the two crucial issues are. This court has read the judgment of the previous full bench that dealt with it. In paragraph 32, the first one was whether the continuation of the impeachment process before the proceedings flowing from case number 2107 have been finally determined will breach the sub judice rule. The second is whether the NA should be precluded from continuing with the impeachment process until a challenge to the constitutionality of Rule 129V has been finally determined. That was a component, that challenge to 129V. His Lordship, Mr. Justice Delama, will well know, because he heard that case. That was one of many points taken. That there were a welter that were dealt with. One can, I'd like to retrofit it this way. Let's assume, against what I've contended, that we're dealing here with a second interlocutory and not with a final judgment to which either res judicata or issue estoppel applies. Well, what does our law say about that? We deal with that on page 11 in paragraph 33. 33.1. There is a general reluctance, and this is the Constitutional Court speaking, approving a case called Mayer and Mayer in Zondi. The reference is given. To allow the variation of interlocutory orders granted by courts, unless the facts have changed in such a way that had they existed at the time the interim interdict was refused, the granting of the interim interdict would have been justified.
You don't regard the fact that the committee has now been established and, according to the rationale of the respondent, has commenced with its work as a substantial change in effect
Not at all.
to affect the issues.
Not in the slightest. It is because the reason, Justice Delama, is this. This case is not brought because of the relief is not sought because something has happened in the committee, which is she's unfairly not been allowed to cross-examine someone or whatever. The criticism directed against the committee is at one thing and one thing only, and that's they've decided to carry on with their work. And they're bound to do that. Why is that? Well, 1943 it empowers and obliges the committee to do this. It's one of those provisions which is a power coupled with a duty. 237 of the Constitution says that where duties are imposed, they must be performed diligently and without delay. And the rules of the National Assembly make it abundantly clear. In the new rules, and specifically the parts which are not impugned or sought to be impugned by this rescission process is how I'll describe it, because it involves more than one rescission application. A copy of the rules is in volume 7, NMN3, bit of a tongue twister. The rules relating to the committee are to be found from page 687 onwards, halfway down the page. Committee for Section 194 inquiry. That follows on 129Z2, which refers to in the event the Assembly resolves that a Section 19 committee be proceeded with, the matter must be referred to committee for a formal inquiry. 129AA then deals with the establishment. 129AB's composition. And I pause to mention that the only function given to the Speaker in relation to the work of this committee is there in 129AB1. Namely, the Speaker determines how many members shall be on the committee. And we know that she ultimately determined 36 people in this case. From then onwards, the committee takes over. 129AC. The committee must elect one of its members as a chairperson. 129AD, its powers and functions. it must proceed to conduct an inquiry to establish the veracity of the charges and report to the Assembly. Sub 2, ensure that it is conducted in a reasonable and procedurally fair manner within a reasonable time frame. Sub 3 is the Audi provision. The proviso to that is the one which was severed by the Constitutional Court. And 4, for the purposes of performing its functions, it has all the powers of parliamentary committees, as provided for the Constitution, the applicable law, and these rules.
Now, my question on that is the issue was raised yesterday about Mr. Dianchi
Waking up in the morning.
deciding on his own,
Yeah.
A, to suspend on the advice of Mr. Tsinoli, and then secondly, reconvene
Yes,
when he woke up one morning.
Yes.
That's the meeting of all the twos,
yes,
2nd of February 2022 meeting.
yes.
And in reading sub 4 of 129 AD, I'm thinking there must be rules that
Yeah.
are not placed before us as to how committees function and how meetings are called, etc.
Your Lordship has put your finger on the problem here. Why are those rules not before you? Because I submit you will look in vain for either of those points in the Public Protector's papers in this case.
Now, I couldn't find it. I went searching. You would have noticed that this was lying open in front of me.
It's just not fair, my
You
Lord,
can-
for a point. That was a big point. More than half an hour's argument directed to it. But where in the papers is this point taken? Had the point been raised, Mr. Janchi would doubtless have referred the the court, to a couple of rules, National Assembly rules. NA Rule 164, sub A, the chairperson of a committee may interrupt or suspend the proceedings or adjourn a meeting. Or 161 read with 2A. The committee meet whenever necessary as determined in accordance with the rules and the decisions, directives and guidelines of the Programme Committee in accordance with Rule 210. A meeting of a committee may be called in terms of Sub-Rule 1A by the chairperson of the committee. Then further provisions about 1/3 of the members can call a meeting, as one would expect ordinarily. The Parliament is a sophisticated deliberative body, very sophisticated. There are rules in the Constitution. There are, in other words, provisions of the Constitution dealing with how it functions, and it obviously has rules. The Assembly has rules, the NCRP has rules, and there are joint rules. These matters would have been canvassed. It is not a question of Mr. Janchi having done something wrong. He did something which was obviously right. He had accepted the advice of Mr. Tsinoli, the acting speaker, not to convene a further meeting of the committee while the Constitutional Court proceedings were pending. And the reasons for that are explained in his affidavit to the Constitutional Court. The relevant document excerpt is attached to the Public Protector's papers, and it's also quoted in the Speaker's answering affidavit. Essentially, it was that if the things carried on in the meantime and the Constitutional Court was against the Speaker on the 2 points which were taken on appeal, then not only would a whole lot of stuff been done which would not have been validly done if the order of unconstitutionality in relation to Rule V was confirmed, because that operates ex tunc, but the hearing of oral evidence would have started and witnesses would have been called under circumstances where the committee would have been obliged by 129 AD3, the proviso, read with Section 18 of the Superior Courts Act, not to allow her legal representatives to participate in the committee. And that, in those circumstances, Mr. Tsinoli gave the advice with which Mr. Janchi accepted, and my learned friend seemed to agree that that was the right thing, to suspend. But then a strange thing happened, and that brings me to the second key fact. So the Constitutional Court hands down a judgment on the 4th of February. And it says, in effect, the challenges to the rule are bad except for one of them, which is of prospective effect only because the hearings haven't started. Paragraph 110. I'll get to paragraph 110 and its implications for the debate about 194.3a briefly later. And it's clear on a reading of that judgment that the Constitutional Court signalled through its urgent dealing with the case, its acceptance of the direct appeals, that it appreciated and expects that the process will now carry on. It made the point in its judgment twice, as I recall, that the incumbent's term ends in October 2023. And it said that if the court processes had run their ordinary course through the SCA, this SCA to the CC, that would tend to reflect adversely on our legal system, because this is a time-sensitive and important matter. And one mustn't lose sight of the fact that the charges against the incumbent are themselves rooted in strident, perhaps that's too strongly put, strongly stated criticisms, sometimes resulting in personal cost orders, which were not overturned by the Constitutional Court when those matters reached the Constitutional Court. But that's something I have no doubt that my learned friend Mr. Budlander will deal with. So we're dealing with serious charges of serious misconduct, which the Constitutional Court said must be considered by the committee. What did Mr. Janchi do? He convened a meeting of the committee so that they can consider what to do. And what happened at that meeting is described in his affidavit. And perhaps it's as well just to go there, seeing as so much is made of that. May I just give you the list of the passages in the affidavits where you'll get essentially the undisputed facts. They're summarized in the Speaker's answering affidavit in volume 6, page 552 to 566, paragraphs 52 to 75. That takes us up to the meeting on the 29th of March 2022. This is everything from the 16th of March 2021, when the Assembly voted to establish the 194 Committee. Secondly, they're described in Mr. Janchi's answering affidavit. That's in volume 8, 721 to 730, paragraphs 8 to 30. That's also up to the 29th of March, because they were filed at the same day. Then they further described in a second answering affidavit by Mr. Janchi, which is in volume 11, 1046 to 7, 9 to 13. That takes us from 29 March up to the 20th of April. Then they described in the joint practice note, which I and my colleagues for the first, second, third and fifth respondents filed on 11 May. One finds that in the interlocutory record or the supplementary record, volume 1, pages 43 to 51, paras 3 to 21, and I point out that the correctness of that was admitted by Ms. Mkhwebane in her affidavit of the 15th of March, which is in the interlocutory record. May, I apologize. 15 May, at interlocutory record volume 1, page 10, paras 7. And they lastly described in the affidavit of Ms. Jonker for the DA, the latest affidavit. That is an interlocutory record 3, 264 to 7, paragraphs 20 to 30. That takes us from 11 to 14 May. So those are the key facts. Now this much discussed meeting of the 22nd, what I think was a carnival of illegalities, or festival, a festival of illegalities. That's in Mr. Janchi's answering affidavit, which is in volume 8 of the papers. And if I could ask you just to turn, this is one of the few passages in the record I will take you to page 726. And the first point I wish to make is that every time there is a meeting of this committee, it happens in public It is live streamed, and the links, the URL links are given in Mr. Janchi's affidavit.
That's where that one of those, I actually checked the links when the affidavits were filed.
Yes.
In one of the meetings, that's where the term Festival of Letters arose, and I don't know who said it, but somebody mentioned the word Festival of Letters.
Festival of Letters.
And that's where Mr. Mpofu got it from.
Okay, so he wasn't an original, as we used to from him. So at 7:26 to 21 to 23, this meeting is described. So firstly, Mr. Janchi says he decided to convene the meeting and that the committee resumed its work. What did they do? They considered the import of the Constitutional Court's decision of 4 February. They also considered a request by the applicant that the committee halt its proceedings until the ConCourt had determined an application for the rescission of part of its judgment and orders, which she intended to make. And now we see what it decided. It decided 4 things. Paragraph 22. 1, it resolved that there was no legal basis for it to halt its work, and it had to continue with its inquiry into the charges. 2, it's in paragraph 23, it adopted a set of terms of reference governing the process going forward. 3, it resolved to identify evidence leaders pursuant to the terms of reference. And 4, it adopted a draft program as a working document, and that's the program which at that stage envisaged that evidence would be start being led on the 4th of May. So that's what the committee did. Now, what's wrong with that? I ask rhetorically. The Constitutional Court has dismissed an application for the wholesale invalidation of or confirmed the dismissal of confirmed the dismissal of an application for the wholesale invalidation of the rules. It said, in effect, the inquiry can and must continue. And the committee was getting on with its business.
So are you saying that the committee was busy with its business? Mr. Zanoni then received information, and for want of another word, the pause button was pressed until such time as the judgment came from the Constitution.
That's what that.
And then when the Constitutional Court judgment came, the pause button was no longer activated.
Correct.
And it carried on.
Yeah. And the person who could put that pause button was Mr. Janchi under Rule 164. He could suspend the proceedings of the committee. He did so effectively by not convening another meeting, exercising his 161.2a power, Rule 161.2a power. But you see, the problem is these points that this is somehow irregular were not taken on the papers, and it would have been explained to you had they been done. But
He
if
makes
one,
that point, and I pointed it out to Mr. Mpofu yesterday. At 7:26 in paragraph 20, he says, I accepted Mr. Chinoli's recommendation and consequently did not convene a further meeting of the Section 104 committee.
Mr. Janchi, in this affidavit and the others, as the Speaker has done also, they have given a matter-of-fact, dispassionate account of the events. What one reads here, there's no spin. This happened, then I accepted this recommendation, then the next thing happened and I convened a meeting of the committee. The committee met, that dealt with these things. You can view the proceedings of the committee on the YouTube. Everything happens in public because it's in the nature of the Parliament that it is a public forum. It's where our representatives meet to determine and deliberate on matters of national importance. I'll get to the claim for personal costs against the Speaker later on. It's strikingly at odds with what one reads in the affidavits as to what has actually been happening in the Parliament. Parliament has been trying to continue with this process despite challenges which have had the effect of slowing things down, and that's not just legal challenges, it's also the COVID challenge, which created a significant damper, put a significant brake on all of its business, as it did on the rest of the country. So, my Lord, getting back to the facts, I'm weaving the submissions around the facts, as you'll appreciate. Go back to page 11 of my note. So, having brought this application for an interim interdict, pendente lita, on the 9th of October, the full bench of this court, the Lordships Saldanha, Steyn and Samela, refused to grant the interim interdict. The court, as His Lordship presiding pointed out to my learned friend, rejected Mkhwebane and the ATM's reliance on the sub judice rule in the course of its judgment. The reference is given, paragraph 108. She sought leave to appeal from the full court and then directly to the Constitutional Court. She didn't ask the SCA for leave to appeal. They failed. So the outcome of that case, the Part A, is therefore that the question whether she can interdict the Assembly from processing the motion for her removal from office pending the final determination of case 2107.
2017, I think.
Is it?
No, it is 2107.
Apologize. That case, the earlier case. That has finally been determined adversely to her. And it's on that basis that we submit, whether you look at this through the lens of res judicata, as we've submitted in paragraph 31 of our heads of argument, issue estoppel as in paragraph 32 of the note, or our law on repeat on repeat interlocutories, that she has, and she's not permitted to ask this court the same question again. She's not permitted to seek the same relief in these proceedings as she did previously. Just picking up on Justice Delama's question to me about changes in the facts. There have actually been significant changes in the facts since then. But in order to activate the court's jurisdiction, the changes have to be facts which, had they existed at the time when the initial refusal,
Favourable to the applicant.
that's correct, would have justified the grant of an interim interdict. Courts are not totally inflexible. They realize that things, circumstances, facts and circumstances change. But what's happened here? The process has moved further along. And I suppose if one were to look at it in a sort of myopic way, one could say unfavourably to her. That's the process in Parliament, because the Nkabinda Committee found that there is prima facie evidence to support the charges. The Assembly accepted that advice and has constituted the 194 Committee, and she's now in jeopardy in the formal sense envisaged by 194, because the committee has been established to conduct the inquiry into the allegations against her.
Let me ask you this, what about this important submission that there may be facts which are unfavourable to, which are in favour of the applicant, namely this whole issue around the SMS?
I'm going to deal with that in some detail in a moment. The short answer to that, which I shall elaborate on, is that one needs to distinguish very carefully between speculation and the facts which one knows from the record and the inferences that one can reasonably draw from those facts. Inferential reasoning reaches a point where it might be entertaining around a dinner table, but it's not a basis for a judicial pronouncement. And with respect to my learned friend and his client, we have an application. Now, that aspect of the case is based on speculation and conjecture. But there are key facts that have changed adversely to her currently. Remember, the case was brought pending the final determination of her challenge to the rules. Well, by right, in ordinary parlance, that was finally determined adversely to her on the 4th of February when the Apex Court delivered its judgment. Now she sought rescission of that judgment. And it is correct that that is a step which the rules and our common law provide for. The problem is, if one looks at the content of that application, as we have done in our papers, in our heads, and in this note, what one finds is that it is an impermissible attempt to relitigate points which were decided adversely to her. That's one of the problems, main problems with it. So, for instance, one of the grounds of rescission raised was the court misapplied its judgments in 3 earlier cases, Heath, etc. That's an appeal point. It's saying you got it wrong. That is not a basis for rescission, and the Constitutional Court has expressed itself recently very firmly about that.
You compare
Yes.
majority judgment.
Yes. The other problem with that application, which we've also identified, is that there are contentions that the Constitutional Court did not consider this, that, or the other aspect. But as we've explained in our heads, and it's in the note as well, I'm not going to, time won't permit me to go there, and I don't think it's necessary for a reason I'll come to in a moment. It's simply not correct. Frankly, those allegations are not true. The Constitutional Court did consider those issues and decided them adversely to her. Now that is not a proper basis for rescission. And if and to the extent the court has to peek into the merits of that application, the court will see that that essentially is the problem with it. The Constitutional Court made findings which are consonant with what I have now submitted to the court on the 6th of May, when it dismissed that application. It didn't simply issue an order dismissing the applications for direct access. In the supplementary bundle volume 1, at page 85, PN9, one has the order. And it contains reasons, albeit brief, for the summary dismissal of this application. And perhaps I should just put something else to bed while I am dealing with that. The rescission application, the first one, like the second one, was brought under Rule 18 of the Rules of the Constitutional Court, which deals with direct access. It is not a rule which makes any provision for the filing of answering papers by the respondent or replying papers by the applicant, unlike Rule 19, which deals with applications for leave to appeal. It says you must bring an application setting out your grounds, the nature of the relief sought, and whether in your submission as the applicant the case can be dealt with by the court without the hearing of oral evidence, and if it cannot, how such evidence should be deduced. That's what Rule 18.2 says. 18.3 says if any party wishing to oppose it must deliver a notice of intention to oppose within 10 days. 18.4 says after such notice of intention to oppose has been received by the registrar, or where the time for the lodging the notice has expired, the matter shall be disposed of in accordance with the directions given by the Chief Justice, which may include A, a direction calling on respondents to make written submissions to the court, or B, a direction indicating that no written submissions or affidavits need be filed. And then 5 says, applications for direct access may be dealt with summarily, without hearing oral or written argument other than that contained in the application itself. And there's a proviso which says that the court can't grant such an application if notices of opposition have been filed without first directing that written submissions be filed by the respondents opposing. So an application can be dismissed summarily on the basis of the application itself. That's the rules of the Constitutional Court. Now the Constitutional Court justices are obviously well acquainted with that. They deal with literally hundreds of applications, either for leave to appeal or direct access applications every year nowadays. The caseload is astronomical after the amendment of the Constitution about 10 years ago. What did the Constitutional Court do? 2 months and 2 days after giving its judgment in this matter, the application was brought, the rescission.
Can you just, I see it's a spokesperson of Parliament. He doesn't have a voice here. Mute him, please. Can I just request, as yesterday as well, all participants, except the parties that need to speak in court, can you please mute your microphones? I know sometimes one forgets to do that, but please work with us. Yes, Mr. President.
So the Constitutional Court considered this application. The rescission application was brought on the 11th of March, a week after the judgment was handed down, and just short of 2 months later, on the 6th of May, delivered an order which reads as follows. The Constitutional Court has considered the application for direct access and rescission. It has concluded that there is no need for directions to be issued in terms of Rule 18.4, calling for written submissions and or answering affidavits. The Court has concluded that the rescission application does not establish any rescindable errors in the judgment. There are also no exceptional circumstances that warrant the rescission of the judgment. Therefore, the Court has concluded that the application should be dismissed, as no case has been made out for rescission. The Court has concluded that the application for direct access should be dismissed, as no case is made out for direct access. The Court has decided not to award costs. And then the orders follow, both applications being dismissed. This is an order which is signed by the Registrar of the Court and stamped, addressed to all of the parties. It is an official act. In accordance with our law, the presumption of regularity, it is presumed to be valid until it is proven to be invalid by evidence adduced to a court. There are 2 proceedings in which that is potentially sought. The first is the second rescission application brought by the present applicant in the Constitutional Court.
The one on the 10th of May.
Indeed.
Filed on the 11th.
And there are also, those submissions are echoed or repeated in this court, where one has a submission made in paragraph 29 of Ms. Mkhwebane's affidavit that the order is, there's a lingering suspicion around that order arising from the SMS, and I'll get back to that in a moment. But for the purposes of the eliminate point, what I wish to point out is this. The situation has changed materially adversely to Advocate Mkhwebane from that which obtained at the time that the Saldanha Court was considering this matter. Her challenge to the rules has been finally determined, and in one limited respect adversely to her, but that doesn't affect anything that's happened so far. The application for rescission of the final determination of that by our highest court has failed. So there is no jurisdiction in this court with respect to reconsider this application for an interim interdict suspending the parliamentary process from carrying on. That brings me to an issue concerning the second rescission application. Before I deal with the merits of that application, I'd just like to deal with its implications. Firstly, generally as regards the rescission order that was granted, and secondly, as regards the relief sought in this case. Because, of course, the relief, the centerpiece of the relief is the first rescission application. Let's just deal generally with the consequences. So what is the legal consequence of the bringing of the second rescission application? We allude to this at page 8 of the note in paragraph 20. And the first point that we wish to make is if one has regard to paragraph 155 of her founding affidavit in this case, in volume 1 at page 53, she conceded, for purposes of Part A, that suspension of an order impugned in a rescission application is not automatic, but may be ordered on the application of a party. She accepts that that's the law. So that's a legal concession. And she, as the court pointed out to my learned friend yesterday, she's seeking in paragraph 2 of Part B an order that the common law be developed to result in such automatic suspension. But, my lords, for purposes of this case, there is a concession that the making of a rescission application does not suspend the operation of the order sought to being rescinded. Now, that is a concession of law. The court is not bound by a concession of law if it is wrongly conceded. But we submit the concession is correctly made, and we refer the court to superior court practice. The references are given and the authorities cited there, but there are essentially three reasons why the concession is right. The first is found by Rujay in the United Reflective Converters case, that's referred to in paragraph 21.1. There is no substantive rule of law that an application to vary or rescind an order or judgment automatically suspends its operation. It's on page 8 of our note. The second is pointed out by Justice Mayer in the erstwhile tenants of Williston Court and others in versus Luray Investments matter, paragraph 20. It's for that reason, it's because there is no automatic rule of law, that we have Uniform Rule 45A. That allows a party who wishes to have the operation and execution of an order that's the subject of a rescission application suspended, pending the outcome of the rescission application. You can go to court to get such an order. They're doing so in this case, in paragraph 2 of Part A. They've brought an application under Uniform Rule 45A. Now, you know, we submit.
Can you check who that person is that keeps on having? It's Prof. Manju. I can see from here. Yeah, she muted herself.
So, a rule has been created to allow court to suspend the operation of an order which is the subject of a rescission application, precisely because the law doesn't have that effect. You have to come to court to get that relief under Uniform Rule 45A. We have submitted, though, that rule does not apply to orders made in rem. It applies to orders in persona, where the particular person, let's call it the judgment debtor, can seek relief. But where one's dealing with an order about the constitutionality of a rule of general application, that person doesn't represent any and all people who are affected by that. It affects all of us equally, at least to the extent that we're all subject or equal before the law. And the third reason, also given by His Lordship Justice Mayer in the Luray Investments case in paragraph 18, is this: is that when enacting the Superior Courts Act, the legislature gave specific attention to further steps in concluded litigation and what those further steps should be, the effect of them on the operation and execution of orders. I'm referring obviously to section 18.1 of the Superior Courts Act. And it provided that if you apply for leave to appeal or leave is granted and you're on appeal, then that is the effect. But it did not add rescission, which it could have. It left, in other words, the position regulated by Uniform Rule 45A. So, where does that leave us as far as the present case is concerned? Could I ask you to just turn to the notice of motion? I'm working with the amended notice of motion, which is in volume 11 at 1018. And for I've already said that the relief which I'm addressing here is the relief aimed at suspending the proceedings of the Assembly, pending, in paragraph 1, the outcome of Part B. That's what the preface to paragraph 1 says, pending the finalisation of Part B, an interim interdict. Then in paragraph 2 it is pending the finalisation of B and or the rescission application. So let's just start with that. The rescission application in para 2. That has been finalised. It was finalised on the 6th of May. So you can draw lines through that. The fact that a rescission application has been brought in relation to that doesn't make it not finalised. It's been finalised. What about Part B? In the debate yesterday, my learned friend was taken to the part of Part B which correlates to the interim interdict stopping the parliamentary process. And there's only one part of that. It's paragraph 1.3 of Part B. Declaring in terms of 172(1)(a) of the Constitution the conduct or decision of the committee to commence or proceed with the 194 removal proceedings while the matter is sub judice to be unconstitutional. And my learned friend said that the matter there is the rescission application. That was in answer to a question from His Lordship Mr. Justice De Lama. And that is right. It can only be that matter. Because on their hypothesis, the way they were approaching this case was, yes, the Constitutional Court spoke on the 4th of February in case 2107, but we've sought rescission of a key part of that, which if it's successful, and if the Constitutional Court then reconsiders that matter in our favour, will turn the clock back to before Justice Nkabinde's committee was appointed. So you can't carry on, you have to go back and start again. That's the theory of the case for the applicant. And that's therefore why my learned friend was quite right to say that the matter in 1.3 is the rescission application. But now the problem with that is that the matter is no longer sub judice, because the rescission application has been disposed of. So where does that leave them? This is quite apart from res judicata. I think it was in Huckleberry Finn, it's up the creek without a paddle. There is no longer pendente anything. It can't be pending Part B, which is pending a rescission application, which is gone. So the implication of the dismissal of the rescission application on the 6th of May is profound. It's devastating for this application before you, if you get to it on its merits.
Well, he says the 6th of May order to be read with the notice of motion is revived because of the 10th of May application.
I've already addressed that, my Lord. I've explained.
I'm just explaining
the reason, but
how I understand Mr. Mpofu's argument to be, to say
yes,
nothing has really changed because we filed the new
I know.
application.
And
Now
the next one will,
again.
and the next one may come as well. He said that he's not ruling out anymore, depending on what further developments there are. But the point is this. I've explained why in our law the lodging of a rescission application does not ipso facto suspend the operation and execution of the order. It doesn't. You have to apply for it.
Well, the Constitutional Court in the Zuma versus the
Commission.
Secretary of the Judicial Commission of Inquiry, etc. That's the one, and 891 of our bundles dealt with the distinction under 42 and rescissions referring back to the old case in this division of Vivanathan, and accepted the analysis of Thringe in that case effectively, and dealing with some other issues as well that's relevant to our case,
including the importance of the finality of judgments.
Well, it's the introduction to that case under paragraph 1 reads as follows. It says, like all things in life, like the best of times and the worst of times, litigation must at some point come to an end. And then deals with the fact that the Constitutional Court is the highest court in the land, and finality and so on. So that's the introduction to the judgment. That sets the stage for the later analysis and dealing with rescission applications to the Constitutional Court.
My Lord, it's a second and now specific to how this pendente what in this application, fundamental problem for the applicant insofar as they're seeking an interim interdict against Parliament. Whether they approach it through the provision, the conventional interim interdict pendente lite in paragraph 1, or through this order suspending the operation and execution of the part of the CC judgment which altered the judgment of the Part B full bench here in one respect so as to keep that open, doesn't matter.
Well,
It's over.
the effect of the participation of a judge, that's the subject matter that the applicant is unhappy with and she wants to be rescinded. That will take the process back, the 194 process in the National Assembly,
Yes.
because it will take the basis of the panel away.
Absolutely, that's
And that's
the
the argument.
Yes.
Whilst that is being challenged, we have the right not to be subjected to further processes.
Yes. So
That's how I understand it.
that is the argument, and what they have to persuade you of then is that they have to persuade you of their prospects of success in rescission 2. It has to be a compelling case. I'll get to that now. And then they have to persuade you of their prospects of success in rescission 1. Those are the two peaks that you have to take.
That's if they get over your first point, the
If the-
judicata point,
Yes.
and the multiple
Yes.
interlocutory applications.
Yes.
point.
So what I'm saying is that on this notice of motion as it stands, I'll go further and I'll say this. I'm going to deal with the merits of the outer interdict and also the merits of this paragraph 2 in the alternative to this proposition. I don't want to be misunderstood. Because of our law on what the effect of a rescission application is, bringing of a rescission application is on the order sought to be rescinded, and because of the concession which the other side have made in para 155 of their finding affidavit in line with the law, the giving of the order by the Constitutional Court on the 6th destroys the basis for the relief sought. There is no rescission application. One can draw a line through the rescission application, and there is also no Part B as far as my client is concerned. I'm not leaving aside the interdict against the President, that's another matter. But paragraph 1.3, the matter is sub judice. One can draw a line through that too, because there is no matter which is sub judice anymore. It is over. There's now a new matter, which is rescission 2. But crucially, my Lord,
Decision 2 is
10 May.
It's interesting because it goes further than what was before the Constitutional Court under 2107.
Yes,
It now deals with
conduct of the Chief Justice.
It's at more than one place in the record.
Page 108 of the supplementary bundle.
The relevant portion is on 109 of the supplementary as well as on 2323
Yes,
of the supplementary.
Yes, it touches the
deals
deal.
with a few other matters as well.
yes. But the point that I wish to make is this. They've made only one amendment to their notice of motion. It's an inconsequential amendment. The replacement of, in the word concerning, with commencing in paragraph 1.6 This is in this court. They have not sought to amend their notice of motion to seek relief pending the outcome of rescission 2, where it refers to the rescission application brought under case number such and such. That was the first rescission application. One reads it with the founding affidavit.
So you say that the relief sought under A is pending the relief sought under B, that's on page 3, under paragraph 2 of the notice of motion, and that specifically states the
matter is
the application brought under that case and the order of this court as amended by the Constitutional Court. So that is the 4th of February judgment.
Yes, it's not just the words, the rescission application. One has to read the whole sentence. Brought under case number suspending the operation and execution of para 118 of the order in case number. It's the appeal, successful appeal against the one aspect of the Part B judgment in this court. They've not amended their relief to seek interim relief pendente rescission 2. They could have done that. They haven't. And if they try and do that in reply, we will strenuously oppose that, because they've known about that judgment since the 6th of May. They've filed further affidavits. They've made their bed. They must sleep in it. They're the applicants. We brought to court to face the relief sought in this notice of motion. I'd like to then deal with outer very briefly. This is now the alternative to these two fundamental points. There appears to be no dispute anymore between the parties that insofar as the conventional interim interdict is sought in paragraph 1 of Part A, that outer applies to that. My learned friend, as I indicated earlier, prefers the Gordon reformulation. We submit that that's a distinction without a difference. It's the Constitutional Court elucidating and applying the principle first formulated famously in the outer case. At page 17 in our heads of argument of our note, at paragraphs 42 to 45, we submit there are three key requirements. They can be reduced to the following. First, in the absence of proof of bad faith, corruption or fraud, the applicant must show a compelling case on the merits of the main case. The court must be convinced the main case is likely to succeed. My learned friend emphasized the likely to succeed part, but it did de-emphasize the convinced part. So a compelling case on the merit, convinced the main case is likely to succeed. A formidable onus. Secondly, the applicant must show they have reasonably apprehend they will suffer irreparable, irreversible and imminent harm if the interim interdict isn't granted, and they're ultimately successful in the main case, and linked to that the absence of a suitable alternative remedy. And thirdly, if the applicant overcomes the first and second hurdles, they must show the harm they will suffer if the interim interdict is refused outweighs the harm to the separation of powers and the public interest that will ensue if the state is restrained, the organ of state, from performing its constitutional or legislative functions.
Can I just pause there? You've referred us to the duties of the National Assembly under 194.
Yes.
And it's a constitutional duty.
Yes.
An obligation. And then if one reads that with 237, the constitutional provision of 237,
yes,
subject to the rights of the individual or institution to be dealt with by the National Assembly, they enjoined to perform those obligations, the constitutional obligations, diligently and without delay.
yes.
Now, how does that affect the discretion that you have when you consider alternates
Yes.
being bound by the Constitution to do certain things. Your clients.
Profoundly.
National Assembly.
Profoundly.
If you can just address us on that as well.
Yes. In the in paragraph 38 of the note, we quote the parts of the outer case which explain why there is a different test when it comes to restraining organs of state from performing legislative or constitutional functions than there is in the ordinary run of interim interdict cases. It's because, as the Constitutional Court explained in paragraph 44, beyond the common law, which is where these requirements were initially fashioned, separation of powers is an even more vital tenet of our new constitutional democracy. The Constitution requires courts to ensure that all branches of government act within the law. However, courts in turn must refrain from entering the exclusive terrain of the executive and legislative branches of government unless the intrusion is mandated by the Constitution itself. And the court added in paragraph 6, consequently, where a court weighs up the balance of convenience where that rests, it may not fail to consider the probable impact of the restraining order on the constitutional and statutory powers and duties of the state functionary or organs of state against which the interim order is sought. And we have outlined those duties in paragraph 54 and following. So the court must place in its proper context what's happening here. Section 42(3) of the Constitution provides that the Assembly is elected to represent the people and ensure government by the people under the Constitution. 181(5) says Chapter 9 institutions are accountable to the Assembly. And then we have 194(1), which makes provision for their impeachment, removal from office on specified grounds and in accordance with a specified process. And it follows from that every Chapter 9 office bearer is liable to be subject to proceedings of the kind in question. And as the Concord put it in the 4 February judgment in paragraph 37, impeachment proceedings are the means through which accountability and fidelity to the rule of law can be achieved. So the conduct of those proceedings in and of itself doesn't constitute an infringement of any rights in the Bill of Rights, but what is more, it is something which is part and parcel of the fabric of our Constitution. These institutions are appointed to support and strengthen constitutional democracy, but the incumbents, if they misconduct themselves, or incompetent, or incapable of doing what they were appointed to do, can be removed. And they must be removed. It's part of what the Constitutional Court has referred to as democratic hygiene. That if problems arise with a particular incumbent of one of those 3 kinds, that this process be undertaken by the National Assembly. That's the choice that the makers of our Constitution settled on. It's a matter for the Assembly. The Assembly appoints, and within limits and for specified reasons, subject to supermajorities, the Assembly removes. What the Constitutional Court has also held is that there have to be rules for that process. Rules were adopted, and those rules are being implemented by the Assembly. That has, as I submitted, a profound impact here. In short, what we have in this matter is a rescission application. First, well, let's step it back. We had a challenge to the rules. The challenge has, to all intents and purposes, failed. The process can carry on, subject to one amendment effected by the High Court and confirmed by the Constitutional Court. 2, rescission of that decision was sought in a key respect, which, as His Lordship presiding pointed out, would turn the clock back to before the appointment of the Independent Committee. That has failed. The Court has seen what the reasons of the Constitutional Court are. The Court knows what our submissions are as to the infirmities of the rescission application, re-arguing points that they've lost. wrong accusations, that points were not considered and decided when they were. Those are the essential two grounds of complaint that make up the 6 in the rescission application. Hardly surprising with respect that the application was dismissed. So we ask ourselves, with reference to outer, do we have a compelling case on the merits? Is the court convinced that this main case is likely to succeed? The court can never be so convinced with respect. The Constitutional Court has spoken twice on the matter. And that's a key link in the chain. We're trying to retrofit now. You see, we're way past that. And Protector Mkhwebane is trying to turn the clock back.
Well, as I understand the argument from Mr. Mpofu, he says outer is not applicable. You've got to go back to Setlagelo and then look at Sutherland J, as he then was judgment in Amabungani, and you read it together, and then the test is different. I'm paraphrasing, but that's the argument, and we have to consider that argument seriously, whether it's applicable here.
Well, there's two things to be said about that argument. I cannot think of a clearer case where outer applies. We are dealing here with a power entrusted by the Constitution to the Assembly alone. The President's function in relation to the actual removal is the formal function of effecting the removal if the Assembly decides after this process. The separation of power looms large, it looms huge.
But that is why I referred you to these provisions of the Constitution, because what we asked to do is to restrain the National Assembly from performing these duties and obligations that they empowered to do and enjoined to do in terms of the Constitution.
Yes.
And it's dealt with by the Constitutional Court in outer.
And it is a compelling case is required for that. That has been tried and never succeeded in this court. We've cited the cases. There are 4 or 5 of them now, culminating, of course, in Part A of the present case. So if you're against me on res judicata, and you're against me on issue estoppel, then at least what I have in my favour is we have a finding of that court on this question: does outer apply?
Well, that's why I raised with counsel for the applicant yesterday the question of res judicata and comparing that to the judgment of the full court authored by Saldanha J, because it deals with the outer question from about paragraph 18 of that judgment and further. And he summarizes both arguments that we have before us. Your argument as well as Mr. Mpofu's argument, that was before that court.
And he not only concluded that it does apply, he went on at paragraph 72 and following, at 601 of the bundle, to apply outer in detail and analyze the strengths of and weaknesses of the various challenges. There were many at that stage. And then he went on to consider the alternative remedy, balance of convenience, and particularly in that context, the impact on the separation of powers. So the applicant is in bad shape. The Constitutional Court having spoken when it comes to the very compelling case which she requires. But now we have a new rescission application. So there's a new order and a new rescission application, and all of that turns on the SMS of Mr. Abramji, and I'd like to address you on that.
How do you pronounce your surname?
My surname.
How do you pronounce it?
Breitenbach.
So it's not a Y?
Yes, oh no, I'm an ER, yes.
Okay. No, that's just an like a name.
Yes.
For those of us that know, that's seen there.
Yes.
Or whatever it is.
I don't think that there's anything of great moment turns on that. It may have been a notarial mistake many years ago, but not in my lifetime. So what we have is, in paragraphs 49, 52, 72 and elsewhere in her latest affidavit of the 15th of May, that's where the court must now look for a case in relation to, let's call it rescission 2. That's in the interlocutory record at pages 24, 25 and 30. And this is the case on the papers. The impeachment process in relation to her cannot be allowed to proceed before the finalization of the Chief Justice's investigation into Mr. Abramji's unsolicited SMS to me on Sunday afternoon, the 24th of April 2022. Now, we submit, and I'm at page 21 of the note, there are 4 reasons why that investigation should not or is not a reason to stop the Assembly from proceeding with the impeachment process in relation to her. But before I delve into those reasons, I just want to emphasize again, nowhere in this notice of motion will you find a prayer for an order that the NA not carry on with this process pending the outcome of the Chief Justice's investigation into the SMS. Nor will you find anything in this notice of motion that the Assembly not be allowed to carry on pending the outcome of the application for rescission of the dismissal of the application for rescission. So what I'm saying
that
this is in the double alternative that I'm now making these
the
submissions.
opportunity to amend the notice of motion
Yes.
with all the new evidence, and they chose only to amend 1.6 by substituting consistent with commencing.
Indeed. So there are 4 reasons. These are now as to the merits. I'm now dealing with the prima facie case, the peak, which the court is enjoined to undertake if it gets to this point in the case. The first is,
What you say is, there's no peak. Once the notice is filed, we have to wait until it's heard.
so perhaps I should just read paragraph 155 of his client's founding affidavit.
That's my
Yes. I've referred you to the cases which say that the mere filing of a rescission application does not have that effect. You need to bring an application under Uniform Rule 45A to suspend the operation in effect. But this is what his client says.
At that point, where are we now?
Yes.
Are we also entertaining an application in terms of 45A, or we have to wait until such an application is brought?
So what we have on the face of the notice of motion, an application in terms of 45A, it's paragraph 2, but it's actually pending a different rescission application. The application for the rescission of the order granted on the 4th of February in relation to paragraph 118 sub 2 of the Part B courts. But so we're in Alice in Wonderland world here, because of all the many steps, logical leaps that we have to make to try and work our way back into what's here in the relief. This is how I understand the argument, is they say you have to consider the merits of the latest rescission application, and then the merits of the other rescission application, and then ask yourself whether you're going to suspend the proceedings to cater for the contingency of the Concourt upholding the latest one and the first one, and then changing its mind on the merits of the appeal. That's where we're at, as I understand the case. But I say the notice of motion doesn't get them there, and that's a point that I've already made. But assuming that we are there, and for some reason it's important for this court to consider the case mounted on the basis of the SMS, I'd like to address that briefly. So firstly, why Mr. Abramji sent this SMS to me, and whether he did so based on his own assessment of the situation, as he apparently alleges. I see this from reports of what he's told the journalist, and apparently also in an affidavit, or because he's received some information from inside the Constitutional Court, as Advocate Mkhwebane alleges or believes. Those are matters which have nothing to do with the matters to be considered by the Section 194 Committee. The latter, what the committee has to consider, is confined to whether or not Advocate Mkhwebane has misconducted herself and or is incompetent for the reasons charged in Ms. Mazzoni's motion calling for her removal from the Office of Public Protector. The two don't overlap at all. The second thing is, whatever advantage Mr. Abramji intended to confer on the legal team representing the Speaker and the Chairperson of the 194 Committee by sending that SMS, that was negated when the following day I disclosed it to counsel for Advocate Mkhwebane and the respondents supporting her, and to this court. So whatever was sought to be achieved was not achieved, but as your Lordship presiding correctly pointed out, it did cause significant disruption in that the case had to be postponed by agreement to get certain clarity from the Constitution, or to report the matter and to get clarity about the truth of the content of that, because, as your Lordship presiding pointed out on that occasion, and as I've argued today, if the rescission application had been refused, that would have a profound impact on this case. One need look only at the notice of motion to know that. And Mr. Masuka very fairly conceded that in his remarks then and in his argument yesterday. The third point is that her founding affidavit in support of the second rescission application, one looks at that, it doesn't contain any facts as distinct from speculation, which dislodged this presumption that the CC's order dismissing her first rescission application, like all official acts, is presumed to be duly granted until the contrary is proved. I'm not going to try and read the Latin, I was never very good at that. The other point is that only the Concord can make that determination. And that will be, in other words, in the determination of that case that has now been brought. Fourthly, and related to the third point, the objective facts, unlike the speculation, but the objective facts to which I'm going to refer, point to there being very little prospect of the Chief Justice's investigation revealing that one or more of the justices of the court who participated in the decision to dismiss her first rescission application were responsible for any leak from within the CC to Mr. Abramji, and I'd like to turn to those facts. They are the following. There were two material statements in that SMS. The first one was that by the time it was sent on Sunday the 24th of April, the Constitutional Court had declined to hear Advocate Mkhwebane's rescission application. The second statement was that the decision would be made known sometime in the coming week, but no later than Friday the 29th of April. As the court knows, on the 26th of April, after the matter had been postponed, Advocate Mkhwebane's attorneys, acting with the consent of the other parties to the present matter, addressed a letter to the Registrar of the Concord about the SMS, which culminated in a request for a response to, and I quote, whether the information contained in the request is true or not, unquote. On 29 April, the Registrar of the CC responded that, and I quote, the outcomes of the applications for direct access and rescission will be communicated to the parties, and I emphasize, when the court has finalized its processes and made its decision. And those last four words, the only possible meaning of that communication is that on 29 April, as at that date, the CC had not yet made its decision. And it follows from that that the first statement in the SMS is false. Now, as things turned out, the Constitutional Court didn't announce its decision by Friday, the 29th of April either. It did so a week later on the 6th of May. And it follows from that that the second statement is false too. Advocate Mkhwebane had questions about the 29th letter and about an interview which the Chief Justice had given apparently a day or so earlier, or reportedly a day or so earlier. And so her attorneys, this time acting not for all the parties but simply for her, on the 3rd of May addressed a letter to the Registrar of the CC. In it, after referring to the remarks by the Chief Justice in that interview on the 28th, which she contended showed that the CC's decision regarding her application had already been made, though not announced. That seems to be her position now. She asked the Registrar of the CC's for answer to a series of questions at page 80 of that interlocutory bundle. But the key question, and there are a couple of them that are fairly similar, the key question is question 8.6. And I quote, is the factual position that no decision has been made underlined, or merely that the decision has not been announced underlined? That was The underlining was in the original. Together with the order which the CC handed down dismissing its application, in other words, attached to the self-same SMS, SMS, it's stuck on SMS's email. It was on the 6th of May at 3:10 in the afternoon, Friday the 6th of May. The registrar of the CC responded to this letter of the 3rd of May from Advocate Mkhwebane's attorneys. And as His Lordship presiding pointed out, that response starts with the following: please be advised that the court reiterates its response dated 29 April, and then goes on to say, and that in that regard will not engage with correspondence of this nature with the litigant. But the first portion of that, which I've underlined, read in its context of what was said on 29 April, what the question was initially, true or not, said on 29 April, the question that was raised, by reiterating its response, this can only mean that as the 3rd of May, when that question was asked, the Concourt had not yet made its decision. And then there's the final point, that the 9 justices of the Constitutional Court who participated in that decision of the 6th of May did so after the registrar had sent a letter to the parties on the 29th of April. I've already referred to it. I've referred to paragraph 3 of that letter, informing them in paragraphs 1 and 2, firstly, of the court's gratitude, not the registrar's gratitude, but the court's gratitude for bringing Mr. Abdramji's SMS to the court's attention, and that the issues raised were being investigated. And it is, I respectfully submit, to say the least improbable, that in those circumstances, the justices having been alerted to this problem, that any justice who participated in the decision was responsible for any leak to Mr. Abdramji. And why do I raise all of this? It comes back to the presumption of regularity. That presumption, which applies to all official acts, says they are presumed to be valid unless the contrary is proven. And one needs evidence. And the objective evidence, which I have rehearsed, does not rebut the presumption. It's a rebuttable presumption of fact. It does not rebut it. Speculation, I'm afraid, does not, to revert back to outer, provide the compelling case, one very likely to succeed. So if this court were to enter the merits, which we submit it doesn't have to do, then again, this aspect of the matter would similarly fail. I shan't dwell on alternative remedies and the balance of convenience. They're dealt with in our heads beyond saying the following. Ms. Mkhwebane has got alternative remedies. In the first instance, if the committee proceeds with its work and it ultimately finds her guilty as charged on one or more of these counts, and if the requisite majority of the National Assembly thereupon resolves that she be removed, neither of which is a foregone conclusion, the evidence hasn't been led, not one word of evidence has been led yet, and who knows what the majority of the members will make of the ultimate outcome. Much will depend, I suspect, on what is found, if anything, adverse to her. Obviously, if there's no finding adverse to her, that's the end of the matter under the Constitution, because that's the requirement. There's a lot of water to flow under the bridge in this constitutionally ordained, mandated, in other words, mandated in the sense of required process. So there are two big ifs there. If she's found guilty, and if there's a resolution adverse to her by the requisite majority, then she may seek judicial review of that decision. That is an alternative remedy which she has. Subjecting herself to this process has a paradoxical benefit for her, She has been charged mainly, but not solely, mainly because several judges, quite a number actually, if one counts the plurality of the Constitutional Court in the CIEX matter, the Reserve Bank matter, have been very critical of her conduct of investigations or her reports in those investigations. There are two of them in particular, or her conduct of the litigation, the review litigation about that. This process presents her with a unique opportunity to clear her name. She can clear the air and clear her name in the process. So there's a distinct benefit for her and obviously for the Office of Public Protector. As against that, we have the obvious and serious prejudice to the separation of powers and to the public interest in the timeliest conclusion of this process that will ensue if the interim interdict she seeks is granted. That is profound. We are dealing with a very important process here, based on serious charges rooted mainly in strong judicial criticism of the incumbent. And that must weigh heavily with this court, as it did indeed with the Part A court on the previous occasion, and against the grant of this relief.
Yes.
That brings me to the sub judice rule. Now, I've already submitted that the matter which was sub judice is no longer. The second fundamental problem with this, I've already alluded to in another context. In the case of the SMS, the issues that raised have no bearing on the issues for decision by the 194 committee. Similarly, here, the issues raised in relation to the challenge to Rule 129V, that is a solely legal matter, legal constitutional matter. The points raised by Advocate Mkhwebane are twofold, but they're both law points. The one is that the Assembly does not have the authority to appoint a judge to a panel of the advising the Assembly. It's a V-raise argument. That was raised in her application for leave to cross appeal, and in her cross appeal because that application was granted. The second is that there's a separation of powers problem with having a judge on a National Assembly advisory panel. Both of those are constitutional legal issues. There are no factual questions there. The fact that retired Justice Mkhwebane was appointed to her panel gives it bite in this case, but the attack is one of a general legal nature. The matters to be considered by the 194 committee, by contrast, are essentially a factual inquiry into the various charges, what are the facts, followed by the exercise of judgment as to whether the facts as found by the committee constitute misconduct or justify a finding of incompetence as alleged. Those two, there's literally nothing in common with the two. So in what sense can it be said that the sub judice rule is infringed if the committee carries on with its hearing evidence from witnesses to ascertain the facts, and then considers and decides the question of her guilt or innocence of the various charges levelled against her? The committee does not have to reflect for a moment on the issues of whether the Parliament had the power to make a rule saying a judge could be on on such an advisory panel, and whether if it did, that would infringe the separation of powers. They simply don't arise. So on the facts, the sub judice rule doesn't arise. And then
Insofar as it relates to the processes in the National Assembly, that had passed already.
Yes.
Because the rules already went through the Assembly.
yes. And
And the only portion where it changed was the excision by the Constitutional Court of the proviso.
correct, and that relates to the process going forward. And so the thing is that factually speaking, that's water under the bridge. Justice Mkhwebane chaired that committee. They did their work. They finished and reported in February 21, as memory serves. That's history. It's a jurisdictional fact that such thing had to be done. It was done. And there's been litigation about that. And crucially, that part of the litigation is attacked only on these two legal bases, which are really, they just aren't issues that are going to arise. And the third problem is, of course,
Issues that are going to arise in the work of the committee, you mean?
yes. And the third is that one has the finding of the full court. The three litigants raising this were parties to the previous case. Advocate Mkhwebane, the UDM and the ATM.
I haven't seen the name of the UDM mentioned in that case.
That's right. I don't
the
think
judgment, because I don't have the
papers.
all the participants except the ones that are named in the judgment itself. So I know there were 10 or so respondents,
22.
but only a few are mentioned.
Yes.
The ATM, the Public Protector, the Speaker,
Yes.
the President, and the DA.
Let me just check
They
one.
mentioned in the judgment.
Yes.
And that's where my comment came from this morning to say to you, the President abided. See.
I just want to check one document, if I may. I'm in the wrong file.
Because the copy of the judgment that I
So there's no copy of the Part A judgment in the papers. It's in the bundle.
No, I have that. That's from 587.
But the Part B judgment is in volume 7. And at page 623, the parties are listed.
Yeah.
And
So there we can see it.
all political parties being the 9th to 22nd respondents. That's at page 6, did I say 6? 623 and 624. It's MN, oh, it's a tongue twister for me, NMN1.
You'll find it. Yes, you may proceed.
So we have a finding. This is the Part A judgment. Yes. We have a finding by the Part A court in paragraph 108, to which His Lordship presiding referred my friend Mr. Masuku yesterday, that the sub judice rule does not preclude, and I'm quoting, the members of the National Assembly from carrying out their oversight functions and the holding of office bearers of Chapter 9 institution accountable in terms of Section 194 and the new rules. That's quite a strong finding, and it would encompass a case which is not like we have at the moment, where, let's say, there's judicial review of a report by the Public Protector, and that has also founded a motion for the removal of the Public Protector. There could be a serious allegation, let's say there's already been a serious finding by court adverse to the Public Protector. What that finding says is that courts, you've got your work to do. National Assembly, you've got your work to do. And the fact that there may be an overlap between the issues, Rule 89 doesn't preclude that. That's the finding of the Part A court. That's binding on this court unless clearly wrong. It doesn't bite in this case for the second reason that I gave, namely that there isn't an overlap at all in the issues here. So this is actually an easy case to avoid any controversy around Rule 89. One needs ultimately to consider the rationale for that. We deal with that in paragraph 85 of our heads, and I'm not going to dwell on that. So we submit there's no merit in the sub judice attack. As far as the alternative reliance of Uniform Rule 45 and Section 172 of the Constitution is concerned, Just to start with 1721B. As the court will know from the Part A notice of motion, there's no reference to 1721B there. But as the judgment records in argument, my learned friend in reply, as I recall, invoked section 1721B, Jafta J's judgment in the Gordon case, just and equitable discretion, and the court dealt with that and held that the justice and equity of the case didn't warrant the stopping Parliament from carrying on with the impeachment process for essentially the same reasons that the balance of convenience weighed heavily against and also obviously the prima facie right problems in the main interdict. So we submit that doesn't really add anything. The considerations are ultimately no different. One has to consider clearly the separation of powers, harm that would be caused by any interdict when deciding on the justice and equity. You have to look at the strengths of the case. You have to look at the alternatives open to the litigant seeking the relief to being given the interim relief. As far as Uniform Rule 45A is concerned, we submit firstly that and I'm now focusing, I'm in a world where I'm imagining that we have this first rescission application is somehow on the table. The first thing about that is that when the Constitutional Court reversed the Full Court Part B's order upholding the challenge to the constitutionality of Rule 129V, what it did was replace it with an order dismissing that challenge. So it changed the order of the High Court to one dismissing a challenge. And the thing about that is that an order which dismisses an application without more, let's say no costs, and in fact there were no costs ordered in favour of the Speaker. But an order dismissing an application is not one which has an operation and an execution which is capable of suspension, whether in terms of Uniform Rule 45A or 172(1)B. It doesn't change the status quo in any way. It's where the order changes the status quo. Pay Mr. Bloggs, the plaintiff, 100. That's an order which operates and has an execution which is capable of being suspended pending the outcome of an application under Rule 45A for rescission or this alternative under 172(1)B. Assuming we're wrong in that, and this court were to issue an order, such as is sought here, suspending the Constitutional Court's order in relation to 129V, that in itself would just have to be stated to cause one's hackles to rise, or your hair, the hairs on your arm to go, whoa, what's this? I'm being asked as a High Court to suspend the operation of a Constitutional Court order. But that's what they're asking. But what would the effect of that be? So that would revive the status quo immediately before the Constitutional Court granted that order, the order dismissing the challenge to 129V and replace effectively. And what was that status quo? Well, that is the status quo created by the fact of an appeal against that order of the High Court. And Section 18(1) of the Superior Courts Act says that that appeal had the effect of suspending the High Court's order anyway. That's why Mr. Tsenoli had to consider and gave the advice that he did. He knew that, yes, the Part B Court had declared 129V unconstitutional and 129AD3's proviso. But he also knew that an application for leave to appeal had been lodged with the Constitutional Court. There was also a conditional application here in this court to appeal to the SCA in the event that the Con Court refused that. But we can leave that aside. There were two applications for leave to appeal, one contingent of the failure of the other. But the effect of those was to suspend the operation and execution of the High Court's order declaring those two rules invalid. So if the applicant were to succeed in persuading your lordships to issue an order setting aside the CC's order, the status quo which would be restored would be exactly the one that Mr. Tsinoli was confronted with, and that was that the inquiry could notionally go ahead. He decided to advise the committee against doing that because of the potential implications of an adverse outcome in the CC. But for present purposes, what's important is that turning the clock back doesn't assist Advocate Mkhwebane in the slightest, because all you would then have is an order of the High Court invalidating 2 rules, which itself is suspended pending the decision of the Constitutional Court, which must notionally still be taken. And the last problem, and this relates specifically to Uniform Rule 45, I have already made this point, that with respect cannot operate in favour of a particular litigant, one individual, where one is dealing with an order in rem. The order that she sought is that a rule of general application be declared unconstitutional. And if that position were to revive, which we submitted wouldn't anyway because of Section 18.1. So that's why we submitted this part of the case is a non-starter. It's conceptually a non-starter. The order, basically, the order of the High Court dismissing the application, which is effectively the order that the Constitutional Court transplanted in, is not one capable of an operation and execution which can be suspended under 45A. It's in any case an order in rem which is not capable of so dealing. And if the court were to do that, our third point is the result would simply be to restore the Section 18.1 position immediately prior to the Concourt order. But in any case, the merits are exactly the same merits as the pre-1. The court will have to consider all the same factors, and for all the reasons we've given there, one could not, with respect, grant an order in this case. I'm told that it's 11 o'clock. I've got 2 topics to deal with. May I speed through those? I shan't be more than 15 minutes, and I apologize to my friend, Ms. Pillay, online, because I'm now eating into her time. So the first concerns the claim for an order directing the Speaker to withdraw her 10 March 22 letter to the President. That is in the notice of motion at paragraph 1.3. It's said to be pending Part B, but it does, on the face of it, seem to us to be final relief. So before dealing with the grounds of that, I'd like to just pose the following question.
Well, they both 1.3 and 1.5 that, or 1.3 and 1.5 that Ms. Pillay will deal with. It's mandamus that sought.
Yes. They're final orders that are being sought. It's not actually interim relief, but we make nothing of that. That's the relief which has been sought. It's conceptually wrong to include it in a paragraph like this. It should be free-floating. But I wish to pose the following question to the court for its consideration. And I do so on the basis of what Advocate Mkhwebane says in her replying affidavit at page 973. The volume number is volume 10. It's in paragraph...
Let's go back to 1.3 and 1.5. I know now
Yes.
I'm eating into your time. Returning to the original application in 2107 and the relief sought there, where for an interim interdict was phrased in relation to the Speaker
Yes.
from taking any further steps in the implementation of processes envisaged in Section 194 of the Constitution and conducted in terms of the impugned rules.
Yeah.
So that would include, because the letter that she wrote was to inform the President that the process have started effectively. And that's the letter to be withdrawn. So that would have been covered under 2 in the previous application as well.
Read literally, it would.
And the alternate to Prayer 2, in that case, in 2107, was interdicting those respondents, which included the President and or their members, who have a conflict of interest from voting and or participating in any way in the process carried out in terms of Section 194 of the Constitution and the rules. So the conflict of interest of the President was also raised there by implication.
Yes. And indeed, it was raised expressly as well. At that stage, the factual basis.
No, the affidavit was next year.
The
His answering affidavit was the next, or his explanatory affidavit, because he abided the decision.
Yes. It was the Bosasa case.
Yeah.
That was the factual basis for the contention. So
Yes.
if one gets to the merits of this, the first point I just wish to emphasize, and this is the applicant herself speaking at volume 11, 973, 78.1, and I quote, "The issue as to whether the removal proceedings has started requires objective determination. The subjective opinions of the Speaker and the President are not decisive." That's what she submits in her reply and affidavit. It's an objective question, and the opinions of the President and the Speaker are not decisive. And I submit that, with respect, is correct. Because what's underlying this is a contention that the Speaker was mistaken to report to the President that the committee had restarted its work, if I can put it colloquially. And what's underlying the contention that my learned friend Ms. Pillay will deal with is the President is wrong to have initiated the consideration of her possible suspension because the committee hasn't yet started. The argument, as I understand it, is that will only happen when the evidence of the first witness is led in the, or heard by the committee. But if it's an objective question, the question that I just lay before your lordships is this: what is the utility of directing that these letters be withdrawn? Because what is really being sought here in this notice of motion is 1.4. The President is prohibited from taking any steps in pursuance of the suspension of the applicant. That's the issue that my learned friend Ms. Pillay will be addressing, is whether the President should be prohibited from doing that, either because it's premature, which is the one argument as I understand it, and that's where my client gets drawn into this issue in a limited way because of this letter, or because the President is conflicted, a matter in which I make no submissions whatsoever. But what is if she's right, as she's pleaded, that it's an objective question?
And the utility, insofar as it relates to the President, is different as to your client, because it doesn't really affect your client further if the order is made that the 194 process is paused. Insofar as it relates to the President, it might have an effect on the Audi and the timelines and so forth.
Yes.
That's the argument as I understand it.
Yes, and I'll leave that to Ms. Pillay to deal with. But it just seems to me that it's a brute fulfillment. If it's an objective question, the court will obviously deal with the issue of whether this is all premature or not in its judgment, if it gets to that part of the case. Whatever the Speaker might have informed the President and the President might have done, the bite will be whether the President is now vested with the power to suspend or not. Has, to put it colloquially, has 194.3a kicked in? That's the issue insofar as it relates to my client.
But to say, if we're with you on some of the other grounds, then we don't even get there.
We don't.
It's more relevant to the President's case.
And that really brings me to the cost side of things. So there's an allegation by the advocate Mkhwebane, and it was persisted with my friend yesterday, that there was something untoward about this. Advocate Mkhwebane at para 137 on page 49, volume 1 says, The Speaker's writing to the President was clearly accompanied by bad faith, improper motives and bias. She's hell-bent, that being the Speaker, to press ahead with the impeachment process in para 31.
Mr. Breitenbach, you've made your submissions on the costs in your heads.
Yes.
So you don't need to address us further on that.
Thank you. May I just take a moment to consult my juniors?
On the face of it, insofar as it relates to the parties, we've made a factual decision, we have to apply the principles. That's crystallized.
Yes.
And the Constitutional Court has been clear about punitive orders and cost orders and punitive cost orders against functionaries, where it related to the public protector as well. So we will have to determine the factual basis after we've heard everybody on the facts, and then we just have to apply the law to that.
Yes, we've made our submissions.
It's a discretionary power that the court has, how to apply the cost of the court. So you've made your submissions in
Thank
your
you.
heads. You've countered the argument by Mr. Mpofu in your head, so we don't need to be any further.
Thank you. If he does raise something new in reply when he's apparently going to address this for the first time to your lordships, I will beg your leave to deal with that in a note, but I'll let that.
And whilst you're here, and I know Mr. Masuku is not virtually present, but I saw Menzies and Malani on the virtual platform, that if we're going to grant parties to file supplementary notes, it must be filed by Sunday afternoon. We intend working on the weekend and to try and prepare a draft by next week.
Thank you.
Amongst ourselves. And then we'll have to polish it.
As you know, my lords, my instructions therefore are to ask that this application be dismissed with costs, including the costs of one senior and one junior counsel. Thank you. Those are our submissions.
Thank you. So it's 11:15 now. I saw Advocate Pillay come in. Advocate Mpofu, you have something pressing?
Yes, my lord, yes. In fairness, while Mr. Breitenbach is here, but he has just foreshadowed it, I thought it might be useful for him to note that insofar as he raises the Rule 28 point, which is a technicality, that we will raise that issue. So if he mustn't go too far.
Yeah. No, when he leaves here, he'll go onto the virtual platform in his chambers in any event.
No, I don't mean literally.
Yeah.
I'm just saying he must be mentally prepared to deal with that if he wants to.
Yeah. Okay. All right, so we'll take a quarter of an hour adjournment so that we can change the batting order, and Advocate Pillay and her team can take the front row. I don't know whether both your juniors are going to chambers or whether...
Yes, we are all retiring herdmen.
So you can be excused in the meantime, and then I take it we've arranged a time for Advocate Bandender later in the day.
Yes.
And hopefully we can push through to what's the customary lunch break. Might be out of kilter with the normal times with Advocate Pillay, and then we can get Advocate Bandender in the afternoon and then finish off with a reply later earlier this evening.
Yes. Thank you.
Thank you. The court adjourns. Just ensure that you mute the microphones. The person that's operating in Mrs. Davids' chambers can ensure that the microphones are muted. We don't want to have the same problem as yesterday. Thank you. The court adjourns.
Okay, I thought Yeah. No, I don't think I either. I don't think so. Hey, no,
Thank you.
It's normally a sign of it. Hey, Chris.
so Andrew,
Yes,
with
Tony.
my running.
Oh, no, it's fine. I've got these two strapping gentlemen. Thank you.
So I told you guys, don't go too high.
Confirmation in 2 days' time. Well, thank you so much for all that help. And whenever you have time, bring up
That was impressive. I thought that vaporized.
use the mind map. If you like mind map, use the mind map.
I was going to say more actually. I think your head's going to be in the background. I just want to see the actual papers.
Yeah, just listen to you. I did this case. So when they did what is done, big bet. Yeah. Much too late.
This has been a nice case for other reasons. But
Andrew?
Andrew?
The online.
Apologies from Mr. Lutuli. He's unfortunately not available, so I'm carrying the can alone today.
That's fine.
I've got my instructing attorney, Mr. Owen, with me, Justices.
Okay, but you will fix it. She'll fix it. Right. So, at the moment, can I just check with the other counsel that's online whether they can hear us? Mr. Budlinder?
I can hear you, my lord.
Who else is there? I can see Mr. Bishop, Mr. Similani.
Yes, my lord, I am here.
Good. And Mr. Breitenbach's team. Mr. Breitenbach's team there.
Sorry, I have my microphone off. I apologize. We can hear you clearly.
Good.
Thank you.
And we have now sorted out the issue with Advocate Pillay, so you can take it away. They might not see you immediately because she's still busy setting up the camera on that side again.
Thank you.
But as long as we can all hear you, you can.
Thank you. Thank you, members of the court. I intend addressing 5 issues before this court this morning. The first, Justices, is to deal with the order that's sought in prayer 1.5 of the notice of motion. I'm going to go to it in a little moment, but just to pave the way for what I intend dealing with. And that's the mandate to withdraw the letter that the President wrote, dated the 17th of March. The second is I'm going to deal with certain points of departure in terms of the interdictory relief that's been sought in this application. Thirdly, the interdictory relief sought in relation to the President seeks to found a prima facie right on 2 issues. The first is whether the threshold requirements under Section 194(3)A have been met. In other words, whether the proceedings have started of the Section 194 committee. And the second is the President's alleged conflict of interest. And so my third topic will be to deal with both of those issues and to make submissions as to why we say a prima facie right has not been shown in relation to either of those. Justices, as the fourth issue, I will deal with the remaining requirements for the interdictory relief to succeed. Those would be the requirements of irreparable harm, the balance of convenience, and the alternative remedy. And finally, I'll make some brief submissions on the question of costs in relation to the President. Justices, if I could then perhaps just locate the President's case in this morass of paper before you. There are 3 affidavits that have been filed, 2 by the President himself and 1 by his attorney. The answering affidavit of the President, the court will know, is at volume 4, page 309. You needn't go there. The second is the affidavit which we sought the admission of, and Justices, it appears in volume 11, and it was deposed to on the 22nd of April 2022. And it appears, Justices, at page 1053. And the third is the affidavit that Mr. Owen deposed to on behalf of the President. It appears in the interlocutory bundle, and it's at page 406. It was deposed to on the 17th of May, 2022. In the course of my argument, I will rely on all of those affidavits on the basis that they have been admitted, Justices. By way of preliminary matters, the second issue is the question of the strikeout in relation to certain parts of the President's answering affidavit. I noted that my learned friend, Mr. Mpofu, didn't deal with it in oral argument. I'm not going to belabor the point, save to refer the court to page 6 of our written heads of argument, and to make only 2 submissions as to why we submit that the strikeout ought not to succeed, Justices. And that is, the first submission is that according to the Public Protector, certain annexures in the President's affidavit are irrelevant, scandalous, or vexatious, she says. The court will note that each of those annexures that have been attached to the President's affidavit relate either to letters that he addressed to the Public Protector or to letters that the Public Protector addressed to him in the course of an investigation. Contrary to what our learned friends say, that it matters not what the merits of any investigation are, we submit quite the contrary. It matters greatly. And for that reason, we submit all of those letters which were attached in order to explain the status and the stage of the various investigations are highly relevant to a determination of this matter.
And those are the four issues that you've identified and extracted from
That is so.
the Public Protector's affidavit.
That is so, Justice Erasmus. And there's another difficulty, we say, and I promise to limit myself only to 2 points on the strikeout, but there's another difficulty with the strikeout that the Public Protector seeks against the President, or in relation to the President's affidavit. And that is, in her replying affidavit, she identifies various paragraphs where she says an application to strikeout will be sought in relation to it. And she doesn't actually answer to many of those paragraphs. But when one looks at the actual application to strikeout that's attached to her replying affidavit, it only seeks to strike out annexures 4C through to annexure 5I. And the court will be aware that we've approached the matter on the basis that the only strikeout before this court is therefore the strikeout as it appears in the annexure to the Public Protector's replying affidavit. Justices, it's PPR 2 at volume 11, page 1027. And so for all of those reasons we say, together with everything that's foreshadowed in our heads of argument, we say that the strikeout ought to be dismissed and all of the information, annexures and amendments made in the President's affidavit ought to be admitted. Justices, the third preliminary issue we've raised by way of, in our heads of argument at page 8, paragraph 12, certain parts that of the Public Protector's affidavit that the President sought to strike. Time has passed and the President's answered to that, so we don't persist with that strikeout. Members of the Court, if I could then start, perhaps just by way of locating my address, by asking the Court to go to volume 1, page 2. It's the notice of motion, and for ease of reference, I'm not going to go to the amended one. I will refer to the original.
What I did on the court file, the original, at 1.6, I just written in the word commencing and deleted the word concern.
I did likewise, Justice Erasmus. Thank you.
So I'm also on page 2.
Thank you. So, Justices, if I could perhaps then try and locate this and draw your attention first to the order that's sought in paragraph 1.5. Now, our learned friends...
Just ask the interpretation.
Not at all.
I seem to have understood, unless I misunderstood it, in relation to the exchange between myself and Mr. Mkhwebane yesterday, that at the end of the day he said it in reading that whether or not 135 the reading of
Yes.
what does you understand?
Yes. So I understood it as such, Justice Miller. I just don't want to leave the point unanswered if it gets resurrected in reply. And
He indicates he will.
he will. I anticipated as much. So it's with that in mind that I do intend addressing the court on it. I believe it's an important aspect of the relief and it does warrant proper engagement on it, Justice Villa. Thank you. So paragraph 1.5 of the notice of motion I identify separately because contrary to the submissions made in our learned friends' heads of argument, where they suggest that it really is an interdict on a proper construction, the only difference is it's a mandatory interdict as opposed to a prohibitory interdict. I submit to your lordship it doesn't fall into the category of interdictory relief at all, and I'm going to come back and deal with that on a separate footing, but perhaps for the moment let me just identify 1.5 as relief that falls outside of the purview of the interdictory relief. Justices, you will then see at 1.4 and 1.6, what's being sought are relatively wide-ranging orders as against the President only in paragraph 1.4 and as against Parliament, I'll call for ease of reference, and the President in 1.6. And so if I could then, Justices, deal with the first of the 5 subjects I had intended dealing with, and that's the order in paragraph 1.5. We submit that there really are 6 reasons as to why that relief is not competent and ought to be refused. The first is, if the court is to have regard to its formulation, it seeks an order that mandates the President to withdraw his letter dated 17 March 2022. So on the face of it, it really is unprecedented relief. It's asking that this court give a mandate to the head of state to withdraw a letter, the lawfulness of which has not been determined by any court as yet. And so what immediately emerges from that, Justices, is the fact that it cannot be granted by way of interdictory relief. And it can't be granted by way of interdictory relief because the import of what is being sought is an order regulating past conduct. And we know full well that an interdict cannot regulate past conduct, except, of course, when there's continuing harm. Members of the court, if I could give you the reference to the SCA judgment in SPCA versus Openshaw, it appears in the Joint Authorities bundle at page 2209. And at paragraph 20 of that judgment, the SCA said, an interdict is not a remedy for past invasions of rights, but is concerned with present or future infringements. It is appropriate only when future injury is feared. Where a wrongful act giving rise to the injury has already occurred, it must be of a continuing nature, or there must be a reasonable apprehension that it will be repeated. And I submit that the letter of the 17th of March, which did no more than to give the public protector an opportunity to make representations on the question of suspension, creates no harm, past, future, or ongoing, and that ought to be dispositive of it. Justices, the same principle is mentioned by the Constitutional Court in the outer judgment, and if I could just give the court the reference, it appears at paragraph 50 of the outer judgment, which appears in the authorities bundle at page 264. The second reason as to why that relief is either incompetent or it must fail, members of the court, is that at the time at which the President issued the letter of the 17th of March, there was no impediment to him doing so. And there's no impediment to him doing so because there was no, and I will submit in the course of my address to the court, developments had occurred through the Section 194 committee. There was no
May I take this opportunity to convey our heartfelt gratitude and welcome all members of the media who have joined us this morning, those who are physically here with us, and those who are connecting via our social
this order that's been sought in paragraph 1.5. And that, we submit, is really dispositive of this leg of the relief. And let me tell the court why that is so. Because the orders sought in 1.4 and 1.6 are interdictory orders. And if our learned friends come home on those interdictory orders, it matters not what the status of the letter was. Conversely, if the interdictory relief is refused, there's value in the letter that was sent giving Audi to the public protector. And so we submit that it has no effect, there's no basis for it in light of the real issue being around the interdictory relief that's being sought.
Except that to keep that issue alive for the applicant is to argue at the later stage when the process is ongoing that the process is tainted. Mr. Pofu puts it as the fruit of the poisonous tree.
Yes.
And yes. I suspect that's the ultimate purpose.
Yes. Justice
the question is just that how does that fall within the context of how it was pleaded?
Yes, yes. And I'm going to come to the question of how it was pleaded, but of course it has this bearing, Justice Erasmus, if at the end of the day the argument is that the unlawful conduct all emanated from, whether it's the meeting of the 22nd of February, whether it's the letter from the Speaker to the President dated the 10th of March, or whether it's the letter from the President to the Public Protector dated 17 March.
Well, Mr. Pofu also wants us to take into account the letter of the 16th from the 5th respondent.
Yes.
Because he says, if you look at the timing, the DA writes to the President on the 16th, and suddenly on the 17th he writes the letter to the Public Protector. But we know the cover letter that was sent to the DA says your letter only received on the 17th.
Exactly.
So there might be an innocent explanation for the timing, but
yes.
Remember, Mr. Mpofu also argues that there's a lot of sinister activity going on, and all of these factors to be taken into account, and inferential reasoning then says, well, if there is smoke, there must be a fire.
Yes, yes.
That's how I understand the
gist
of
that
the
way.
argument.
I understand it in that way too, Justice Erasmus. Can I make two submissions in response to that? One at the level of fact and one at the level of law. At the level of fact, we simply don't know. We've got the cover letter that goes with it, and had that been directly pleaded as that being the impetus for the President's letter of the 17th of March, it would have been answered. And the court would have had before it a full factual account from the President as to what happened in that chronology. The second issue is the question of law, Justices. And the question of law is this. This is not a review application. This is an interdict. And one could well conceive of a matter where someone says, well, when there was a decision taken on X date, there wasn't an open mind that was brought to bear on that decision. And I can tell you there wasn't an open mind because the decision maker was tainted in regard to A, B, and C. That, of course, though, is a very different case from what we have here. We don't have a review, we have an interdict. We have an interdict where the prima facie right sought to be established against the President is one that's founded on two issues, conflict and threshold requirements of Section 1943A. So, Justices, for those reasons I submit it doesn't really have any bearing on the relief sought in this application. The fourth issue is what's being sought is a mandate to withdraw the letter. but there's no challenge to any underlying decisions of the President in any of this. So if one were to put it at its simplest, it's the President that took a decision to issue the letter. He did so based on the factual circumstances as they were, and as I'll take the court to in a moment. And therefore, there isn't a decision that's susceptible or that's the subject of a legality challenge or a PAJA challenge or any of that. You've simply got it hanging in the air where a head of state issues a letter on the basis of certain factual circumstances. The underlying bases and factual circumstances are not reviewable, are not reviewed, yet the letter is being sought to be set aside. And we say that that's not appropriate or competent relief, and it ought not to be granted by this court. Justices, the next issue is the entire relief that's premised, the Part A relief, is meant to be interim relief. And the preamble to paragraph 1 of the notice of motion Yes, thank you.
Please, I had an exchange with Mr. Mkhwebane yesterday about this issue about whether or not this letter was in any way punitive.
Yes.
And he referred me to some authority about the punitive effect of, possible punitive effect of this letter. But if you go to, for a moment, to page 10 of the papers, the main papers, the founding affidavit.
Yes.
Paragraph 1.
Yes.
And the second, sort of the second paragraph, but it's in the first paragraph, the second is sort of the main sentence.
Yes.
The incumbent says, I am the applicant in this application.
Yes.
In my aforementioned capacity as the public protector.
Yes.
So, the capacity in which this application is launched, I think, on that, is it's launched, the incumbent is launching the application in her capacity as the public protector. So I can't see how, under these circumstances, there is any punitive effect connected to the letter written by the President,
Yes.
which forms the subject of paragraph 1.5.
Yes. Yes. Justice Villa, I agree with that proposition. I do so for two reasons. The first is, as you correctly point out, it is the capacity in which she launched this application. But the second is that the authorities that the court was referred to dealt with the effects of a suspension. And of course, what this letter, can I ask the court to go to the letter? It appears at volume 2, page 166, BMS 6. And if the court looks at the wording of the letter, you will try long and hard to find any punitive element to it. On the contrary, had a letter like this not been sent, and had the President taken any decision, the President would have been challenged for having acted unlawfully. So it's a letter that's written aimed at facilitating rights as opposed to a punitive letter. But the other point, Justice Villa, is this. In paragraph 3 of that letter, the President says, it would therefore now be appropriate to consider whether or not you ought to be suspended pending the finalization of the committee's work. He goes on at paragraph 4. I hereby ask you to provide me with reasons why I should not exercise my powers in terms of 194.3a of the Constitution in writing within 10 working days of this letter. I'm going to come back to the time frame in a moment.
Just a moment. Just for people on the virtual platform, you will note there's some movement on the camera that focuses the bar. Don't be concerned about it. It's our internal IT people trying to get a better picture. And I saw them reconnecting another router to that computer.
Thank you, Justice Erasmus. So just...
Sorry, you're saying the letter must be looked at from the viewpoint of something that is rather facilitating a right or facilitating an opportunity to the incumbent rather than a punitive
That is so.
demand.
Absolutely so. And that's exactly why our learned friends must accept that, and that's exactly why they have sought not to review this letter or challenge it in some kind of, because it doesn't meet the threshold requirements. It doesn't adversely affect her rights in any way. The threshold requirements on the page I'm talking about. And so for that reason, Justice Villa, differently put, and I want to perhaps emphasize this, had the letter not been sent, the President's conduct would have been susceptible to challenge.
I didn't follow the last point.
Had the letter not been sent, and if the President had simply proceeded to take a decision under 194.3a without giving Audi to the Public Protector, without giving her an opportunity to be heard, we would have been sitting in this court on a very different challenge.
Well, that would then be a review of the President's decision to suspend in the event that he suspends.
That is so. That is so.
Now, does that not also apply to the conflict issue?
In what
That
sense?
it will be a ground of review in the event that he makes a decision.
That is absolutely right, and I'm going to come to that. Of course, what that means is it doesn't foreclose the door on interdictory relief. But what it does, because a litigant has an opportunity to review at a later stage, doesn't deprive them of the right to an interdict. But there's an exceedingly high threshold for that interdict. And my learned friend, Mr. Bredenbach, took the court to that, and I'm going to highlight a couple of points on that. And my submission, in short, on that point, Justice Erasmus, will be to say that on the conflict issue, it doesn't rise to a prima facie right on the outer test for the purposes of the interdictory relief, that sort. On the conflict test, we say also it underscores the President's point that if a decision is taken, and if that decision is to the detriment of the Public Protector, her recourse is to review it. So she has an alternative remedy in place. And those, we submit, Justice Erasmus, are highly relevant to whether or not the Public Protector has demonstrated compliance with threshold requirements for interdictory relief.
So you're going to take the normal test plus the outer principles.
That is so, Justices. Thank you. Justices, I was making this point, and that is, even though the notice of motion in paragraph 1 at page 1 seeks an order pending the finalization of Part B, and so on the face of it, it appears to be an interim order that's being sought. The effect of an authorization of a withdrawal is a final order. How does one resurrect that order at a later stage? And what makes it all the more confusing is when one looks at it against the relief that's being sought in the notice of motion, page 3, paragraph 1.1. And that's the Part B relief. The Part B relief in 1.1 is to declare in terms of 172.1a that the conduct and or decision of the Speaker, and in 2, conduct and or decision of the President in relation to those initiating and pursuing the suspension, and then paragraph 2, setting it aside. So one asks quite rhetorically, what is there to set aside in relation to that letter if the order in the terms as sought in Part A is granted at this stage? So in effect it has final relief, but the interesting thing about that, Justices, is that there is no case made out for a final order on this. The court would have looked long and hard at the founding papers in this matter, and it's premised on the relevance of Rule 45A and interdictory relief in terms of ordinary common law requirements. So for that reason too, we say that it ought to fail. And then, Justice Villa, I think this has been foreshadowed in my engagement with you, but just the sixth reason is that the public protector suffers no prejudice from the letter. And what's notable about this is the court will know the chronology in this matter well, but if I could briefly highlight it, it's the letter that goes off from the President on the 17th of March, telling the public protector you have 10 days in which to make representations. There's then an extension that the President grants, and that extension is to the 3rd of May, and then there's a little bit of toing and froing between Mr. Mpofu and I, and eventually we settle on the 4th of May, based on the President's instructions to it. Then the court will know from the bundle of interlocutory documents, there's then a little bit of a quibble about whether that ought to be extended to the 25th of May or the 26th of May. And we finally settle on the 26th of May. So the point is, even the time frame in that letter has been overtaken. So the principle of Audi remains, and it ought to stand, but the time frame has been overtaken by at least 4 further engagements on it. So for all of those reasons, Justices, we say that the relief sought in paragraph 1.5 of the notice of motion doesn't get off the starting blocks. And I haven't heard, I listened carefully to Mr. Mpofu's arguments. I didn't hear anything that swayed any of the submissions that have been made by the President in relation to the 1.5 relief on it. Now, our learned friends say in their heads of argument, well, we've misunderstood it, because in effect what it is a mandamus. It's a mandatory interdict, so the argument goes. And the court will be well aware, a mandatory interdict, it doesn't fit the features for a mandatory interdict. It's a letter that has happened already.
If that is so, and with the time that has now elapsed and the developments that have taken place, one of the supplementary affidavits has pointed out that the public protector already submitted submissions on the conflict of interest issues to the President. So there's been compliance with the letter to an extent. What is the effect of us now telling him to withdraw the letter? What's the status of the responses there?
Yes. It underscores the difficulty that the public protector faces in it. And it's a letter, Justice Erasmus, of the 23rd of March. And what she says is that I'll do it in 2 installments. And then she reiterates that on the day before the hearing of this matter, I think it is. And I'm going to give you installment 1 now, which is the conflict of interest point. And I want to expressly reserve rights to deal with the merits of the issues after that. And so, of course, the effect of setting aside this letter is to close the door on whatever has been said already on it. Justice Erasmus, I do accept, though, that there may well be a slight difficulty with that argument, in the sense that the President, through the State Attorney, responded to that letter, and Mr. Mpofu took the court to that. But that notwithstanding, I'd submit that there are 6 other reasons that I've given as to why the relief ought not to be granted on that. Justices, if I could then move to the second of the topics I intended covering, and that is the departure points or first principles around the interdictory relief. The first point I'd want to make is, sorry if the court will bear with me for a moment, is the fact that this is an interdict that is directed against the President, and what it seeks to do is to stop in its tracks the exercise of a constitutional power given to the President. And the court will be well apprised of the legal principles that go with interdicting. Never mind a statutory power, but a constitutional power given to an organ of state. And justices,
That's the constitutional power in 1943A.
in 1943A, exactly so, Justice Erasmus. And so if one has regard as a first principle of interdictory relief in circumstances such as these,
That power must be exercised when all the jurisdictional facts are in place.
that is so. That is so. Justice Delamo, I don't quibble with that at all. My submissions to this court are really not that the President is immunized from any kind of judicial scrutiny on this, but that the threshold is a very high one. And it's one that the Public Protector has manifestly failed to meet on the evidence in the matter. So, Justices, if I could go then to those principles in outer, it appears in the bundle, the court needn't go there, but it appears in the bundle of authorities at page 264. And the first point, my learned friend Mr. Bredenbach took the court through it, so I won't belabor it, but the first point is that the Constitutional Court said at paragraph 44 of outer, that any restraint against the exercise of a statutory power will be given only in exceptional cases, that's the wording, exceptional cases where a strong case for that relief has been made out. And so the court will ask, is the Public Protector's case exceptional, and has a strong case been made out for it? The Constitutional Court said the doctrine of separation of powers is even more vital as a tenet of our constitutional democracy in looking at interdicts of this nature. Paragraph 47, Justices, the court said it will only be granted in the clearest of cases and after careful consideration of separation of powers harm. And then it said at paragraph 65, when a court evaluates where the balance of convenience rests, a court must recognize that it's invited to restrain the exercise of terrain of the executive and legislative branches of government. It must assess carefully, says the Constitutional Court, how and to what extent its interdict will disrupt the executive or legislative functions that have been conferred by law. It went on to reiterate a proper and strong case must be made, and it must be granted only in the clearest of cases.
So if the right to get an interdict is at a low threshold, do you agree with me that you may come home then if the balance is high in your favour?
Yeah,
And vice versa, because there must be an interplay between the various elements that you need to prove for interdict.
there is undoubtedly so, Justice Villa, but the point is, of course, the stronger the right, the less relevant the other requirements.
So
exactly.
if the right is low, the higher the balance.
The higher the balance, that is so, that is so. But where that gives rise to a very interesting issue in this matter is the following. The harm, and I'll come to it in due course, that's alleged, is premised on a so-called illegal suspension by the President. If I succeed in demonstrating to the court that there's no basis for that, and therefore there is no prima facie right that has been vindicated, then of course, on the pleaded case in this matter, the irreparable harm issue actually fails simultaneously. The second difficulty, Justices, with the interdictory relief is that even if our learned friends are correct in the challenges they make, it actually doesn't entitle them to the orders in the terms that they have sought it. And let me perhaps make the point in this way. If this court is to find, Justice Delama, that there is merit to the prematurity argument, in other words, and I don't make the concession at all, but in other words, that even as at this stage, the proceedings of the Section 194 Committee have not started, then the consequence of that finding is simply to say, well, any decision will be premature until such time that those proceedings have started.
Let's go to the Constitution. The question was raised by my colleague yesterday, whether there's a need for the delegation. The way I read the Constitution reads, the President, and only A is applicable for our purposes now, 3A, may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. And then, of course, the and for removal under B. Is there anything wrong with taking preparatory steps before the start of the proceedings?
That's an
Like saying the National Assembly, as in this case, has already adopted the report of the panel. That's the basis of the inquiry to follow, a la paragraph 110 from the judgment of the Constitutional Court. Read with paragraph 19, of course, of that judgment. So I'm issuing a letter now. It's going to start in future.
Yeah.
But the charges are already confined, or the complaints are confined in the panels.
Yes. Yes.
Would that be open to attack on the basis that it's brought before us?
Yes.
Because that's the factual matrix we're working in.
Yes. Yes.
And he might have difficulty in arguing that the process has started, having regard to
Yes.
the dictum of the Constitution.
Yes. Yes.
But I'm thinking about what is the mischief that one must prevent in writing a letter prematurely.
Yes.
On
Yes.
on that basis.
Yes.
Because the obligation you have is to act only after, and the power only vests with you after the start.
Yes.
But that's the power to suspend.
Yes.
I'm asking the question, I'm thinking.
So there are a couple of answers to it, and I'm going to foreshadow them all in some detail in the course of my argument, Justice Erasmus, but let me answer it in the following way at this stage on a high level. Paragraph 110 of the Concord judgment dealt with the state of matters as they were addressed in an application for leave to appeal to the Constitutional Court in August of 2021. So it was clear that as at August, despite the letter, that as at August, the Concord had before it what the factual state of affairs was.
And there was no inquiry, no committee on that case.
No.
That's
So,
2107.
oh,
Yeah.
okay, yeah, I don't know the page number, I'm
No,
afraid
no,
I have to...
It's the case number. It was
The,
the-
oh, sorry, the case number. Thank you, Justice Erasmus. Yes, no, but the point I want to make is that that was the state of affairs when the Constitutional Court was informed in the application to it that there had been a decision to hold in abeyance, to suspend the process. That was in August of last year.
That's the Chinoli affidavit.
That is so. Now, Justice Erasmus, what we know is that since then, a number of things have happened, and I'm going to go through it in more detail, but if I could just foreshadow, we have the Section 194 committee meeting on the 22nd of February. We have a set of terms of reference that's adopted. We have a draft program and a revised draft program that's been adopted. We have an Audi letter that goes through on the 22nd of April, which gives the public protector until the 23rd of May by which to answer. We have evidence leaders who are appointed on the 29th of March. And I'm going to take...
And then there was a meeting scheduled for the 4th or the 5th of May.
Yes, which happened.
And it was postponed, according to Mr. Janchi's later affidavit, to the 11th.
To the 11th.
Where the committee then decided that they're going to proceed.
That
now,
is...
Let me take you back one or two steps in relation to the start of the proceedings. How do we determine the start of the proceedings as defined in the Constitution?
Yes.
Because you will have all these steps that are taken that might just be in preparation for the start. Now, normally in civil law, once your summons is served on you, some people might argue it's the issuing of the summons, but at least when the summons is served on a person, and you are then called upon within a certain days to file a plea or to not do anything, for that matter, then the process has started for normal civil litigation.
Mm-hmm.
Criminal litigation is different, but you have, for example, provisions in the Criminal Procedure Act that can withdraw a matter up to the stage of the plea. Once the person is asked to plead, then the trial must run or is entitled to a verdict. So I'm trying to find a way, without going to the dictionary, of where does it start?
Yes.
You get all these preparatory steps. To my mind, it can't start before a charge is formulated. And the person to be the subject of the inquiry at least be informed of the charge that he or she has an answer. And then you get given a certain amount of days. The 30-day Audi is applicable in this case. So Mr. Mpofu argues, no. The inquiry starts because he calls it the inquiry a la paragraph 19 and 110. The Constitution speaks about proceedings. It uses the term proceedings. Will it only start in July? I think it was the 11th. Speaking from memory, or as it started on the 22nd of March, or will it only kick in once the 30-day Audi has run out with a 5-day extension? That's in the papers. Can you just...
So I'm going to come to that in some detail, Justice Erasmus. It's a very important point. I don't want to give short shrift to it or not answer it, but I intend dealing with it in a whole section in my address, if you'll allow me to come back to that in a moment. Thank you. But the point I was making in relation to the interdictory relief is this: even if our learned friends are correct on the question of a conflict or the question of a prematurity argument, this court has to look at it against the orders as sought in 1.4 and 1.6. And so one asks, if the President is conflicted, does it follow from that he ought to be prohibited from taking any steps in pursuance of a suspension? Is he not permitted to delegate the power in relation to the suspension? And I use that as an example to underscore the breadth of what's being sought and the fact that it doesn't correlate to the actual challenge as brought. Likewise, Justices, if one looks at...
You're saying as it's currently phrased, it will also prevent him from delegating
That is so.
to his deputy or another member of cabinet, which power he has in terms of the Constitution.
That is so.
So he has the authority to suspend. He also has the authority to delegate. So by giving it in this broad terms, I just want to understand your argument. It denudes him of that constitutional power.
That is so.
And then it's clearly a
Overbroad.
separation of powers issue that we will be overreaching.
That is so. That is so. And one look...
I have the point. I just want
Thank
to
you.
understand.
Thank you. And if one looks at it also in so it cuts differently depending on what grounds this court may be inclined to find favour in the public protector's argument. If this court is to find that the President acted prematurely, and only that finding, then the consequence of that is simply for this court to declare at what stage in its view the proceedings under 1943A have started.
Has it been properly ventilated
And
for us?
I'm sorry?
That's the question.
That is the
Has
question.
that point been properly ventilated?
Yes. But I would submit, Justice Erasmus.
Definitively.
Yes, I would submit, Justice Erasmus, that the point is actually a far narrower one, and that's because of the basis on which our learned friends have brought it. I'm going to take the court in the fullness of my address to paragraph 53, I think it is, or 91, I can't remember, of the founding affidavit. And I'm going to refer the court to what's been raised there. But at the moment, the point I simply want to make is that the relief as sought doesn't follow from the grounds of challenge as initiated. And then, Justices, the last point on the interdictory relief is this. There's a rescission application or a second rescission application before the Constitutional Court. There have been certain steps that have been taken in the intervening period. The President has said on affidavit that he is not, no orders were made against him. He is not involved in any of the rescission applications, and they therefore have no bearing in relation to the President's conduct.
That's what I pointed out this morning, that the President abided, although he was the respondent, he abided in
Yes.
the decision of the court.
Yes.
It dealt with the rules.
That is so. Well, Justice Erasmus, that's an important point, because paragraph 3 of the Part A relief sought in that matter was the one, as you pointed out this morning, it was the order in relation to the conflict of interest point. And the court will know from the affidavits that were filed in that matter, which are attached and referred to copiously in this matter, the position, the public protector's position was, because we have the Bosasa pending litigation at that point, and because we have certain findings that the public protector made against the President in respect of the Bosasa report, the President was conflicted. And it was in response to that, and solely, Justice Erasmus, in that context, that the President filed 2 affidavits, and he set out his position that he didn't concede a conflict, but he won't decide the matter while the litigation remained pending before him. Nothing more, that was it. And I'm going to take the court through to that, but the relevance of that for the purposes of how the relief sought against the President has been structured is, if I succeed in showing this court that there's no conflict of interest and that the proceedings have started, it matters not whatever the status of the second rescission application is for the purposes of the relief sought against the President. Justices, if I could then turn to the third topic of my argument, and that's the question of the prima facie right, and I intend referring to it starting with the question of when the proceedings have started. Let me ask the court to go to the case. Justice Erasmus, I said to you earlier on, the task of this court is made a lot easier because of how the case has been pleaded. Let me ask the court to go to page 36, volume 1.
That's that paragraph 91 you referred to.
Paragraph
earlier.
91, that is so.
I'm there.
And there are a couple of things that the public protector says in this paragraph. She says they certainly had not started as at 10 May 2022.
10 March.
10 March 2022. But of course, there's no significance to that, Justices, even if she's right on it, which I don't accept for reasons I'll address. But the section 194.3a speaks to a decision to suspend. It gives the President the power to suspend. Whether he writes a letter, and this is your point, Justice Erasmus, and if that letter is found to have been premature or any of that, it doesn't result in any consequence as at that point. And then, Justices, you'll see what this is based on, the start of the proceedings. She says the contention is based on the simple notion that the following prerequisites had and or have not all been met. And she gives us 6 prerequisites. She wrongly criticizes the President for not having denied this in answer. He did deny it. But let me perhaps take the court through those 6 factors that she identifies. The first is she says there has been no proper promulgation of the amended rules. There's no basis that's been laid anywhere in the founding affidavit. And if the rules have not been properly promulgated, then the consequence is a review order. It doesn't follow from that the President can't take any decision. The rules are the rules and they stand. And so there's no case made out at all for the first ground which the public protector relies on.
Is the requirement for it to be promulgated or to be accepted by the National Assembly?
Well, it's unclear. Certainly my reading of it is that it must be adopted.
If you look at the rules that was the subject of the litigation,
Yes.
they followed the process of going through the National Assembly.
Yes.
And all that happened was the decision of the Constitutional Court excised
Exactly.
the proviso in the rules in relation to the work of
Legal,
the committee.
yes.
I'm using the work of the committee loosely here, and the right to legal representation in that regard. That's what the case eventually, the final Constitutional Court order. And the order of the Constitutional Court, and I have it somewhere here, reads as follows. It's interesting the way it's framed
Yes.
for the purposes of our
Yes, it is. It appears at 1989.
It's at 1871 of the authorities bundle. I'm just going to read paragraph 3 of the order. Reads paragraph 118AI of the order of the High Court is amended to read Roman 1, the phrase, the inverted commas, provided that the legal practitioner or other expert may not participate in the committee, close quotation, is irrational conduct and inconsistent with the Constitution and is declared invalid.
Yes.
Then the important part follows. The proviso is severed from Rule 129 AB sub 3.
Yes.
The amended rule now provides that the Section 194 Committee, open bracket, now the Constitutional Court formulates the amended rule. That's how I read the order of the Constitutional Court. It must afford the holder of public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert of his or her choice. So where the original order didn't provide for legal representation, now they have rephrased
Yes.
it and says the amended rule now provides.
Yes, yes. And Justice Erasmus, as you correctly point out, this is distinct from those cases where the Constitutional Court directs Parliament to go and amend a rule or go and revise a legislative provision or whatever it is. It doesn't do it. And it's interesting because although our learned friends make that point at 91.1 of the founding affidavit, they don't pursue it anywhere in the papers or in argument as far as I can see. So the point is, there's no requirement around the proper promulgation of amended rules, and it follows from that that cannot be the threshold against which proceedings have started. Let me then move, Justices, to the second issue, and that is the second so-called prerequisite that the public protector relies on, is the procedures and parameters for the participation of her legal representatives. Now, there are two documents that have been adopted that bear on that. If the court would. The first is the terms of reference. Can I ask the
For the
court?
194 committee.
Yes, that's right. It's volume 8, Justice Erasmus. And it's at page 739. And the court will see there the draft terms of reference appear there. They explain the background to this whole long and very sorry tale. At clause 2, they set out the legal framework in some detail. At the bottom of that page, they set out the process around the adoption of the new rules. And then importantly, Justices, at paragraph 3, they set out what the objectives of the inquiry are, what the format of the inquiry will be, the question of how witnesses will be called, who can ask questions, how they'll be sworn in, the right to cross-examination and the processing of evidence. And then at 4.5, they set out the issue of legal representation in Audi and what the legal practitioner, what rights the legal practitioner has in all of this. Justices, at paragraph 5, they set out the nature of the inquiry as being inquisitorial in nature, that the evidence leader doesn't act as a prosecutor. And then they deal with, at clause 6, issues of public participation and transparency, how the meetings will be conducted, and then the nuts and bolts in terms of venue, timeframes, etc.
This takes us to another point that Advocate Mkhwebane raised. Remember, he specifically honed in on the constitution of that committee for the meeting of the 22nd of February. I will note that these last page of the document was adopted by at that meeting.
Yes.
Of the 22nd.
Yes.
So just in case you want to say something about it.
Yes.
In answer to the attack on the meeting of the 22nd,
Yes.
Advocate Breitenbach dealt with it on behalf of the National
Yes.
Assembly, but insofar as it affects
Yes.
your argument and answering this, maybe
Yes.
you give us comment.
Yes, okay. I don't want to overstep at all, Justice Erasmus, but perhaps I'd only make this point. As a matter of fact, that meeting happened. As a matter of fact, these terms of reference were adopted, draft terms of reference. As a matter of fact, these terms of reference stand. As a matter of fact, the President was entitled to have regard to it. So those are the submissions on that. Justices, then when one looks at the procedures and parameters that she identifies at paragraph 91.2, one would have regard to the terms of reference and one would have regard to the Audi letter. Can I ask the court to go there? It's in the interlocutory bundle at page 54.
You may proceed. I will find it in this morass of papers in front of me.
Okay.
Yes, I've read it, so
You've read it, yes. So, Justices, Justice Erasmus, you put to me the question of at what point do the charges get put to her? And does that mark the start of the proceedings? But of course, if one looks carefully at this letter, this Audi letter of the 22nd of April, it explains to her that on the 21st of February, the DA Chief Whip tabled a motion to initiate this inquiry for her removal, and it identifies the grounds. The grounds alleged are incompetence and or misconduct. It then explains, Justices, the process with the panel that was appointed and the report that the panel submitted on the 24th of February, together with their recommendations around it. It then goes on in a fair amount of detail. I'm not going to take the court to every paragraph in it, but it says to the Public Protector in the second paragraph at page 55 that on the 22nd of February, the terms of reference were adopted, and it's attached. It then goes on to say that the terms of reference confirms in accordance with the rule that she'll be granted a right to be heard in her own defense and to be assisted by a legal practitioner or expert of her choice. It then goes on to set out that she'd be given an opportunity to call any witness, to cross-examine any witness called by the evidence leaders or submitted or subpoenaed by the committee. And it goes on to explain that the statements will be made to her at least 7 days before the hearing of the matter. It sets out the revised program that will be followed, and it says in the last paragraph, Justices, at page 55, the purpose of the communication. It serves to afford her an opportunity to respond in writing to the allegations contained in the motion in terms of the Audi principle before the committee proceeds with oral hearings. And so, Justice Erasmus, I would submit...
So this is the letter which is commonly referred to in these proceedings as the Audi letter.
The first
and that's
one.
dated the 22nd of April.
That is so.
It gives the terms of reference, etc. And
That is so.
remember at the time, so the supplementary affidavit that we've referred to in paragraph 91 was dated, let's find it quickly, 31st of March.
Yes. Yes. So, and that's a part of the difficulty, and Justice Erasmus, you alluded earlier on to the question of whether this court has sufficient information before it in order to make a call on this. And I'd submit that part of the difficulty this court had at the inception of these proceedings is that it was a moving target. Developments were happening all the time, and we're struggling to pin it as to at what point was the magical switch over to the start of proceedings or not. But much of that is now water under the bridge. And I say that because when the court adjudicates this matter at this stage, it would do so on a conspectus of all of the evidence that served in order to demonstrate, I would submit, that the proceedings have clearly started. Yeah, perhaps if I could just make that point on that issue. And then, Justices, if I go on, the third subparagraph of 91 refers to the appointment of evidence leaders. The Public Protector accepts in parentheses that this occurred on the 29th of March. So that's a non-issue. She then goes to the fourth issue, and she seems to suggest a prerequisite for the start of a hearing is for there to be engagement with the public protector regarding her availability and or that of her legal representatives. Now,
can I ask you on that? Is there anything to be argued in connection with the words used in the Constitutional Court judgment, right to be heard, as opposed to the words in 194.3, which say the start of proceedings?
yes, yes.
Those are two different concepts.
Absolutely, and I am going to deal with paragraph 110 quite carefully, but at a high level, Justice Villa, the point is this: paragraph 110 of the Constitution, is that the paragraph your Lordship's referring to?
And also the order that says right to be heard.
Yes, who read with
So
the
it said
order.
there is a right to be heard. So in
Yes.
other words, that was the legal representation.
Yes, yes,
But a right to be heard, to me, is somewhat different from somewhat different from the word start of the proceedings.
yes,
Proceedings can start before you have the right to be heard.
absolutely, yes. And that I submit is a critical point, and that's why I submit, that's the second reason why the
I'm not
Constitution...
sure whether I followed my
Sorry.
brother's question. The start of the proceedings, and I think you agree with that, is that they can start, but you don't have the right to be heard. You're the very same person that the proceedings are about your removal. I'm not sure whether.
Yes. So I see it in this way, Justice Delama. Section 194.3a provides gives the President the right to suspend. Before the President exercises that constitutional power, he has to follow a due process. The President gives the public protector audi in relation to that process, and he does so by virtue of the letter dated the 17th of March. The public protector then has, in addition to that, the proceedings before the Section 194 committee. Those proceedings she's been given her first stage of audi in relation to those proceedings, and that's the letter of the 22nd of
Is there
April.
any relevance in the fact that in your submission to us, up to that point you call it a process and then you start calling it a proceeding? Was that deliberate, or is it just...
No, it was inadvertent, Justice.
Because it could be a way of looking at it. Say you have a process leading up to the proceedings, and I'm not swayed at this stage one way or the other. I have to think it through. And then the proceedings start at which point?
Yes.
And that's why I
Yes.
mentioned the analogous litigation
Yes.
stages with reference to the civil law and
Yes.
reference to
Yes. Yes.
the criminal law.
Yes. So Justice Erasmus, that's an interesting point, because our learned friends, as you'd know from the heads of argument, they try and align it with civil proceedings and the issue of summons. And they somehow suggest that one ought to adopt a similar approach in this matter.
Well, the argument before is, Mr. Mpofu says, when the evidence is laid,
Yes.
when I'm there in the room with my legal representative,
Yes.
that's when.
Yes. And there are two answers to that, Justice Erasmus. The one is, of course, let's go back to what the pleaded case is on that and what's been said on that point. And the second is, one needs to just step aside from all of this and ask, objectively, what is the purpose to be served by a suspension in circumstances such as these, or in any circumstances, not such as these generally? And I don't know much about labor law in these processes, but as I understand it, the suspension serves a number of purposes, one of which is to protect the integrity of the office, a second of which is to avoid a situation of potential witnesses being victimized or being tried to be influenced in some way or whatever it is. And if one were to give an interpretation that says the start of proceedings is on the day that the first witness comes in. The effect of that is to fundamentally undermine the integrity of any proceeding. And it has that effect because if there was a risk of any victimization, there was a risk of any influence being brought to bear, none of that can be catered for through the suspension process as envisaged under 1943A. Justices, if I could then, I was at 91.4, which is the question of the availability of legal representatives. And the first point I make on that is, of course, and there's no authority being given for that being evidencing the start of any proceedings, none at all, and that ought to be the end of the matter. But the second thing is if one looks at that as against the first Audi letter and the last paragraph at page 56, where the chairperson said, I request that you further inform the committee by no later than 18 May whether or not you intend using a legal advisor or other experts at the hearing, and if so, to provide the committee with their names, contact details, and indicate whether they should be copied into further correspondence on the matter. So I'd submit, Justices, on that point alone, that ought to be the end of the fourth so-called prerequisite. The fifth one is the point that Justice Erasmus raised with me, no charge sheet, and I've taken the court to the Audi letter, and I've explained why that in effect addresses the fifth and the sixth points.
It references the panel report as well, and it uses the electronic links to the letter.
Absolutely, that is so. So, Justices, we say for all of those reasons, none of the 6 prerequisites that the public protector puts up herself actually has any bearing on this, either because there's no basis for that constituting a prerequisite, or because on the evidence before this court, all of those have now been overtaken by events.
In determining whether the proceedings have started, are we confined to look at what she puts up? Let's say, if none of these factors that she puts up points to the proceeding not having started, therefore, we can conclude that they have started, or we can look at objective factors
Yes.
to come to a conclusion
Yes.
whether they have started or not
Yes.
started.
So let me answer it this way, Justice DeLonge. If the factors the court is going to look at are the kinds of issues that ought to have been foreshadowed in the pleadings so that the parties had an opportunity to address them, then I'd submit it's not proper for the court to go beyond the pleaded case. If the issues are such that they're either common cause or they don't necessitate any further evidence, then of course the court is at liberty to do so.
And one of the common cause factors is that the President's letter preceded this one that came from
The 22nd of April, the Audi letter.
Yes. So, Justice DeLonge, I've engaged with that issue long and hard in preparation for this hearing, and I've wondered what then is the import of it. And I think, let me answer it this way. I started my address by engaging with the question of the competence of the relief that was sought around the letter. If you're with me on it not being competent, then that ought to be the end of the matter on that. If it was premature, he still hasn't exercised a 1943A power. And for that reason, there's no prejudice to be sustained by it. And it follows that there's no order that can be given from it. And so even if it was early, as matters stand, the public protector got the first Audi letter from the Section 194 committee on the 22nd of April. She has until the 23rd of May by which to respond, and she has until the 26th of May by which to respond to the President.
So, as the founding affidavit was drafted long before, when the matter came before us on the date of the postponement, I think it was the 25th, we were told from the bar about this Audi letter by Mr. Mkhwebane. He said my client only got it on Saturday or something like that. But now the papers were supplemented, and now all these papers, all these affidavits were admitted, all these further affidavits on both sides, on all three sides, put it that way. And all this information is before us. Is it necessary for us to make a definitive finding on when the process starts?
Yes.
If we are reviewing the process has not started when that letter of
17
on
March.
page 2 in the notice of motion was written, that's the end of the story insofar as the finding of that it was premature. Whether they would be entitled to, if it's a mandamus or an interdict in respect of the letter, because it's water under the bridge.
It's water under the bridge.
But that's it. That finding is made. Then there's no need to go and look and make a definitive finding on the start.
Yes, yes.
And because by doing that, we will make a finding without necessarily having all the participants that might come to court on that issue before the court.
Yes, yes.
There might have been amicus that wanted to join, but this was not the place to come. Because I suspect there's going to be a debate around it. And there's going to be litigation.
Yes.
And whether the case was properly pleaded and all the necessary information, all interested parties are before us, that we will have to think about before we make a definitive finding.
So, Justice Erasmus, I agree with that proposition, and I agree with it for the following, not only because it supports the case I'm making out, but I agree with it because I believe it has merit. On the evidence, on my counting, there have now been 9 steps that have been taken in this process. And I'm going to go through it quickly. I know I'm probably running out of time. And my submission at the end of it would be, when the court looks at all of those 9 steps overall, it is indisputable that the proceedings have started. And whatever the position historically might have been, that's of no moment. As you adjudicate on this matter, on the evidence as it stands, it has in fact started.
And that is up to, when did we start?
The 17th, the last affidavit.
I think the last affidavit was the 15th or the 16th.
Okay. 17th, my attorney says to me.
The day before Mr. Owen's affidavit and Mr. Manuel's affidavit came in. So it was the 17th.
The 17th, yes, thank you. So, Justices, if one then looks at it, let's start at the very beginning on this issue. And the court would bear with me for a moment. Can I ask the court to go to page 486 of the papers? It is in volume 5. For 486, Justice Delano, volume 5.
Of the original.
Of the main pleadings bundle, that's a.
Okay, you may start.
Thank you.
I will find my papers.
Thank you. Justices, that's a letter from the Speaker dated the 21st of July 2021, and it's addressed to the President. It has in the title line, commencement of proceedings of the Committee for the 194 inquiry. And she says to the President, I wish to advise the President that the committee established in terms of Rule 154 to conduct the 194 inquiry into the removal held its first meeting on 20 July 2021. The committee has now elected its chairperson, and it will now commence with the inquiry as provided for in the Assembly rules. As previously advised, once the Assembly has considered and debated it, basically the President will be informed of the resolution. So that's strike one as to on this chronology. Strike two, Justices, is the meeting that was held on the 28th of July. You needn't go there, but if I can just give you the reference, it appears at page 367, paragraph 71. At that meeting, a range of issues were discussed, including the purview of and the form of the inquiry under Section 194 and the draft program that would be adopted. Strike three, Justices, is the affidavit to the Constitutional Court on the 18th of August, which then referred to the proceedings being suspended pending the outcome of the application for leave to appeal from the Crown Court. Strike four is the meeting of the 22nd of February, and that's dealt with at page 367, paragraph 73, and at page 726, paragraphs 21 to 23. And according to the chairperson's affidavit, at that meeting of the 22nd of February, it considered the Constitutional Court's decision, it considered the Public Protector's request to halt the proceedings and decided to continue with the inquiry, it adopted the terms of reference, and it resolved to identify the evidence leaders and adopted a draft program as a working document. So that's what happened, and whatever the Public Protector may say in criticism of that meeting, at the level of fact, that is indeed what happened. And then, Justices, you'll be aware that on the 10th of March, the Speaker sent the President a letter that appears as in Volume 5, PAA 6B, page 487. And
It was also in the founding papers.
It was, that's right, Justice Erasmus. In that letter, she refers to the resumption of the proceedings of the Section 194 Committee, and she says in the second last paragraph, in this regard, the committee resolved on 22 February 2022 to continue with its consideration of the motion for the removal of the Public Protector. The committee has adopted its terms of reference and a program to guide its proceedings and progress.
I don't want to misunderstand your point by reference to all these steps. And it seems to say because the steps were called proceedings, therefore the proceedings have commenced.
No, not at all, Justice Delano. Absolutely not. What it's saying is that if one can't telescope it to a magical date on this, one looks at it in a contextual way, in accordance with the principles that ought to guide this court in its interpretation of 194. And on that contextual analysis, when one looks in context, all of these steps, it can only result in a single answer, which is that it started. So then, Justices, the next step, the sixth step in this, is the meeting of the 29th of March, and that's referred to at the chairperson's affidavit, page 729, paragraph 29, where it said that the committee met for a fourth time. At this meeting, members were reminded that the terms of reference had been adopted. They were informed that the Public Protector had asked that the process be halted. They resolved to continue their work as per the existing program, and they welcomed the appointment of the evidence leaders. The 7th, Justices, is the letter, the first...
Just to go back to that, you say the Public Protector, the applicant asked for the process to be halted.
Yes, the Public Protector had asked for the process to be halted. That is so.
A process which hadn't been started.
That's, it's contained in Mr. Janchi's affidavit.
That's right.
yeah.
That's right. Let me actually take the
That's at page 729 and more particularly in paragraph 29, sub 3.
That is so. That's exactly so, and it just so that I don't misquote it at all, Justice Villa, at sub 2 it says, Mr. Dianti says, the letter further requested that the committee halt its process until the rescission application had been finalised. And then, Justices, the next step was the 7th step in this, is the first Audi letter. I've given you the reference, the interlocutory bundle, at page 54, and it's dated 22 April. The next step of it was the meeting of the 11th of May of the Section 194 Committee, and I'm actually going to ask the Court to go there, if the Court wouldn't mind going to the interlocutory bundle at page 2. This is in the DA's further affidavit. And Justices, I refer to this. I understand the applicant raises in their further affidavit an objection to the admission of this. I had understood that the Court didn't have a problem with it, but obviously I'd make a submission on the basis that it is admitted. But it's page 284 of the interlocutory bundle, paragraph 20, where it said on 11 May, the Section 194 Committee met and took the following decisions that are relevant to this matter. First, it decided to continue with its inquiry. Second, it approved a draft updated program, which is then attached as PM 13. And then it says, in terms of the program, there will be an invitation for public participation in the period between 12 May and 2 June. The committee will meet to discuss the procedural management of the hearings on 3 June. The evidence will be processed and preparations will be made for the hearing between 7 and 10 July. And the committee will start its hearing of evidence from witnesses on 11 July 2022. The committee aims to adopt its final report on the 29th of September. So that then, Justices, takes us to the last step in this whole sorry tale, and that is the public advertisement that was put out on the 11th. It appears at the interlocutory bundle, page 249. And it's PCA 10 to the Public Protector's further affidavit. And the Court will recall that from the terms of reference, provision was made to afford the public an opportunity to provide information. And this is an advertisement inviting the public to furnish information to the committee into the removal of the Public Protector. And so, Justice,
They envisage that the charge sheet might grow when these inputs from the public are received.
I'm not sure. That's not foreshadowed on the papers. I see it as the perhaps let me read it from the notice. It says that it's the objective of the inquiry is to assess the charges contained in the motion in order to determine whether Advocate Mkhwebane
So it's the charges of the Mazzoni.
Exactly. That is. So, Justices, let me, I know I've been on my feet for a very long time and I'm not anywhere.
How long do you anticipate you still doing?
Oh, it's, Justice Erasmus, can I finish this point? And then I had promised my very good friend Mr. Budlander that I would be off by 2:30, but I don't think that's going to happen.
No, because then we can take the adjournment at a convenient time.
Thank you.
We might want to take the adjournment from 2:15 or 2 o'clock. Gives us 3/4 of an hour, and then you still have another half an hour thereafter before he comes in. And I doubt that he's going to be that long, because a lot of the issues that he raises has been raised by yourself and Protector. Obviously, must have sufficient time, and then Advocate Mpofu must still reply. So I'm thinking, to my mind, if we can try and get you out of here by 2:30, get Mr. Budlander in, give him 2 hours, gives us 4:30, and then give Mr. Mpofu an hour to reply. He's been on his feet yesterday for much longer than what we anticipated. So that'll take us to 6 o'clock round about there. And I'll speak to my colleagues whether we can extend the time.
Thank you. Thank you. Justice Erasmus, let me.
Good news for you. Colleagues have no time limit tonight. So when we adjourn, I'm going to arrange with the court manager to see whether we can have relief staff for the admin staff after hours.
Thank you very much.
Yesterday we got it right. I can't guarantee that we will have the necessary support staff available, because it's short notice. People use public transport a lot. You see, we have a lot of female staff. They've got children at home that they have to pick up and so forth. So we'll try our best from our side. But amongst yourselves as practitioners, try and keep it as tight as possible.
We will.
So that we don't unnecessarily inconvenience the staff. As the bench, we've made a commitment. We'll try our best to sit and finish today. But just bear in mind, it's not just us.
Yeah. No, we're greatly indebted to the court for facilitating it. Thank you very much, Justice.
So until 2 o'clock, then. So the court will adjourn till 2 o'clock, 1400 hours, and will the usher will you just tell the security that we're starting early so that they let the people in.
Yeah, well, yeah.
Thank you.
Ms. Miller.
Thank you, Justices. So I want just to round up the point on the start of the proceedings, and I want to do so, Justices, with reference to 5 points in closing. And I make each of those 5 points against the background of the threshold outer requirements. And the court will ask, in light of these 5 points, do we reach the threshold of the clearest of cases? So, Justices, the first is the question of when was the motion presented to the public protector, and there was some suggestion that that may be the charge sheet or the basis for it. And it's interesting, Justices, because if you look at the interlocutory bundle, page 55, which is the Audi letter, and the second page of that letter, second last line, the public protector is told, "It is my understanding that you have previously been furnished with a hard copy of the motion and the accompanying evidence." And then if the court has regard to the DA's affidavit, at page 798, volume 9, and the court will see that the copy of the motion is then attached to that, as is the full panel report. And so the first point I make, Justices, is that that horse has already passed and it's been overtaken or bolted, it's been overtaken by the Audi letter, and that's point 1 in engaging with the question of whether the proceedings have started or not. Point 2, Justices, is the principles of interpretation that would guide this court on interpreting section 194.3a. And we've referred in our heads of argument, Justices, to the matter of EFF versus the Speaker. It appears in the authorities bundle, page 42, and it's at paragraphs 49 and following from there. And the takeaway principle from all of that is the significance of this office and the importance of preserving the integrity of the office.
Yes.
Thank you. The importance of preserving the integrity of the office, and in giving that interpretation, this court will engage with a point that I've already made but want to emphasize, and that is if the court raises the issue of the start of the proceedings being when the first witness testifies, whether or not that defies the objective of a suspension, at least in part, or undermines the objective. The third issue is just to emphasize the 9 steps that I've pointed out and to say that the court looks at all of that holistically to reach a conclusion as to whether or not the threshold requirement has been met or not. The fourth, Justices, is to make the point that none of the 6 grounds that have been raised at paragraph 91 of the founding affidavit withstand scrutiny for reasons I've addressed. And the last is a point that Justice Villa raised with me, and I don't think I engaged sufficiently on it, and that is the relevance of paragraph 110 and the order of the Constitutional Court. And if I could just make, I think, a couple of concluding comments on that before I move on to the question of conflict. The first point, Justices, is it's significant that of the 9 points that are highlighted, at the point at which the Constitutional Court judgment was handed down on the 4th of February, we were at point 3 of those. And so things have moved on substantially since then. The second point is, of course, this issue arose in the context of the retrospectivity argument as raised. It's a very different question because the question is in the context of legal representation and whether or not it goes retrospectively or prospectively. And that's, of course, a different inquiry to one of whether the 1943A proceedings have in fact started. And one sees that, as Justice Villa correctly pointed me to in the order at paragraph 3, the order didn't... Oh, I'm sorry, Justice Erasmus, it's you.
Yeah.
It's my apologies.
No, it's fine.
It's the amended rule now provides for that, and it talks about affording the holder of the public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert of his or her choice. So it's about legal representation. That's what the rule was at issue in those proceedings. And we submit that's very different from what we're dealing with now. So,
and the Constitutional Court, in terms of Section 172,
1B, yes.
They did not make any order regarding retrospectivity, did they?
Yes. No, they...
721B,
yes.
Roman numeral 1.
Yes. Yes, so they say at paragraph 110, as a result, the retrospectivity of the order of constitutional invalidity will have no bearing on the lawfulness of the current process and will not disrupt the steps already taken. When the 194 inquiry formally proceeds, the public protector will be entitled to full legal representation. That is the key, Justice Erasmus.
Of paragraph 110 of the Constitutional Court judgment.
Yes.
And then one must determine, if necessary for our purposes, when does it formally proceed?
Yes.
And that's a question one has to determine on the facts.
Yes. So, Justice Erasmus...
And you're saying that for your purposes, and that's going to be in this argument as well, with the adoption of the motion goes to the committee, that is the proceedings before the committee. But at worst, there's another point to be determined.
Yes. So I think, reason it slightly differently. The wording of 1943A refers to the start of proceedings. It doesn't talk about formally proceed or whatever it is on that, unless I'm misunderstanding you, Justice Erasmus.
Remember
so, yes, correct, it does.
Remember the process, and I call it the process deliberately. The process of the 194 committee started way back in 2021.
Yes.
And then it was paused.
Yes.
Part of the judgment discusses that, pausing
yes.
the Chinoli indication.
Exactly. Affidavit, yeah.
Now one has to determine what is meant by that. Proceed from where they are after the judgment. Proceed from the point where they paused, and then one has to read that in terms of when does 1943A kick in, and that's the start of the proceedings. Well, for us, it's an interpretative exercise.
Yes.
Having regard to the legal principles as well as the that's
yes.
how I understand it.
I understand it in that way. Thank you. Justices, that then brings to a close my argument on the start of proceedings. And for all of the reasons I've submitted, the point is there's no prima facie right that has been demonstrated on there, and therefore our learned friends don't get past the first threshold for interdictory relief. The second basis on which the prima facie right has been founded is the question of the conflict of interest. Now, this, Justices, is a particularly interesting point because it morphs in the papers and the argument likewise morphs. So there's three different terms that I used. The primary one appears to be one of a conflict of interest, and that's the one that's foreshadowed at paragraph 53 of the founding affidavit. Paragraph 68 then refers to bias in relation to the President, and it's referred to in the context of the so-called hurried action by the President on this. And then the Nemo Judex principle is referred to at paragraph 125. And in the course of argument by Mr. Mpofu, the argument was made, well, one analyzes or looks at it on 3 grounds: actual bias, reasonable perception of bias, and conflict of interest as foreshadowed in section 96. We say the starting point when looking at the question of bias is the principle, or conflict of interest, whatever you call it, is the principle that there's a presumption that administrative officials will perform their functions lawfully. And that exists as a matter of legal principle in our law. If I could give the court the reference, it appears in a couple of cases, but perhaps the easiest one is Minister of Health versus New Clicks. It's 2006, Volume 2, SA 311, CC at paragraph 152. And so the corollary to that is that courts will not assume that a discretionary power is going to be abused by whether it's an official, whether it's a president, whatever it is. And the authority for that is Glenister versus President of the Republic, 2011, Volume 3 SA, 347 CC at paragraph 222. So that's the departure point, and in light of that principle, one of the questions this court's going to have to engage with is, does the case made out on conflict/bias rise to a prima facie right? Justices, then let me deal with the 3 different terms that have been used and what the import of it is for the interdict that's being sought by this court. The first is the conflict of interest term, and if the court would have regard to to section 96 of the Constitution, and the court will see at 96(2)(b), members of cabinet and deputy ministers may not act in a way that is inconsistent with their office. Let me pause there. That's not the applicant's case in this matter. Or expose themselves to any situation involving the risk of a conflict, and here's the important part, between their official responsibilities and private interests. So the first question that this court will ask...
And in terms of section 91, the president is a member of cabinet.
That is so, Justice Erasmus. So the first question that this court will ask is on the case that the public protector has made out. Has she demonstrated a conflict between personal interests and official responsibilities, private interests and official responsibilities? And justices, we say that...
dealing with it in the last affidavit by the president, or Mr. Owen, on his behalf. I'm not going to go there to the affidavit to try and find it. The point is made that he only deals with those 4.
Yes.
That's the Busasa issue, the Dirks issue. There's an NGO that...
The judicial culture.
And there's a 4th one.
Yes.
And in the answers, he says, the first time I hear about this, when it was raised in there.
Yes.
So maybe in the context, as you discuss that, also take that into account.
Thank you, Justice Erasmus. I will. So it's an interesting point because we raise the point, and then the court will see in the public protector's replying affidavit, the court need not go there, but if I can just give you the references, it's page 961.
The 4th one is in Biowatch.
Thank you, Justice Erasmus. The references in the reply, page 961, paragraph 37, page 970, paragraph 66, page 1076, paragraph 18.2. And in all of those places, what the public protector says in response to this question of the clash between the private interests and the official duties, she says, well, if you look at two of the examples I've given, the one being the Bosasa matter and the second being the Zimbabwean trip, both of those fall within the purview of Section 96. So implicit in that is that her acceptance that none of the others fall within that.
The other one deals with the state capture, the judicial capture, and the Dirks matter deals with the leaked tape.
Yes. Yes.
Now the leaked tape, there are a lot of documentation to and fro between
Yes.
the public protector and the president, and that's what happened in March of this year.
Yes.
When the complaint was made, the public protector initiated the investigation, asked the president for an answer, and he answered.
Yes.
And then the judicial capture seems to come from the inter alia, from the interviews for Chief Justice.
Yes.
And the Malambo interview and the role of the Minister of Justice. That's how I understand it.
Yes.
The Zimbabwe trip is the now Speaker when she was Minister of
Defense.
In the bilateral with the counterpart, and then the ANC officials hitching a ride.
Yes. Yes.
On the plane.
Yes.
And I'm mentioning this to you so that you can get your sequence right. And in the Bosasa matter, your answer is it's been dealt with by the courts. Mr. Pofu in argument yesterday said, no, that's not totally correct because there's a sealed documents issue that's still alive, and that might expose practice.
Yes. Thank you. Thank you. Just I'm going to bear all of that in mind. I think the first point that I want to make is if the case is one of a conflict of interest, it's going to have to be the threshold of Section 96(2)(b that has to be met. And my submission to you is that on all four of those instances, contrary to what the public protector says, I will demonstrate to the court that there is no clash between official duties versus personal private interests on this. In each of those instances, there was an investigation or a pending investigation, whether as president or as deputy president. Those occurred by the public protector in purported compliance with her mandate. In taking a decision on the suspension, the president is tasked in his official capacity to take that decision. In relation to the investigations, they were against the president in his official capacity as president or as deputy president. And it follows from there, Justices, that one doesn't get to the 96(2) so-called conflict as contemplated. So then the second issue on this is just to dwell for a moment. I know we've spent some time in our heads dealing with it, but on what the import of the public protectors at the level of principle of her argument on conflict is. We know that the president ultimately appoints the public protector. We know that the president ultimately promulgates the ethics code against which people are held to account.
Which one?
Point taken, Justice Erasmus. And we know that the President has the power to suspend and the final removal pursuant to the 194 process. And the key question is there any basis on which to suggest that each of those functions operate in these hermetically sealed bubbles, and that any overlap between them actually results in conflict? Because if that were to be the departure point of this court, it would mean that this court would be fundamentally rearranging constitutional processes and objectives. That's the import of the public protector's argument on that.
Should we, in considering your argument on principles to be applied, we'll also measure that against the relief sought? Because
Yes.
as I read the relief sought in this regard, it's 1.4
Yes.
of the notice of motion.
Yes.
And we've dealt with it this morning about taking any steps in pursuance of the suspension.
Yes.
Now, even the letter will be a step
Yes.
in pursuance.
Yes.
Is the delegation of his constitutional powers to another member of cabinet in order to perform this function, is that a step
Yes.
for 194? And if so, then we tread on very dangerous ground.
Yeah.
Because the effect might be that you denude the holder of the constitutional power of that power, and is it the place for the judiciary to rearrange the constitutional makeup and the framework?
Yes. Yes. That's exactly right. Justice Erasmus, my submission on that point is that's exactly right, and the breadth of the relief is apparent from the plain wording of the notice of motion. One needn't go any further. On its plain wording, it goes as far as I've submitted to the court. But the second issue, Justices, sorry, I've lost my train of thought. Is that on the facts, they actually haven't demonstrated a conflict. So one doesn't even get there. So if I could then just, and the point I was making is this, at the level of principle, if the submission is each of these functionaries have very compartmentalized functions, and the moment there's any overlap between them, it results in a conflict. If that's the departure point, it has to be applied consistently. And a consistent application would denude the public protector of ever investigating the president because the president appoints her. It would denude the public protector of using the ethics code against which the president is to be appointed because he promulgates it. It would denude the president of any power to suspend her because of all. So those are the ramifications, and which is why the analysis of the conflict issue needs to be carried out as carefully as I'm submitting.
You can't approach this simplistically because then it will apply to a judge.
Yes.
And more particularly, the category of judges where the president makes a selection. Because when it comes to the High Court judges, I'm just using as an example, when the JSC makes a recommendation, he must.
Yes. Yes.
But when it comes to the leadership of the judiciary, on the Chief Justice and the Deputy Chief Justice, it's a different story.
Yes.
We just had it now. 4 names are sent through, or how many ever names are sent through, and the president makes a selection of the consultation. All of us, when appointed, ultimately the president signs your appointment letter.
Yes. That's right.
That's the constitutional framework.
I could do no better in showing what the import of this kind of reasoning would carry way beyond this application, Justice Erasmus.
My other question, and I'm taking some of your time, but I want clarity on this point. is, does it arise now? Because if you apply the basic test for an interdict,
Yeah.
in the event that the President does not suspend, it won't arise ever. In the event that the President suspends, the conflicts and so forth, that can be taken as
Yeah.
a ground of review when it ultimately comes up. So there is an alternate remedy.
Yes. Absolutely so, Justice Erasmus, and that's where the conceptual muddle in this comes up. The conceptual muddle is the fact that at this stage, for an interim interdict, those matters have to rise to the level of a prima facie right, and they have to be able to show that there's no alternative remedy. And if they don't, then the public protector is not left without any recourse. The remedy is then review on whatever grounds at the end of the day. So I'm conscious of time, Justice Erasmus, but I agree with the submission. There's one last point I want to make on the question of conflict of interest, and it's a point, as far as I could see from the papers, that despite the President having raised it consistently through, it hasn't been dealt with at all by the applicant, and that is the import of Section 13 of the Public Protector Act. Because Section 13 of that Act, Justices, I noted to my horror, we didn't have a copy of the Act in the bundle. I'm reluctant to give you too much more paper, but can I hand this up, please? Thank you.
For completeness, I take it you have it somewhere in PDF form.
My attorney will.
Since the only thing is forwarded to Ms. Davis in PDF form, and then we'll upload it onto the electronic record that we've prepared.
Thank you.
So that everybody has access to it, and for our work over the weekend, we don't have to ship all this paper around.
Thank you. So, Justices, if you would go to Section 13 of the Act, which is headed Application of Act, and it says the provisions of this Act shall not affect any investigation under or the performance or exercise of any duty or power imposed or conferred by or under any law. And so we submit, on a proper interpretation of Section 13, it's the Public Protector Act that gives her the power in Section 7 to conduct an investigation. We know, and we've raised in our papers, the breadth of those investigative powers. She's entitled to conduct a preliminary investigation. She's entitled to conduct an investigation for something like discourteous conduct, or conduct that concerns or causes prejudice to another person. And so, on her reasoning, it would be, if she starts an investigation against the President, for instance, because there's a complaint that he's discourteous, she's passed the hurdle of an investigation, and never mind that, the consequence is that she's ousted his constitutional powers. And we submit the legislature and the makers of the Constitution were very much alive to that. And that is why Section 96 is framed in terms as circumscribed as it is, and that's why we have Section 13 of the Public Protector Act, which allows, notwithstanding any investigation pursuant to this Act, it allows for functionaries to continue to exercise any power or duty imposed or conferred by law. And when the court has regard to that, Justices, we'd say or submit that it would be an exceedingly difficult point to reach a conclusion on the outer test that despite Section 96 And despite Section 13 of the Public Protector Act, she's risen to the level of the threshold that outer contemplates. And so for all of those reasons, we say that there's no case that's been made out for a conflict of interest, and that then ought to be the end of that issue. The question of bias, Justices, there's no case, although there's vague reference to bias because of how hurriedly the President acted, there's no analysis in the founding affidavit or anywhere else as to whether it's actual bias, whether it's a reasonable perception or apprehension of bias, and how does all of that actually work or impact on it. On the actual bias, we submit that it can be disposed of very quickly. No case has been made out for it, and that's the end of it. On a reasonable perception or reasonable apprehension of bias, we submit, Justices, that we know that's an objective inquiry. It's therefore not what the Public Protector thinks. It's all factors considered. We'd submit that when one looks at that against Section 13 of the Public Protector Act, the court would be hard-pressed to say that even if a case for a reasonable apprehension or reasonable perception of bias has been met, it rises to the level of the outer threshold. So, Justices, for all of those reasons, at the level of principle, we say that the claim for a conflict of interest, bias, actual or perceived, simply doesn't get off the starting blocks. Let me then move to the 4 points that Justice Erasmus raised with me, which is the 4 grounds on which the Public Protector alleges conflict or bias. And I think it might be a good idea to ask the court to go to paragraph 53 of the founding affidavit, which 23, exactly. Thank you, Justice Erasmus. And what's striking about this is the way in which these challenges are brought. We know now the threshold is a high one, and in seeking to vindicate that threshold, the Public Protector deals with it in the most superficial of ways. She says at 53, the President is disqualified due to a conflict of interest in respect of various complaints against him, which have been and or are still being investigated. And the first is the Bosasa CR17. The second is the allegations of the judicial capture. I'm going to interrupt this chronology, Justices, just to make one point here. You needn't go there. But if I refer you to the Public Protector's replying affidavit, page 959 at paragraph 29. You'll see that there's an important and significant shift in this issue of the allegations of judicial capture. I highlight only that at paragraph 53 she says that it's complaints against him which have been or are still being investigated. It's framed somewhat differently in reply when the President points out this is the first time he's heard about these allegations of judicial capture, and it's referred to as him being implicated in it. The third is the Scopa complaint, and the fourth is the Zimbabwean trip complaint. So let me then go to the first of it, Justices. On the Bosasa complaint, the argument appears to be this, that because the President was involved in litigation against the Public Protector on the Bosasa matter, and because he accepted, for the purposes of the previous litigation, that while litigation was pending, he would not make a decision on a conflict. It follows from there, so the Public Protector argues, that that conflict must be accepted as a matter of fact, and that conflict doesn't, what's the word she uses, evaporate the moment the litigation is complete. And Justices, we say we've dealt with it at length, and I'm conscious of time, but we say that the points on the Bosasa litigation are pretty narrow. The facts as the President sets them out are as follows. The Public Protector issued a report in which certain findings were made against the President. The President disputed that report on various grounds, and he did what any ordinary person would do, which is to take it on review. He was vindicated in the High Court on that review, and he was vindicated by the Constitutional Court on that review. And the Constitutional Court has now spoken definitively on that issue, and that now is the end of the matter. The fact that he agreed not to make a decision while litigation was pending is no basis on which to oust that constitutional power at this stage of the process. But the Public Protector then comes back with a further point, and her further point is, well, never mind that. In addition, we have litigation that's now pending in the Gauteng High Court, and litigation, in that litigation, both the President and the Public Protector are involved. And she says, albeit very guardedly in her replying affidavit, but she says, well, as Justice Erasmus has raised with me, that may have the effect of overturning a whole number of things on the Constitutional Court judgment. She doesn't tell us exactly what that is. She doesn't tell us why that is. And she doesn't tell us why, on a factual matrix of where the Public Protector has filed a record, one political party goes to court and asks for the unsealing of that record. The President is cited as a respondent in that matter. The Public Protector is cited as another respondent in that matter. Neither of them actively become involved in the litigation. And the President says, when the CR17 campaign came in, got involved in the litigation, I decided to take a back seat to it. So the breadth of what's being asked of this court is somewhat alarming. It's where you have two state functionaries as co-respondents, no litigation neck and neck against them, yet this court is being asked on the basis of simply being involved in the litigation to find a conflict. And so we've set that out, Justices, in a great amount of detail in the President's answering affidavit. I'm not going to go there. Actually, let me perhaps just give you the reference. Can I ask the court just to, at page 324, volume 4, the President sets out the guiding principles in relation to conflict, and at 328, he goes item by item, blow by blow, in relation to the 4 issues that she raises.
Of the main.
That's so. That is so. So that's the case, Justices, on the Bosasa matter. The next case is on the claim around judicial capture. Now, that's dealt with in the President's affidavit at page 337, paragraph 40. But it's another surprising complaint, and it's surprising for these reasons. Firstly, the President says he knew nothing about this report, about this issue or complaint, until shortly before this application was launched, when it was foreshadowed in a letter written at the end of May. He says that, Justices, at page 338, paragraph 41. The second is he says he's now looked at the complaint, and the complaint is one that the Public Protector herself attaches to the papers. And the complaint says in terms that its purpose is to lodge a formal complaint against Minister Lamola, the then now Chief Justice Zondo, and Judge President Mlambo. That's the purpose of the complaint in the letter itself. And then she goes on, or the President then goes on to then explain there's certain statements that are attributed to Justice Mlambo in the JSC interviews where he is being interviewed for Chief Justice. He's now caused through his attorney to go in and to look at the recordings of that, to listen to the recordings of that interview. And that interview actually says nothing of that which is alleged. And he sets it out, Justices, quite helpfully at page 340, paragraph 44.2. He says that the complaint was that J.P. Mlambo said as follows: during the Mlambo stated publicly something to the effect that he did not apply to act, but received a call out of the blue from the DCJ Zondo, who informed him that he was instructed by the President to appoint him, i.e. Mlambo JP, to act. Then the President says, based on what Mr. Owen has heard, the correct quotation of what was actually said is referred to there, and it doesn't vindicate the complaint or what the public protector attributes to the President in all of this. And he goes through in agonizing detail to show what the recording actually shows as compared with what's been alleged. And then he says, Justices, at paragraph 44.3, he categorically states that he did not instruct the Deputy Chief Justice to appoint Judge President Mlambo to act in the Constitutional Court, and he appreciates the constitutional role in all of that. And one would then pause and ask, on facts as tenuous as those, does it rise to the level of outer for this court to interdict the exercise of a constitutional power? Justices, if I could then take you to the third complaint, which is the Scopo complaint. And that's dealt with at page 343 of the papers. And the President there once again gives a very detailed explanation. I won't belabor it because Justice Erasmus has run through it already, but I do want to make only this point, and that is Scopo asked the President for a response to certain allegations that were allegedly made at an ANC-NEC meeting on the 27th of March, where it was alleged that the President made reference to a misuse of public funds in internal elections for leadership positions in the ANC. The President was then asked to respond to Scopo, and he then gave a comprehensive response to Scopo. He refers to that, Justices, at page 344, paragraph 48.2. And then he says, after having done that, at 48.3, he then received a letter from the Public Protector on the 14th of February, and in that letter, she said to him that he had violated the ethics code because he had failed to inform and provide evidence to all relevant authorities that he had knowledge and evidence of misuse of state funds for party activities in order for them to investigate. Justices, at paragraph 48.4, he then summarizes his response to the Public Protector, and he says at 48.4.5, I confirmed that I have no direct or personal knowledge other than this publicly available information of who used public funds, from the institution, from which institutions or entities they sourced these funds, or how the misuse of public funds happened, or to whose benefit it was used. And he identified in his letter to Scopo some of the public sources, I think he identified 5, where he got that information from. And what's remarkable about this complaint, Justices, is the President then comprehensively and exhaustively addresses it. And it doesn't follow with a letter saying, you've answered the question, that's the end of it. It follows with a letter on the 22nd of March, it's at 48.5, from the Public Protector, which says, I've now written to the ANC for answers on this. There seems to be a veiled hesitancy on the part of the ANC to give me that information. And in light of you being the President of the country and of the ANC, I'm asking that you assist me in availing this information that I had requested from the ANC. The tone and tenor of that letter goes a long way toward showing that there's no indication of any wrongdoing on the part of the President. His cooperation is being asked for, and the President then replies to that. So that shows another example of where the nature of the complaint is such that it simply isn't elevated to making out a case of conflict, bias, or anything else. I'm conscious of time, so let me move quickly, Justices, to the last of the four issues.
I've looked at paragraph, from paragraph 53 onwards.
Yes.
Now these, the response of the President was on the 3rd of March.
Yes.
To that, to the SCOPA.
Yes.
And he wrote back, or the follow-up letter was the 22nd. Now, I've looked at the attachment to the founding affidavit.
Yes.
That letter of the Public Protector to the President wasn't attached, was it? Did I miss it?
No, it wasn't attached, and if I could... Yes, go ahead, Justice.
The applicant sets out a case of I'm investigating. It's attached the answer, paragraph 58 of the farming affidavit.
Yes. Yes.
So it ends, insofar as the SCOPA issue is concerned, as BMS 7B.
Yes.
But there was another letter on the 22nd of March.
Yes.
To the President. That's not being dealt with in the founding paper.
Yes.
The founding affidavit was signed on the 31st of March.
Yes. Yes.
A week after that letter.
Yes. And it actually goes beyond that, Justice Erasmus, and that is, can I ask the Court to go there? It's volume 2, page 176.
So it will be volume 2 of 11 that later became volume 2 of 15.
Oh, yes, that's right.
So page?
Page 176. And this is the sole document that she attaches.
The unfortunate issue is that because the case has morphed, you've got documents all over the show, and you have the duplicates of documents more than once. and the indexes are different for the two sets of papers filed. Some of the indexes says file 2 of 11,
Yes.
and then others, then becomes 5 of 14. So for the way we work it makes it extremely difficult, especially if you work with hard copies. I'm with
Thank
you.
you. So
176 is that?
it's the 7B letter, Justice Erasmus.
Yeah, that's the letter from the President.
Yes, but what's interesting, you raised with me, well, she didn't attach some of the other letters, but very importantly, she didn't even attach the annexure to the President's own letter. He says at paragraph 2, I attach to this letter my submission to SCOPA, which contains a full response to the allegations, which I deny that I have in any way contravened the ethics code or any further obligation. And then if you turn over the page at 2.5, he says, I refer the Public Protector to paragraph 10 of my SCOPA submission, where I detail the steps that I've taken to ensure the alleged misuse of public funds is thoroughly investigated as requested at 20.6. And the court will know that the President then came in and attached to his answering affidavit all of the documents relating to this issue. And in response to that, we're facing a strikeout application because we're told that it's irrelevant, it's scandalous, or it's vexatious.
That's why I'm asking you a question, because I know this is 15
Yes.
application is looming.
So on that, yes, so that I think concludes the SCOPA issue. The last issue is the issue of the Zimbabwean trip. And the court would bear with me for a moment.
The affidavit of the speaker is attached.
Yes, that's right. But a number of other things aren't attached. Oh, there we go. But it's dealt with, Justices, at page 350, paragraph 50 and following. And the President takes issue once again with the way in which the so-called conflict is raised. There's a one-liner that says the Zimbabwean airplane matter is well documented and at an advanced stage. And there's a single document that the Public Protector refers to in support of that conflict. Justices, at page 351, paragraph 52. The President then explains in painstaking detail what happened in relation to the Zimbabwean trip. And he explains at paragraph 52.3 that he approved the Minister's request in terms of Presidential Act 108 of 2020, the request for travel to Zimbabwe and for an acting minister to be appointed. He then goes on to say that he then found out that there were certain ANC members who were on that trip. And he says, Justices, at paragraph 53.5, he asked the then Minister of Defence for a report on the trip. She gave one report, it was inadequate. He asked for a second report, she gave a second report on it. He considered it, he reached the conclusion, and those conclusions are set out at 53.7. That having read the reports, he's come to the conclusion that it was not in any way justified to ferry the ANC NEC delegation to Zimbabwe on the South African Air Force aircraft, which the then minister was meant to use for her own approved trip to meet with her counterpart. He concluded state resources were inappropriately used, and he therefore decided that her salary for the next 3 months should be paid into the Solidarity Fund while she continues to fill her duties without pay, and that she ensure that the ANC reimburse the state for the costs incurred in ferrying their delegation to Zimbabwe on the Air Force aircraft. And so one asks justices, in light of that explanation, the President didn't approve it. When it came to his attention, he took measures to get the facts right. He got the facts right and he imposed a sanction. The sanction was then implemented and executed. All of this happens more than 18 months ago. Not a word from the Public Protector since then. I won't talk about things subsequent to papers having been protected, but and the Public Protector then says, well, that's a pending investigation, and that's what conflicts the President. And one just has to telescope this to look again at the import and the breadth of what she's actually saying. So, justices, for all of those reasons, I submit that none of the grounds made out for a conflict of interest or bias, reasonable apprehension of it, or actual, pass the threshold that this court must be satisfied of. And for all of those reasons, we submit that the interdictory relief must actually fail. The justices, we've dealt with the question of irreparable harm, balance of convenience, and no alternative remedy already, and I think through my engagement with the bench, I've already foreshadowed those issues. I'd perhaps only want to emphasize one point, and that is that the case for irreparable harm is founded on a so-called illegal suspension. There are other rights that she refers to which don't get off the starting blocks, right to dignity, right to reputation, all of those things. But it really comes down to this. If the court were to find that there's no prima facie right that has been established for all of the reasons I've submitted, then the consequence of that is that there's no threatened illegal suspension that's going to take place, and it follows from that that there's no imminent or irreparable harm that this court needs to be interdicting the President on. And so, justices, for all of those reasons, we say then that the interdictory relief must fail. If I can, in 1 minute, just deal with the question of costs.
Of course, the request for personal costs.
Yes. Yes.
I think that Mr. Dayton about this morning, you've dealt extensively in your heads of argument on that.
Yeah.
And so has Mr. Mkhwebane and the others. Sure. So, unless you want to raise something, we can decide that.
Not at all. I perhaps just want to make this point, and that is the case for costs on that basis was not made out in the founding affidavit. It follows from there that there's no basis for a costs order on the scale that's been asked for in any event. And the second point, I think, is just to make this point clear, and that is that the President has opposed this application because that's what he's entitled to do. I would submit with great respect that he's put up a reasoned and a spirited opposition to this as he is entitled to. And we simply can't run the risk of state functionaries being told, when you put up an opposition to a case, it must follow that there's a basis for a punitive costs order. And so I submit there's no case made out on that at all. If the court would bear with me for 30 seconds to make sure I haven't forgotten anything, please. Justices, I'm told I have nothing further to add. I'm indebted to the court. Thank you very much, and to my friends for accommodating me.
Thank you, Ms. Pillay. Mr. Badlinder. No, we don't have the graveyard shift. That's something.
No, I've got the one before the graveyard shift.
Mr. Badlinder, once you're getting your papers resume at 3:15. Just to take a counter break, and then you can sort out all the technology and everything. For the people on the virtual platform, you can stay on if you so wish. Is there a way, Melissa, that you can mute these microphones? And then we'll come back in 5 minutes' time. On my watch, it's almost 10 past.
5 minutes, thank you.
On the clock, there we just need 5 minutes. On the clock there, it's 5 past. On the computer, so I'll rely on my colleagues. I think my watch is a bit fast. So we'll take a 5-minute break and we proceed.
Let's go, please.
Court adjourned.
trying to find the order of the Constitutional Court
in the
dismissing or refusing to entertain the decision application. Yes, trying to find it. It's at many places. It's the question. Yes, I can see the stamp of the Constitutional Court. I found it.
Yes, it's in yours and it's in ours. I'm just trying
I know. I've tried to find it. I had it. So this is this one. I'm looking at volume 3 or 4 in the supplement.
Yes.
So there's this investigation now launched by the public protector into the SMS with judicial capture. I'm counting there were 9 judges. 2 of them are identified in the SMS issue.
Based on the hearsay reports used to report, yes.
No. On the affidavit filed by the
yes.
By the public protector.
Yes.
She wants them to be questioned.
Yes.
Those 2, including the Chief Justice.
Yes.
So they will be the subject of this investigation. The one that will still be open and then allocated to the deputy. The letter said it was open and it was delegated. The letters were sent to us in the practice.
Yes.
And I indicated there were requests from the media, for example, to have access to the practice.
Yes.
And I refused.
Yes.
Because there were all these annexures that didn't have any status as court papers.
Yes.
But that means the Constitutional Court in Rescission 2 might sit with an issue of not having the quorum.
That's absolutely so. And
because they will now go below the 8.
Can I go one stage further? You know those serial litigants who are.
Now, let me just finish this.
I'm so sorry.
Let me just finish the point. And then the Rescission 2, I'm trying to understand. I want you to comment because you make the point here under your 8th point.
Yes.
Rescission 2, the application is for a declarative.
Yes.
Declaring actions of the court and the Chief Justice to be unconstitutional.
Yes.
Is there conflict between the court that they can't hear the matter? It affects the quorum of the court, and the minimum is 8 for the panel. So 2 is taken out, and then the court themselves are implicated. I'm just thinking aloud, and I want your submission of it.
So the point that with great respect you've touched on is that if we have too broad a definition of conflict, it has a deleterious effect in all sorts of ways. It affects those court decisions, the quorum, it affects what happens here, it affects all sorts of other cases. And that's why you only say there's conflict if there is a true conflict, and only if there's a reasonable perception of bias, not just because someone's worried.
Applying the double reasonable.
That's the point.
I've raised the point with your colleagues as to how the relief sought is played.
Yes.
In conflicted persons, in this case, the president. In the previous application, it was anybody that's conflicted,
yes,
including the politicians in the National Assembly. If at this stage before it's even delegated. And I'm sure Mr. Pofu will reply on that, because I've raised it this morning with all the council that came. Does it then mean that we can't delegate also?
I'll tell you one thing with respect. If this court holds that the president is conflicted and can't determine this, then the moment the president delegates it to anyone, the next case in front of the next full bench will be he was precluded from delegating. I would lay folding money on that. It's inevitable. Inevitable. And if he doesn't delegate it, but he simply absents himself and he lets the deputy president do it, the next point will be, well, somehow he once had a discussion with the deputy president about it, and so the deputy president must therefore also be conflicted.
So one of the cases you cited in your heads of argument was the case where the judges were banking with a certain bank.
Yes. That's Absa versus Burnham. Exactly. And the court, yes. You have the point. The point is, conflicts are important in our law, and they need to be properly avoided. But if you draw the lines too broad, you undermine the judicial system, the Chapter 9 system, the government system, and you create the opportunity for unscrupulous litigants or unscrupulous participants to take advantage of it. Lastly, Justice Erasmus, and I must move on to costs, but lastly, the point is, we made the point that this case is obviously distinguishable from the two prior cases, State Capture and Corruption Watch, where the Pretoria High Court held there was a conflict which prevented President Zuma from making appointments. The one was the appointment of the NDPP, and the other was the appointment of the head of the Commission of Inquiry. And we give the reasons for that. But one of them is that suspension is just a temporary status while something else happens. Appointing someone as the NDPP for 10 years, if you appoint them, that's it, they're in. Similarly, the Commission of Inquiry, it wasn't a temporary status where someone would do something. You appoint that person as the head of the Commission of Inquiry, he's there for as long as it takes. And we make the point also that in those cases there was already a finding that the allegations against President Zuma were credible and serious because of the history of that. Whereas here, there's no basis before you to conclude anything about the complaints against President Ramaphosa. So those two cases are plainly distinguishable, and we've set that out in detail. So in summary, when you apply the Van Rooyen standard, that it is an objective inquiry, and that the standard is one which requires double reasonableness and is the view of the reasonable, well-informed observer, not the hypercritical, suspicious, paranoid observer. When you do that, and you consider these points, there is no basis to conclude that there's a conflict being shown in this case, particularly when the onus in that regard rests on the public protector to show the conflict, and there is not been shown. Justices, that leaves only one last point, and that is the question of costs. We seek an order for costs.
Let me just go back, and I've got to check in the Constitutional Court case, the one where the decision is pending. You were the only party granted costs.
That's correct.
Yeah. The other parties were all ordered to pay them.
Yes, we were granted costs because we were the only private litigant. And with respect, that would apply equally here.
And here it's yourself, the ATM, and the UDM.
Yes. So, but of course, if the application is dismissed as we submitted should be, then the ATM and the UDM would have lost. So they would not be entitled to their costs because it would be the outcome at odds with what they say.
And if it goes the other way, then you will be the only one paying costs.
It wouldn't be us paying costs, it would be the organ of state, because the Biowatch principle says that the organ of state responsible for the decision pays the costs, and the third parties who are brought in are not subject to adverse costs.
So why shouldn't the Biowatch principle apply to everyone?
Because the way the Biowatch principle works...
In your address to me, Mr. Ray, is that because it has been raised in the head, so...
The way the Biowatch principle works is this. Biowatch deals with two principles. The first is, when there is... So Biowatch, I'm going to say nothing about whether the speaker deserves costs against the public protector or the reverse. That's not my debate. But what Biowatch says is, where there is an organ of state and a private party, so the public protector and the DA, If the organ of state wins, then unless the DA has been held to act inappropriately, vexatiously, there's no order as to costs. If the organ of state loses, then the DA gets its costs. So that's as between the DA and the public protector. As regards the DA, the ATM and the UDM, Biowatch says that where you have a dispute regarding the conduct of an organ of state, which radiates out and affects private parties, you don't make all the private parties pay the costs, you make the organ of state pay the costs.
You get the protection.
Exactly. And so that's why we don't seek costs against the UDM and the ATM, we only seek costs against the public protector. So,
and do you seek it on a personal
oh yes, I'm coming to that
basis and the scale, just so that we have an argument?
Absolutely. So the first point is if we win, we're entitled to our costs, including the cost of due counsel. But now we go further, and we say that we seek personal costs awards, and we seek them on a punitive scale. Now let me deal with the elephant in the room. Our learned friends in their supplementary affidavit put up the judgment in Public Protector versus SARS, where the Con Court, quite rightly with respect, criticised the tendency of courts to make personal costs awards against the Public Protector without any basis. Not only do I accept that because I'm bound by it, as you are, I accept it because it's plainly right. Personal costs awards are a serious matter and they shouldn't be given willy-nilly or on any of that basis. No difference. But one mustn't forget that the court which gave personal costs against the Public Protector was the Con Court in South African Reserve Bank versus Public Protector, firstly. And one secondly mustn't forget that in the Estina Dairy case, which is DA and CASAC versus the Public Protector, the High Court gave personal costs against the Public Protector, and the SCA refused leave, and the Con Court refused leave too. So what does that mean? What it means is what you would always have known, which is there's no rule about the Public Protector. There's no rule about these being different cases. You will approach it on the proper basis, which is personal costs are not there for the taking. It's a serious matter, and you will only grant it if there is a proper case made out. And it's the facts of the case that matter.
I understand that this part of the argument will have to be linked up with the background and context that you argued, and then with 104
exactly
of the SCA of the Constitutional Court judge.
You have the point exactly with respect, because what we say is it is time to say enough. It is time to say that when you lose in the Con Court, that's fine. But when you then bring a hopeless rescission application, and you bring an interdict on the back of that hopeless rescission application, and then you lose that hopeless rescission application, and you bring a doubly hopeless rescission too, and then you seek, which I understand is now going to be moved as an amendment, you now seek an interim interdict pending that second doubly hopeless rescission application, it is time for the court to say no. It is time for the court to say that this is not bona fide litigation, this is vexatious, it is abusive, and it involves the Stalingrad approach, which I've referred to the Con Court judgment to deal with. Because it is, and that's for a simple reason, there is absolutely no reason that my client or anyone else should be put to the cost of defending this vexatious, wasteful, and abusive litigation. And that's what an order of special costs is intended to do. And there is absolutely no reason that the taxpayer should be footing any bill for costs when this is litigation that is brought for one purpose and one purpose only, which is to delay as long as possible the impeachment proceedings of Advocate Mkhwebane for one reason and one reason only, and that is for her personal interest. And whatever you do, even if you decide not punitive costs, you should be directing that she pays personal costs. Because this is not litigation that is brought in the interests of the Office of the Public Protector. It is litigation that is brought solely in the interests of Advocate Mkhwebane. And I might be corrected. I don't think in fact, almost sure I didn't ask for personal or punitive costs last time around, and I certainly didn't in the past. Because I'm a believer that you only ask when it's justified. And my submission is it's justified in this case. Because what has gone on here, with great respect, is abusive.
Well, the public protectors seem to think it's an appropriate case where the Speaker and the President should take personal.
That is what the public protector has thought in every piece of litigation I have ever done against her in these cases. She asked for punitive costs against the Speaker and the President in Part A in front of Justice Saldanha. She asked for it in Part B in front of Justice Baldwin. I can't remember, but I'm pretty sure she asked for it in the Concord. She's asked for it again. It's not for me to deal with it, but let me just say, the cry becomes a bit hollow when you ask for it every time. But that's not for me to deal with. But I'm making the submission thoughtfully and seriously that it is enough. It is time for this court to say that, and I'm not asking the court, I know what's going to come. We're going to have lots of reference to the Fourth Estate and political pandering. That's why I gave you the reference to Stalingrad in the judgment of the Constitutional Court. And if I can just read that quote, because I read it as part of the introduction, but it's important to bear it in mind with costs. You will recall this quote from Zuma versus Democratic Alliance. The government and public can hardly have a legitimate interest in supporting a defense against criminal charges, here impeachment, by an incumbent public office bearer, and especially not in respect of charges of dishonesty. Here's the point. Allowing officials to resist being held accountable by drawing on state resources to obstruct or delay a prosecution / impeachment subverts the government and the public interest. So if allowing Advocate Mkhwebane to resist being held accountable by drawing on state resources to obstruct or delay her impeachment subverts the government's interest and the public interest, how can it be appropriate for the government, the Office of the State of the Public Protector, to pay the costs? It can't be, in my submission. And so we make these points in order. Firstly, we're entitled to our costs, including the cost of due counsel. It's a
Can I ask you, before I forget, what do you say about the wasted costs of the 25th of municipal aid?
I think, in fairness, I think it was agreed, I'm not sure it was agreed actually. At one point it was suggested that those be costs in the courts, and I think the appropriate thing would be that they be costs in the courts. But, let me say, I do not press for a special costs order in respect of those proceedings, because those days, one way or another, were a mess, and to try and unscramble that deck at this point is going to be impossible. So my submission is that the appropriate costs award for those days, the wasted costs, would be that the public protector must pay those costs on an ordinary scale, in respect of your client. In respect of my client. But in respect of these proceedings, brought after and persisted with after the rescission order was dismissing the rescission application, these should, firstly, we're entitled to them. Secondly, whatever scale you do, they should be paid personally by the public protector. Not 15%, all of them. Thirdly, they should be punitive, because this is abusive litigation. And then fourthly, and I can't cite your authority for that, and that's why I tell you, fourthly, it seems to us that this is a case where the court would appropriately want to ask, is it appropriate for the public protector's legal team to be paid by public funds?
Mr. Bernard, and just for your edification, your opponent, Mr. Mkhwebane, has described by way of gestures that you are now asking for the sue not to be tied around his neck.
My Lord, we asked for this in our heads. They've elected not to deal with it. I've got lots of matters from the back, but let me be clear on what I'm saying. I'm not making a joking submission, and I'm not making it for purposes of theatre. I'm making a point that for public funds to be used to bring an utterly hopeless application, utterly hopeless, where the only potential beneficiary of the litigation is Advocate Mkhwebane herself, not her office. I am making the submission that that is an improper use of public funds. And I am asking this court to direct that the legal fees incurred by Advocate Mkhwebane should be paid by her, not by the office. Now, let me again say in fairness, if you ask me to point you to authority for that, I cannot point you to authority because the issue has not been squarely considered. The case which considers it...
And it's a question of our discretion, but I want to ask you just... The litigation started in March.
Yes.
This litigation?
Yes.
Started with the issuing of papers.
Yes.
Then there was the pause, 26th of April, I think it was. Then came the 6th of May.
Yes.
Things changed dramatically there, you say. And I just want to understand your submissions. So up to there, she might have thought that she had a chance. And in the event that it's on a normal scale personally, you can live with it.
Yes.
But after that, after the Constitutional Court that ruled on the 6th of May, from there onwards, up to today, she knew, she should have known, you argued, she had no chance.
Absolutely.
You called it a hopeless, hopeless application. And whatever costs incurred by her, she has to foot the bill.
Exactly.
And for the state institutions, that being the National Assembly, and that there was 2 respondents but 1 team, the presidency, yourself, that must be an affirmative step.
It's exactly like it. And let me say, thank you very much for putting it that way, Justice Erasmus, it's helpful, but let me say this. Let's just think what a bona fide litigant would have done. The bona fide litigant, assume that the public protector was bona fide in launching the application prior to the 6th of May. I have my misgivings, but let me make that assumption in her favour. She launches an application which is twofold. I want to interdict the National Assembly, pending rescission, rescission 1, and I want to interdict the President because of the conflict. That's the double-barreled approach. That bona fide litigant then gets an order from the Con Court dismissing rescission 1. What does that bona fide litigant do? At the least, the bona fide litigant writes to the parties and say, look, okay, I lost, rescission 1 is done, I'm withdrawing the application against the Parliament. I don't intend your costs because it was reasonable at the time, but I'm withdrawing the application against Parliament and I only proceed against the President. If we were there, I would not be asking for punitive costs because there would at least be some demonstration of bona fide intention. We have the opposite. We have the double-barreled application. 6th May comes, the Con Court dismisses it. Not only is it persisted in, but a fresh application, an entirely abusive application, is brought in the Con Court. And now we are told, I'm told by my colleague, now there's going to be an amendment to seek interim relief pending rescission 2, in light of Mr. Brayton's submission. That is abusive, and it is vexatious.
I wanted to deal with your approach to that application that might come from the bar, or papers filed later, whilst you're on your feet.
Certainly.
And your colleagues can each file a note by tomorrow afternoon, close of business, in relation to the application, the Rule 28, I take it. It's going to be a Rule 28 application.
Let me deal with it immediately. We are not going to oppose the amendment. We say that the amendment doesn't help them because their case is hopeless on the facts as pleaded. But provided that what is happening here is simply an amendment of the notice of motion, we don't oppose the amendment of the notice of motion. Quite frankly, the last thing we want is for the public protector to now say, well, I have some other cause of action which I'm going to bring in front of some other full bench next week.
In other words, it's if you look at the notice of motion, it will be paragraph 2.
I presume so.
And that will be restyled to make provision for the application filed, the rescission application filed on the 10th or the 11th of May, effectively.
Yes.
Am I right, Mr. Mpofu? Am I reading your mind correctly?
You are indeed, my lord.
Just so that before we excuse Mr. Badlinder, then we know we've got his submissions on that. And Mr. Badlinder, we've argued the case so far.
Yes.
And your colleagues are listening. On the basis that it has been filed and everybody actually made submissions that what they feel about it. So instead of dragging the matter out because of applications for amendments, they can make written submissions and we can deal.
Yes, no, that's absolutely so. And let me say, certainly we have no issue with those affidavits going in, but on the amendment, let me state my view unequivocally. If that is the proposed amendment, as my learned friend has just articulated, we do not oppose it. We say it doesn't help.
In other words, without affidavits,
yes.
They just note whether they want,
exactly.
Whether they are in opposition to it, and then we can deal with it.
Yes, but let me make then the point that I was making, Justice Erasmus, because what it demonstrates is it demonstrates the vexatious nature of this litigation. Because what the public protector wants at all costs, on any basis and on any argument that can be dreamt up on the spur of the moment, is an interdict, an interim interdict. And so it was initially an interim interdict pending rescission 1, but when rescission 1 disappeared, came rescission 2. Now it's an interim interdict pending rescission 2. Before that, it was an interim interdict pending the challenge to the rules. It is, and I say it again, it is an application which has as its design delay at any cost and on the basis of any conceivable or inconceivable legal argument or conspiracy theory.
Now, is that not a good reason for the court then to allow such an amendment? Because one knows if you go strictly according to the application of the law and the rules, and you say that this is how you plead it,
yes,
this case is no longer applicable,
yes,
therefore there is the door,
yes,
it's open to any litigant then to take the steps from there down to room 1 and file a new application.
That is precisely,
because you haven't dealt with the merit.
That's precisely my concern, and that is precisely why my client has decided to adopt the approach. And I saw Justice Delamo smile, but it's precisely my concern that if we don't do this, there will be another application in room 1 tomorrow, and there will be another full bench in front of 3 more judges next week. And that is not in anybody's interest.
Why are we talking about filing new applications? This case was argued before us on the basis that the interdict is sought pending the finalization of Part B and the rescission application brought under case number 257-851. That's the rescission 1. I'm raising this in relation to the issue of cost insofar as the meritless rescission 2.
Yes.
According to you. So when we decide the issue of cost,
yes,
should we look at it as it is here and not be concerned that there is a rescission 2 in the pipeline? Because on this it's not ours.
With respect,
no.
My learned friend made repeated reference to rescission 2 yesterday.
But the prayer and the relief he seeks is with relation to prayer to rescission 1.
But that makes his case, Justice Delamo, even more untenable and even more hopeless.
Yes.
So
I'm saying,
yes,
if we have to restrict ourselves, ourselves to what he was here to argue.
Yes.
Well, he may seek to amend now and introduce rescission 2. And if that is done, then we can look at the cost, including what you say is a meritless rescission 2.
Indeed. Can I deal with the 2 ways of thinking about it? One is to think away rescission 2.
Yeah.
And one says you're only looking at the relief that's pleaded. Well, in that event, it's hopeless because it's relief pending an application that's already been dismissed. So it's hopeless, vexatious, punitive costs, personal costs. The other scenario is you read rescission 2 into it, as it was argued and as it's now going to be amended. Well, then it's pending a hopeless application to the Concord. hopeless, vexatious, punitive, and personal costs. So you can take either route. The conclusion in my submission is the same.
Well,
But you say
to borrow an expression from your colleague this morning, you were saying that as a case where he goes upstream without a paddle. So what you're saying now is by introducing decision 2,
downstream without a paddle.
And in the direction of a waterfall.
Yes, I've never been very good at rivers and paddles, so I'll bow to your knowledge, but yes.
So you're saying at worst case for your clients, at the worst case for them regarding costs, you are saying that costs must be granted for your clients from at least the 6th of May.
No, I'm saying costs must be granted in my client's favour from the launch of this application.
Yes, but
including the cost of 2 counsel.
But you're saying your claim for costs on behalf of your client is unassailable.
Yes.
Immediately once the Constitutional Court rescinded that application.
Exactly. My claim for punitive and personal costs is unassailable from the 6th of May. Exactly. So one way of doing it would be to award my client its costs from the date of the launch of the application, including the cost of 2 counsel. But from the 6th of May, the costs should be paid on a personal basis and a punitive scale. And with effect from the 6th of May, it should be directed that Advocate Mkhwebane is personally liable for her own legal costs rather than the Office of the Public Protector. And that would, with respect, be an appropriate balance of the different considerations.
Yes.
Thank you very much, Justices. I appreciate the additional few minutes.
Certainly. Mr. Mpofu, I don't know, Warren, do we know whether those microphones section works? I was going to move to the platform.
Might I be excused to come to the chambers?
Certainly. I think what we'll do is it's 10 to 5. Maybe we should take a short break. Just to stretch. I'm reminded that it's only 1:45, and I'm looking at the screen over there. You want to go? Let's make it 15 minutes. Let's freshen up. Mr. Mpofu, it will also give him an opportunity to, I don't know whether he now keeps chambers in Cape Town.
The flight's to catch.
What time is your flight? Oh, all right, let's take 5 minutes.
It needs more than an hour to get to the airport.
Does it take?
More than an hour to get to the airport.
Mr. Mpofu,
I'm sure Mr. Baglan would like me to leave right now.
No, I'm here overnight.
Mr. Mpofu, of course, that's an incentive for you. That's short.
Yeah.
That's exactly what I'm saying. I don't need you to remind me. That's why I'm making that. I'm making that point.
We just want to stretch and go outside.
5 minutes.
5 minutes, and then we'll come back on our own because all of you are going to be except for Mr. Butler. So unless if you want to sit in and enjoy your company. Seeing that you've appeared in matters together a number of times over the years.
No, I think it's better if you could think it'll ask personal costs against me.
So you have already directly asked for personal costs against you.
So we'll take a short adjournment for about 5 minutes or so. And then we'll come back and we'll conclude. Thank you. The court will adjourn shortly. and the one that's cynical. And it's clear that on your argument, he falls into that category.
Clearly, well, it's not a category. Actually, they are in a category of their own. They are the complainant. It's like if someone stabs someone, the one who is being stabbed is the complainant. They can also be neutral, but themselves it's them. But anyway,
thank you for it.
Yes, thank you. So, okay. What is the purpose of Section 193A? Because we've heard all sorts of things now about the start of the proceedings, and it would be absurd if the start of the proceedings happens at a particular stage, and so on and so on. Or if it was motion proceedings, then it would never start. That means the drafters of the Constitution must have been out of their minds to put such a thing, because you can never determine the start of the proceedings. So they were smoking something. No. The purpose of this is to protect a person who holds a very important office in the democracy. A person about whom the highest court in this land has said this person is susceptible, is the biblical David against the Goliath. In this particular case, 3 or 4 Goliaths or more out there. That person who's the David against the Goliath, whose unfortunate and unenviable task is to investigate those Goliaths and sometimes put them out of work or out of their careers, is a person who must be protected constitutionally. That is what the mothers and fathers of the Constitution sought to do in giving the protections in Section 194(3)(a) and determining at what particular stage they may be suspended. All right?
In fact, it goes further than that. It's one, providing for the independence.
Yes.
And then for the protection of being bullied.
Yes.
So the stages leading up to 194(3) is also important, because you can't, just because somebody had laid a complaint, act against either whether it's a member of the judiciary or the public protector or another head of Chapter 9 institution.
Yes.
And I understand what you're saying. Therefore, one has to be very careful in interpreting these provisions, not to undermine the purpose.
Yes, but that is what courts are enjoined to do, in this country at least. When you're interpreting a legal instrument, you search, as you currently do now in this discussion, Justice Erasmus, for the purpose. That's the starting thing. You search for the purpose, context, and it must be business-like. We have, I don't have to quote authorities for that to this court. It is once you have established that purpose that you can embark properly on the interpretational exercise. Otherwise, it's just a road to nowhere. You're just looking at words and commas, and then you can go until the cows come home. What is the purpose of this instrument that I'm interpreting? Then we all know. Then that's number one. Number two, Rule 39(2) of the Constitution tells us how we should conduct interpretations. It says we must do so by taking into account
Section
So section 39, sorry. When interpreted any legislation and when developed in the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. That Bill of Rights, among other things, we know from Makwanyane that one of the most important rights, second only to the right to life, is the right to dignity, is the right to self-worth, is all those things that I spoke about yesterday. So you have a double protection, you have actually a triple protection, if you like, Justice Erasmus. One, it is the protection that comes from Section 10 of the Constitution about dignity that we all have. It doesn't matter whether you're a king or a public protector or whatever. That we all, it inheres in all of us as human beings, simply because we're human. Okay?
Because you also have to read Section 39 with Section 1.
Yes.
And 1A puts human dignity right up there.
Right up there.
As the foundational
Yes.
values of
and more importantly, for the purposes of this court, 1C, which is the supremacy of the Constitution and the rule of law. That little forgotten thing nobody has mentioned today. The rule of law simply really says our courts are the custodians. Justice Mkhwebane puts it in Ganka 1 very well when he distinguishes, I remember the paragraph, between
go. Check the other one, the computer has the camera on that one. That's, oh, there we go. We're back on listening profile.
Yes. So, against, I'll come back to this purposive exercise. But the backdrop is what was said in or EFF 1, where paragraph 66, the Justice Mkhwebane says, and the, or rather the court, and the fact that her investigative, and that's important because we're talking about the investigations that she's doing against the president, for example. The fact that her investigative and remedial powers, so for now let's forget the remedial powers, it's concentrated on the investigative powers. Target even those in the throne room of the executive raw power is just as revealing. In other words, her powers include powers to investigate the president, all of us in South Africa. It's a public protector. The only, she can even investigate judges for that matter. The only limitation which is placed thankfully by the Constitution and also by the Public Protector Act is that she may not investigate judicial decisions. So for example, I can't go and say, I'm not happy with Justice Erasmus's judgment, Public Protector investigate this, and we know the reason for that. That's a constitutional protection. But other than that, she can investigate corruption by anybody. So that's what Justice Mkhwebane was talking about, the investigating powers which can go to the, what she called, the throne room of the executive raw power. That the Constitution requires the public protector to be effective and identifies the need for her to be assisted and protected to create a climate conducive to independence, impartiality, dignity, and effectiveness. Shows how potentially intrusive her investigative powers, again. So raw power, investigative power, whether it's about Zimbabwe, whether it's about Mervyn Dex, whether it's about that, but those powers she has are intrusive to these Goliaths. Right? Shows how potentially intrusive her investigative powers are and how deep the remedial powers are expected to be. the obligation to assist and protect the public protector so as to ensure her dignity and effectiveness is relevant for the enforcement of her remedial action. The public protector would arguably have no dignity and be ineffective if her directives could be ignored. Now, what am I saying? I'm saying that there is a constitutional imperative, and where you and I were, Justice Erasmus was, there's the dignity in Section 10, protection for her dignity. There's the injunction on all organs of state, including the court for that matter, because the judiciary is an organ of state in that context. And the president and the parliament, everyone, all organs of state have a duty, legal obligation to protect her and ensure her effectiveness. Right? Now, against that backdrop, we then have to, let me make this thing easy, because really, to now say, no, well, what would be the point of only, what Mr. Padlander was saying here, what would be the point of only suspending her once a witness is called or whatever? Like, it's too late. No. The reason that people like the public protector and judges are protected, and you are bound by that analysis, I'm afraid, because the Constitutional Court in the judgment, the Constitutional Court in this matter, specifically said there should be no distinction in the fairness regime that is granted to judges and even the president, right? That's said specifically by the Constitutional Court. So let's look at this again, and I'm hoping that I'm going to try and do this quickly so as to drive the point in the context of what one might call comparative interpretation, the style of comparative interpretation that was done by the Constitutional Court. Let's look again at, if you accept that as a premise, let's look again at Section 177, which deals with the impeachment of charges. And anyone who knows anything about how that works would, I mean, all these alarmist things would be said. How can a judge, Mr. Padlander was telling us, a judge can shoot people or whatever. So how can that same person be expected to sit? It is because the Constitution is not concerned about individual cases. The Constitution is a document that looks for 1,000 years from now, when we are all gone, when there are different public protectors, not one who is universally hated by all these people. We need to understand that those persons, that person must be protected. So here's the thing, Justice Erasmus. Go to 177.3. And I made this point yesterday, but I want to make it from a different angle now. 177.3 says, and in fact, this is the point I was making. Judges, for obvious reasons, have even bigger protection. But that's because the Constitution, once again, wants to protect their independence and effectiveness and so on and so on. Because all sorts of, imagine if every litigant who's unhappy were to just put a complaint and then charges must be suspended because it will be too late or they will interfere with witnesses or whatever. Then we would have no charges left because I'm sure every day there's some aggrieved litigant. So the Constitution then sought to protect them, rightfully so. Not to protect the one that Mr. Padlander is talking about, who goes around shooting people in the taxi rank. But if to protect the judiciary, we have to protect that one as well. So must we. Because the Constitution is not about targeting the hated person. It's about thinking, using your head to think that in 500 years' time, there might be a situation where the holders of the raw chambers of power just don't want to be scrutinized. about a trip to Zimbabwe or about anything else, and therefore they will use or abuse their power. That's the thing. That's why judges, if you read this section properly, you'll actually see that the judge's protection is even higher than that of the public protector. And for a good reason, as I say. Why? Why do I say that? I explained this yesterday. It says, the President, on the advice of the Judicial Service Commission, may suspend a judge who is the subject of a procedure in terms of subsection 1. So let's go to subsection 1. The judge may be removed from office only if the JSC finds that the judge suffers from an incapacity, is grossly incompetent or guilty of misconduct. The National Assembly calls for that judge to be removed and so on. Forget about that because that's a second stage. So in reality, what does it mean? When can a judge be suspended? Only when the Judicial Service Commission finds, right? Not when it starts the process, not when it calls witnesses. So you can have witnesses up and down, but the judge will still be in office. Why? Because the founders of the Constitution wanted to protect those types of people. So you cannot, the JC, I explained it yesterday, that finding can only be done, actually it's beyond even what I was describing yesterday.
Are you correct, Mr. Mpofu? Look at 177.3.
Yes, that's the one I just read.
On the advice of the Judicial Service Commission, it doesn't say after the Judicial Service Commission has made the finding. The finding is the removal from office. But 177.3 says the President, on the advice of the Judicial Service Commission, may suspend a judge who is the subject of a procedure under subsection 1. So that procedure under subsection 1 can still be ongoing and not finalized.
Okay, no.
That is definitely, I can give you, I don't want to mention the judge's name, but I can give you an example of that, how that happened. There was there's a procedure that has not yet taken place, and the President has suspended that judge.
No.
Well,
no. The President cannot suspend judges. Anyway,
we don't have to go into the detail of the process.
No.
Because you and
I'm making a different point. Yeah.
You and I know, because both of us in different capacities that actually sat in those issues, and so it's a three-step process, and often before the third step is completed, then the recommendation is made that you may suspend. But it comes from the JSC.
That's the point that
Justice advises the President.
Absolutely. That's the point that is being missed. It's a very simple point. All I'm saying is that advice of the JSC comes at a particular stage. It can never come before the JCT finding, which is stage 2 in your proposal. And I'm making a very simple point that at that stage, that process which precedes that suspension can take years, as we all know, on its own right, until such time. The JSC can't just wake up and say, simply because there's a complaint, for example, that they're going to. But I don't. Yeah.
Of course, the point I understand your point that there's a particular protection built into the Constitution, whether it be for judges, Chapter 9 institutions that include the public protector. The judge's protection goes even further because it starts with your tenure, where the public protector is as a non-renewable term of 7 years. Judges at our level get appointed for life, and then you can only be discharged from duty in compliance with the Remuneration Act, etc. And then, of course, there's a further protection insofar as it relates to judges. Our salaries can never be reduced because you need the judiciary to be independent and protected. There must be a process so that you don't have frivolous attacks that might impact on their independence, nor can they then be bullied. I used the word bullied earlier on, so that into succumbing to
Justice Erasmus, I will not.
So you don't have to take it further.
No, absolutely not. The only thing really I can say is simply to say, hopefully, that it must be self-evident that whether we're talking about the public protector or the or judges, to a different extent for obvious reasons themselves, that the purpose is the same, which is to protect those persons. And so what might look bizarre to the naked eye as to, but why don't we just lynch them and take them to the gallows straight, is something that would backfire if we were to be so gung-ho and want to draw the gun at the slightest provocation.
So, where the public protector and the auditor general, as is common with the judges, is that for other heads of Chapter 9 institutions, you can have a simple majority.
Yes.
Whereas with us, the public protector and the auditor general, you need a 2/3 majority.
Yes. Thank you. That was my next point to close this. You preempted me. I think I'm going to finish early.
So sorry, I just want to know your position, your argument, your submission is saying, when do you say the president, when is the trigger, do you say, for the president to have written a letter, even a caution letter, to the public protector? When do you say is the trigger for that to happen?
Well, it's like, I answered that yesterday. It's the, if you take the word after literally, as I don't know, I said that was my first answer. But the second answer is on current information, let's say it's on the 12th of July.
When those proceedings start?
Yes. Okay. On current information. And I say that advisedly because, as Justice Erasmus pointed out, it's been a moving target for various reasons. Some, it's not what Mr. Badlander was saying, unless, of course, according to Mr. Badlander, the public protector must even be blamed for COVID-19 and everything else. But the honest, in seriousness, the barring a catastrophe, Justice Bill,
so you say the trigger date is 12 July 2020?
Yes, and I'm using that notion just to illustrate the after.
That's to work with the current program.
Yes,
that was this last meeting.
Yes, and that, by the way, is subject to all sorts of things. It's whether the Audi, the so-called Audi 1, whether it's legitimate, whether the 30 days is sufficient, and so on and so on.
There's still a debate on how to calculate that.
And how to calculate that, yeah. But all things being equal, Justice Villiers, I would say the 12th of July. Now, but please allow me just to round off this point because I want to move on. But just letting back to what Justice Erasmus pointed out. If you don't believe me that the purpose of 194.3a is a protective one, then you must at least consider what Justice Erasmus has just said, which is that the founders of the Constitution deliberately, why else would they have said, for all the other Chapter 9 heads of Chapter 9 institution, you need a simple majority in Parliament. But for the public protector and the auditor general, you needed 2/3. Why? There can't be any other reason except to protect those offices from the kinds of things that Justice Mkhwebane was speaking about. Right. Now, the reason for that is because at paragraph 52 of the entitled EFF1 judgment says, and that is the public protector. She is the embodiment of the biblical David that the public is, who fights the most powerful and well-resourced Goliath, and impropriety and corruption by government officials are the The public protector is one of the true crusaders and champions of anti-corruption and clean governance. Hers are indeed very wide powers that leave no lever of government power above scrutiny, coincidental embarrassment, and censure. Right? Pause there. Leaves no level of government from coincidental embarrassment and power. So these are things that any human being that cannot feel nice or feel well about being subjected to that. But then that is what must be protected from. Then it says her investigative powers again. I'm reading at 55. I'm not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. The predicament though is that mere allegations. This is the important part. Okay.
That's stated in itself.
Yes. Mr. Butler says ridiculous the idea that mere investigation, which is really the point, a mere investigation triggers the possibility of a conflict of interest. Mere investigation, right? Not, that's why we were asking for the removal of all that material, because that material that we say is offensive. And by the way, we don't even pursue that application, because we might need that material later. But and my learned colleagues, at least one or two of them said they would oppose it, so I don't want to.
The Rule 28.
Yeah, the Rule 28 we definitely want. I'm saying the Rule 615.
The Rule 615.
Yeah. And let me explain, but having said we're not pursuing it, but let me just explain where we came from, Justice Erasmus, in the context of what I'm discussing now. It was because the president went, as we said in our papers, chapter and verse about this one went to Zimbabwe and all. It doesn't matter. It doesn't matter what whether there's a good case or a bad case or whatever in particular about a particular investigation. The fact we've made it clear, we are saying A, there are ongoing investigation, common cause. B, those investigations involve serious impeachable offences if proven against the president, common cause. All of them, all four of them. If it can be shown that the president, can pick anyone you like. If it can be shown that the president knowingly allowed members of his political party to board Air Force One to go to a meeting with ZANU PF or whatever they were doing, then it's something that I have no doubt would be raised as an impeachable offense. If it can be shown that the president conspired in some judicial capture, I'm sure it would be an impeachable offense. If it can be shown that he knew that there were public funds that were used, the Mervyn Dex thing, but said nothing about it, I'm sure it would be impeached. That's all we need to show, that there are investigations which are in jeopardy, and that's why I said to Justice Erasmus yesterday, let's not waste time about this Busasa story. Assume for a minute that we are wrong on Busasa, that the sealing of documents perpetuates the thing. Assume we are wrong. The three investigations on their own, ongoing investigations, are far worse in terms of the threat or what is called the potential embarrassment or worse to the president than any ongoing litigation could ever be. So, and that's the substance. We mustn't look at the litigation stopped on the 12th. Therefore, on the 13th, the conflict evaporated, as we say. It's not. That's something of that simplicity. And therefore, what we are really about here is the protection of the public protector. Now, If we accept that, then, and again, this is another misunderstood argument. I was saying, on top of that, then we must also look at what the law tells us to do when we are dealing with a punitive piece of instrument, right? Now, I don't want to get into this debate about whether a suspension is punitive or not, because it's a waste of time.
No, you made your submissions.
I've made my submission, I stand by them, but let's assume again, for some reason that I cannot even fathom, that I'm wrong about that. What cannot be denied is that Section 194 itself, forget about 3A now, is a punitive statute. That was said by the Constitutional Court twice. It was said in paragraph 138 of the impeachment judgment, and it was said by Justice Mkhwebane, if you remember when she talks about the legal representation. She says the consequences are grave, no less than that. That's in paragraph 44 of the current judgment. The consequences, although not prescribed by the Constitution, for the removal of a Chapter 9 institution office bearer, especially a head of a Chapter 9 institution, are grave. And we're told that that's just. So, the 138 of the other one says that 89 is punitive. So, you now, apart from the protective purpose, you now have another double protection to make sure that you, because it's a penal statute, you don't interpret it like any other statute. Because why? It intrudes on the rights of individuals. So this puts paid to this other notion that somehow we must forget that there's a human being here and say that no, it's a person, it's the office that's going to be suspended or something like that. That is against the spirit of what the Constitutional Court said in the Nkandla case. Because when it says, hers are indeed very wide powers, and she is the embodiment of the biblical David. She, not it. Not the office of some inanimate thing that has no feelings. So and it says the Constitutional Court linked directly. This is why the Nkandla finding was made, that the dignity that is referred to in section 1813 is her dignity, not some dignity of an office, whatever that means. Because there's no such thing. So the dignity is just as we have to protect the dignity of judges. And we all know that that literally means the dignity of the judicial. But that is done by people with breath and human beings with flesh and blood. You can't say, oh, well, I can just undermine you, Justice Erasmus. But my defense would be that, no, I was not undermining the judicial, I was just undermining you, or vice versa. What is that?
Well, that discussion you had in the taxi last night on the way to the hotel.
Yes, or when I left here.
Or on this evening on the plane back to Germany.
Yes, but
then I'm sure our dignity will be impugned.
will be impugned. Thank you, Justice. But I mean, really, I don't, as I say, excuse the pun, that doesn't even need to be dignified with. And so she says, for example, in pleadings, she says, I accept the importance of accountability, but this must be done lawfully to protect the dignity, not just of me, but of the other Chapter 9 institutions, or other heads of institutions as well. That's paragraph, page 19, paragraph 42. I must emphasize the fact that I'm ready and willing to assist the National Assembly and to protect the image and integrity of the office of the public protector. However, fairness and justice have to be the golden thread that runs through the Section 194 proceedings, not only for the incumbent public protector, but for all current and future holders of the office of Chapter 9 institutions. That must never be forgotten. Because if we're going to be overzealous about lynching this particular one, then the consequences are going to be further than grave. Now, having said all that, some of the protections, I just want to, Mr. Masuku has asked me just to touch on one or two things, and I'll also touch on one extra thing regarding the Rule 89 grant. You remember that we also raised it, but I obviously didn't argue because I knew Mr. Masuku was going to cover it. But I just want to remind the court another important constitutional fact. Section 50, Mr. Masuku made a very important point yesterday, which is that none of these parties who are saying, oh, well, you don't have to worry about Rule 89. None of them have attacked the constitutionality of Rule 89. Because they would have to say, no, this rule is too, what do you call it, lenient. We will put it that way. It's too lenient. Maybe we need the Canadian one or the British one or whatever. Ours is too lenient because it's unqualified. It simply says you can't. It's a complete bar. That's another argument for another court case. For now, we must accept that the rule, unqualified as it is what we have. Now, here's the most important thing, Judge Erasmus and my lords. To show how intact Rule 89 remains. Remember when they were promulgating these rules, they did something quite brilliant. They said, look, Rule 88 says that we may not talk about we may not impugn the integrity of somebody in Parliament. But now that will mean these rules will be sterile. Because every time we open our mouth, someone is going to say, Rule 88. So they said, at the end of those rules, as you know, they said, ipso facto, we are also amending Rule 88. Brilliant. So that it will allow us to do our work. But they did not do that to Rule 89. That failure to change Rule 89 must have been deliberate, because they knew that Rule 89 would also do all these scary things that we were scared about today, if Rule 89 is properly applied. But they did it. So Rule 89 is Rule 89. If it's wrong, someone else must challenge it, but for now it must be applied. What is more, this is the last point on this purposive analysis. Why do we have Rule 89? One of the reasons, my lord, is that members of Parliament, unlike you and I, well, not you and I, unlike you and me and the others, because I'm sure you judges also have the same protection, but members of Parliament, in terms of Section 58 of the Constitution, Section 58 of the Constitution protects members of Parliament from criminal liability and civil liability for anything they do in Parliament. Okay. Now, that is, I mean, that's actually extraordinary. Even when it works in my favor, I usually find it very extraordinary. That actually a member of Parliament can basically go to Parliament and say anything about me, anything false, obviously false, but there's nothing I can do. They can, defame or whatever, and say all sorts of criminal things, but there is zero can do them, what you call total immunity. So one of the prices to pay for that, because nothing is free in life, one of the prices to pay for that total immunity is Rule 89. Is the fact that you may not then impugn the dignity of the courts, thinking that, oh, I've got total immunity. Therefore, I can comment about pending litigation because there's nothing, nobody can do anything to me. So Rule 89 was put to make sure that there is a limitation. So it's there for a good reason. That's why they don't want to amend it. And therefore, this idea that, oh, please, if I forget any point, this one I may not forget. Where is the abrogation or violation of Rule 89 there? You know, sometimes we take things so literally. People think that when you say you may not reflect on pending litigation, that simply means moving your lips. No. Remember, one of the pending litigation issues is the fact that the Bathman court found that a judge should not participate in the panel. The implication of that would be that the committee itself should not even exist yet, if that is correct. As we all know, it would, as Mr. Tsinodi said, it would take us back to that stage. So that committee, it doesn't have to say anything. Every time it opens its mouth or it just sits. The mere fact of convening a meeting is undermining the outcome that might come from the pending litigation.
On rescission too.
Yeah, on both. In other words, I'm making a broad point. I'm saying, for now, let's assume there is pending litigation. I know there's a debate with that. Let's say there's pending litigation of whatever nature. I'm saying the minute it is possible that the mere sitting of the committee preempts, before they even say let's open with a prayer, that preempts the outcome of because that court might say, no, let's go back to the independent stage because Justice Kabinde was wrongly. So that's what we're asking you to do. Please stop these people, because every day they're doing something else. And every time they do the next step, they are preempting the mere fact that we might have to go back to base 1, base 2, or whatever, depending on the 17th step. Okay. That's crucial. And we might say, oh, that's not fair, we don't have accountability, what have you. But that is the law. It says they are prohibited strictly, as Mr. Mansuku said, from doing anything. Now, what is worse is, I don't know if your lordships have had an opportunity to go to those video links that Mr. Janti. I beg you to go to the last one of the last meeting of the 11th of May, just as an example.
I've seen it.
Yes.
That's the one there where the first speaker was Mr. Olomisa, was sitting.
Absolutely. You've seen it. Now, let me give you highlights from that one. Number one, Mr. Olomisa made his remarks. Mr. Janji, fortunately, helped our case. He said, oh, before we start, let me tell you, this is not yet the merits. This is just a logistics meeting. Very good. So we've quoted that in our Rule 65B application. So he clearly makes it clear that these are not the proceedings yet. And I know why, because he's thinking about, otherwise we would have to call the lawyer. The point we were making is that it's just around. Because these people, and then, so that's what justice, that is what justice, just...
You can call him general.
General, yes, he's my client in another context here. That's what he said. And then Mr. Janti said that. And then everybody, you know why they took that decision? Ms. Dakude in particular stood up and said, no, That whole thing about the SMS and Mr. Abraham Chief has got nothing.
No, the legal advisor said they don't want to get involved.
No, those ones, I give them stars like Mr. Timothy. I'm talking about the members. In any event, Rule 89 doesn't apply to the legal advisors. They said, Mr. Kabude of the ANC said, no, we've seen this thing about the Abraham G story and so on. It has nothing to do with us. And then there was a chorus of DA and ANC people saying the same thing. And that's how the so-called decision was taken. But saying that, when that matter is now in what you refer to as Rescission 2, Justice Rasmus, just making that statement is reflecting on an ongoing and pending matter. You also remember I can't remember his name, from the DA.
Scriber.
Yes, the one who said, oh no, now we'll have a rescission there. We'll have a rescission.
That's the only name I remember that I saw.
Yes, in fact, you were 100% right. He said, no, we'll have a rescission and then we'll have another rescission. So that is reflecting on ongoing pending litigation. And when Mr. Janji, who's supposed to be the Rule 89 police, according to him, says, when he summarizes, he says, no, the other litigation doesn't involve us and so on. So it was just a criminal activity going on there. So, and that's what we're asking you to stop. Please stop these people from doing more and more illegality. Because contrary to what Mr. Badlander says, that actually is the right thing to do. Rather than, we could say, let them do it. One day we'll go to court and they will see. But no, we are coming to a court of law to say this thing must be done legally, which actually goes to a very important point that you raised, Justice Erasmus, about Section 237. That's why the Public Protector says, by all means, let's do it, and let's do it properly and diligently and so on and so on. But for God's sake, let's do it legally. That's all she's asking for. Let us do it lawfully. Let's not in the process because we want to do it. Actually, it's not diligence to just serially break the law. So the Section 237 is pregnant with that requirement. If you read Section 237, it says all constitutional obligations must be performed diligently and without delay. So,
okay,
nobody.
I will mute himself. I think it's.
So, okay, yeah, thank you. So, nobody in their right mind would quibble when I say Justice Erasmus. In Section 237, we must insert the following words. It says all constitutional obligations must be performed diligently, lawfully, and without delay. It's obvious, because the diligence to illegality is not diligence. So that's really what we are all about.
Well, the principle of legality strikes right through.
Absolutely, it permeates everything. That's why it's in Section 1, exactly. And I was making the point earlier that Justice Mkhwebane in the Ngango judgment, I'm just rushing through, says something very important about the distinction, the bogeyman of separation of powers. It says, of course, as the court, we cannot prescribe how Parliament must do whatever. But he says, brilliant, but it's our duty to check whether. That's the word. Not how, whether. That's all we're here. We're here to say to the court, you must determine whether all these things that we're pointing out are consistent with the Constitution or not. That's it. 172(1)A. Very simple. If they are not, as we argued that they are not, then 172(1)B kicks in, where you must give remedies. And those remedies are limitless, quite frankly. You can give any, whether it's a mandamus or whatever, you can give it under certain 172(1)B, because it's a wide discretion. The only trigger is the finding in 172(1)(a) that such conduct, it sounds simple, but it actually is the key to everything. When deciding a constitutional matter within its power, everyone accepts that this is a constitutional matter within the court's power. The court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its consistency. Simple. There's no one else who has that power except the court. And then after that, the court may make any order that is just and equitable, including, so the width of that provision is symbolized by two things: any order, and then they even say including, just to make sure that you don't even confine it to just those things that are said. Order limiting the retrospective effect and so on, and order suspending the declaration of invalidity, and whatever, a mandamus, interim suspension, whatever, structural order, or whatever the court for that particular case seems to. And that's why in our, and maybe sometimes you have to spell these things out. On page, in our notice of motion, maybe next time we should be more explicit.
The media is going to be an extra. In life there will be, I mean, even in another case. Because sometimes we assume, look at, everyone has been going on about this notice of motion. Nobody remarks about 1.8. It was mentioned by you yesterday.
Yes.
I think everybody accepts that that is an alternative. It's like...
No, it's not that. Sorry, that one was about 2. No, I'm just saying 1.8. That debate I was having with Justice Tulong was about 2.
Yeah. No, but the 1.8 gives us the just and equitable relief.
Yes. In terms of section
38 and 172.
Exactly. That's important. That's the most neglected part of this case, which is so important.
And that is pulled through to the alternate to prayer 1.
Yes. Yes, that's fair alternative, if you like. Yes.
And then
that's correct. Yes.
2 part.
Yes. But for now, I'm just addressing prayer 1.8. Very important. Section 38, remember, is the one that says whenever your rights, any right, whether it's dignity, section 34, all the rights that we're invoking here is invoked, then a court of law must declare no, I think I'm over-emphasizing it. You can get any relief, including a declarator, in terms of section 38, and then 172 we've already discussed. So that's where we are. That's the heartland of constitutional relief, not this element stories we hear here. Right. Now, once we accept that the court has, once and we have to think creatively. So when we ask for interim relief, we're saying, therefore, assume that's what the picking exercise is. Assume that the declarator one day that the president was convicted, just picking anything. Or assume that the declarator that the proceedings had not started. You pick through that. Once you pick through that, then you come back and say, okay, then I'm going to give you interim relief. Because what would be the point of that happening when you're already dead? If you don't go to the gallows. That's why in America there are people who literally sit in the gallows for 20 years. Because it's understood that you can't implement until you've gone through all the steps. Anyway. So that's where we are. Now I just want to also assist the court. You know, in the number 5 of our so-called Big 5 cases was always the Mhlahla judgment. There's something very interesting in that judgment. In fact, what is more interesting is I'm always able to predict my opponent's arguments. But there was stone silence about paragraph 110. I think Ms. Pillay is the only one who ventured there for 2 minutes. Mr. Breitenbach promised in the morning, but he didn't.
It's been dealt with in the heads.
Yes, you know, everyone deals with it in the heads. I'm saying, yeah, I'm talking about here. After all the debate that we had on it, nobody dealt with it. Why? That's just good advocacy. Because when you have a point that is unanswerable, the best thing you must do is just to stay away from it. It's very simple. 110, which is binding upon you, makes it abundantly clear, even to a child of 2, that the proceedings had not started by the 4th of February at least. Because otherwise, it doesn't matter what Mr. Baglamer says, that no, or not misdelay. No, they were pegging it to August when the case was debated. So what? Nothing happened between August and February 4. So that's just like saying nothing. So up until the 4th of February, it's the proceedings in the eyes of the Constitutional Court, the highest court in this land, had not started. Now, what are you faced with? You are faced with the reality, my lord, that the persons, the president,
I'm listening.
Yes, the president, the speaker, Mr. Janji, and the DA. Even on a Plascon Evans basis, cannot establish the contrary. The Justice Erasmus, I'm saying the people who should know better than all of us, who are supposed, whose constitutional task it is to implement these things, should tell us. They must tell you, we can't have 2 days of hearing and nobody of the respondents has told you when did the proceedings start. They duck and dive and give all sorts of when. It can never be that the founders of the Constitution put such an important date, but it's not objectively determinable. It's just whatever you want it to be and inferential. No! If the law says you can only vote when you are 18, then you must know on what date did you turn 18. You can't say, no, but look, I'm taller than this one, therefore obviously. No, the date must be objectively determinable to everyone. But all these people who are standing here, one says it was the 16th of March, as Mr. Butler, when the
resolution was adopted.
Yes, well, it was adopted. The Speaker says it will start. We don't know when. I'm writing you to say it will now start. Whatever will now start means, but at least the word will suggests something in the future. She says that on the 21st. Mr. Janji says no, it was on the 20th when we had our first meeting. So all of them have said different. When did the thing start so that we can get to this constitutional 194A? We don't know. It's just this and that and conjuncture and balls in the sky and what have you. And that's what we say, that what is clear now, even, and then there is a moving target. We're now told that actually, I don't know, they started on the 22nd when the Audi letter was sent or whatever. But that has 2 problems, Justices. One is that it means then they all concede, at least, that on the 17th of March, when the President wrote that letter, those sittings had not started. That's at least one thing we know. And they also have to concede, even on the new versions that we had this morning, that and this is crucial, sorry I forgot to mention this yesterday, that that's another thing that I think people always miss. There's a law, I just don't have the case, there's a law but it's tight, that when the Constitution, or rather, when a court declares certain conduct invalid in terms of 172(1)A, it's puzzling to law students. It is not saying it is invalid now. Okay? It is saying it was invalid when the Constitution was adopted in 1996. That is the only reason why there's that provision about the prospectivity. Because all things being equal, when you declare something invalid, you are declaring invalid from the day the Constitution was declared. That's why courts then have to have what the Speaker asked for here, and Justice Kaka refused. Because they said, please don't just give us if you have to find against us on this legal representation thing, please make it prospective. They were protecting themselves against this day, but this day has come now. And the Constitutional Court refused. And therefore, if the Constitutional Court refuses, it means the order is retrospective. Now that means literally everything that was done without legal representation in the proceedings that they say started in July, it has been nullified anyway by the order of the Constitutional Court. So it's a debate to nowhere to say was it the 21st or the 28th, because it doesn't matter. If it was before that order, it's nullified ipso facto by law. So the proceedings cannot have started at any point before the 4th of February. If you read what I've just said, the retrospectivity point plus paragraph 110 of the judgment. It's impossible. It's just playing with words. And then Justice, I just want to refer you. Oh yeah, then the other confusion is between process and proceedings. The process, everyone knows the process. In fact, forget even about commencing. The rules themselves say the process was initiated by Ms. Mazzoni or the Speaker. That's not what we're debating here. We're talking about, that's why the Constitution must read it properly. It says after this, not just the start of the proceedings, after the start of the proceedings of
a committee.
Sorry, of a committee, yes.
Strangely enough, it doesn't say before a committee. It says of a committee, not before a committee. That's doesn't use the word before.
100%. Yeah, but the point I'm making is it would cover that as well. It says, may suspend a person from at any time at start of the proceedings of a committee of the National Assembly for the removal of that person. Now,
and that's the committee referred to in 1941B, exactly. Which is the prerequisite before the adoption of the panel report. Yes. In other words, no, not the panel report. Final adoption of the resolution to remove.
100%. So in other words, if we go back to the judge analogy, it's the after the proceedings of the JCT. So the process and the proceedings cannot be confused, really. They can. You can have a debate about what you alluded to this morning, but nobody really answered it, as to whether the inquiry and the proceedings is synonymous in this context. That debate you can have, and I will answer it now. But we can't have a debate about between the process and the proceedings. That's obvious that those are two different things. So the process, when we say please halt the process, we don't mean halt the proceedings. We're talking about the process, whatever you are doing, basically, whether it's stage 1 or step 1, step 16 or whatever. Just stop. Okay. So but to understand that justice, we need to go to the Mkhwebane judgment, and you will find the reference to I think it's 19. It's 19. It's the one you what do you call it? In our language, we call it subtweeting. the Justice Erasmus, or telegraphing, yeah, alluded to this mention when someone was talking about 110 and talked about Rule 9, paragraph 19, but nobody was biting. The reason, I guess, why Justice Erasmus did that is because paragraph 19 actually is the key to what might look like a puzzle to many people, where there's none. This is what Mkhwebane J said. During the inquiry, the office bearer has the right to be heard in his or her defense and to be assisted by a legal practitioner or expert. However, such legal practitioner or expert may not participate in the proceedings of the committee. So it's clear what she was talking about at 110. It's the proceedings, because that's what the legal practitioner is about. Now, and secondly, she clearly uses just in that one sentence, the word inquiry and proceedings interchangeably. In the very same sentence. Yes, it is the same sentence. Starts with during, it ends at.
So you can participate in the inquiry, but not in the proceedings. Yeah, I take it that's in the deliberation and other stuff.
Yes.
Before or after, that's the debate that we have to look at.
We can have, yeah. But the point is that she delivered, the Constitutional Court uses the word inquiry and proceedings in the same breath. So you can't now come and want to be giving us nitpicking definitions.
Well, you only yesterday in an argument spoke about 110.
That's correct.
And that is why I came back this morning.
You did, and no one, I think, so I'm just highlighting that to show that the Constitutional Court knew exactly what it was doing, which was said to the president. Let me put this proposition to show the absurdity of what they are arguing. And I think I raised this with Justice Delamo yesterday. Please understand one thing. They are caught, if you look at 110, they are caught between two stools. There's no way out. Because it is either the proceedings started and they did not invite, they didn't provide the full legal representation, which is wrong. Or, in other words, they are guilty of contempt of court. Or, as 110 clearly shows us, the proceedings had not started, which is why they did not invite us. But then, if that is so, then you can't suspend. There's literally no other alternative. It doesn't matter. You can jump and twist your mind and do whatever, but there is no alternative. There is no alternative theory. It's either one of those two things. If I was them, I would choose the one that is unlikely to send me to jail. I would choose, of those two alternatives, I wouldn't choose the one that says, yes, the proceedings have started, but we told the Constitutional Court to go and jump. We'll do it without the lawyers. Surely that's not what they did. What they did was to recognize that the proceedings have not started, but now they want to wiggle out of it. That's a more palatable outcome. Because if they indeed, when Justice Mkhwebane made it so clear that there must be full legal representation, full. And remember the words that are removed from the excised words. They say, provided that such legal practitioner shall not participate in the committee. Very important. In other words, the Constitutional Court said, what the Constitutional Court found to be unconstitutional is the fact that there is a proviso that says the legal practitioner may not participate in the committee. That means when the committee does anything. So even on the average, even if they said, no, we were just appointing, doing the terms of reference, according to the judgment, the proper interpretation of the judgment, by then they should have had legal representation. Remember, justices, contrary, somebody said something, and I don't think it was deliberate, but something that might be misleading this morning about the independent panel process. The independent panel process, by the way, provides audit, and it provides the participation of lawyers. It's simply that it's not like lawyers in physical attendance. But I know because I participated in it. The 194 process says there must be audit, the public protector must be given the allegations, and then representations must be. So all the audit rights are fulfilled. So how ridiculous would it be if indeed you have the legal rights in the independent panel, then they get withdrawn, and then they get restored at a particular stage, which is what they are doing. That's what the Janchi process with respect is now. It is a suspension of legal representation illegally, because according to them, no, don't worry, we'll give it back to you later when there's a hearing. But what's the meaning of full legal representation? Surely full legal representation means full legal representation. Once it has started in the independent stage, it should simply continue. Of course, it comes in different shapes. It might even be to invite the legal practitioners for particular stages, just like judges would do.
So, after the Constitutional Court, the rule now reads, the committee must afford, because remember that the committee is not in front of you because they're just excised. So under Order 3, before the quotation mark, it must still be the committee because that's not been excised.
Yeah.
So it will read, the committee must afford the holder of a public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert of his or her choice.
Correct.
It does not say when, where, how.
Yes.
So that's how the rule now reads.
Yes, no, I agree.
Now you say when the panel, and that's before the National Assembly referred it to the committee, there was no issue there, legal representation.
Yes. And all I'm saying, Justice, is that if you read it in context.
So the proceedings or the work of the committee, that's an open question.
Yes, that's an open question, but one thing is for sure. That's why I'm saying you can't have it both ways. It's either you say the proceedings, as Mr. Badlander says, you say the proceedings started on the 16th of March, but then it means everything that has been done until now has been illegal because it is not in compliance with Justice Mkhwebane's.
Depending on how you interpret it.
No.
Because if you interpret it just to be heard in your defense, assisted by a legal practitioner or legal.
Yes, then it means the inquiry itself.
The hearing itself.
Yes, yeah. But you see, and that would be.
But that won't affect the definition.
No, and it will.
And the interpretation of.
Absolutely. We will still have to succeed. You're quite right. It's just we would still have to succeed. It would simply mean then that right only kicks in at the hearing literally, not the proceedings as said.
Well, it's if it's the right to be heard in your own defense, it means that you will have legal representation when the particulars are provided to you to prepare that.
Absolutely. Yes, but surely it should also mean that you must be at the lowest. You must be consulted and engaged when the terms of reference are being finalized and the program and the dates of hearing. That's what happens anyway. You can't say I have a right in your court, Justice Erasmus, to be legally represented. But then you just sit with the other party one day and determine the date of hearing without me even being notified or whatever. I must just watch in the news like everyone else as to surely, man, the right to full legal representation, and the Constitutional Court must have used those words advisedly. Full legal representation means full legal representation. It doesn't mean 3/4 or 98% or 95%. It means full legal representation, as we all know. Okay, to do this.
Gina tells you you're going to miss your flight. I just want to say that to you.
No, I didn't hear. I missed when you said that. I've asked myself, not. And then, then we have. Let me just. Yes. The point I was making, which I was making, I think we moved on to something that was this justice. If you look at what we all know as contextual interpretation, it would be permissible to go into what were the words that were removed by the offending words. And I'm saying those offending words were that the legal practitioners may not participate in the committee at all. Whether at any stage, that's what, and the antidote that was prescribed by the Constitutional Court was full legal representation. That's the one submission I want to Then there is, let me just give you this one to show you some of the dishonesty, apart from the one that we've pointed to. Mr. Tinoli, and I won't go to the references because I don't have time, and it's in our reply, I think, or the heads. Mr. Tinoli says, despite everything we're saying here, he says, under oath, I decided to suspend the process because of the reasons we discussed yesterday. Mr. Janti deliberately lies to this court, and if need be, we're going to charge him with perjury himself. Because there's no protection here, the protection is there in Parliament, but he can't lie to this court. He says, at paragraph 8, he says that no, and he does it in a clever way. You know, he puts a quotation, but takes away the part with the quotation and unquotes the part where he's changing, he's replacing one word with another one. He says, no, Mr. Tinoli decided to suspend the proceedings because then he puts the code. So he was not dishonest enough to change the quoted part. But that can't be a coincidence. That's a deliberate misleading of this court, or thinking that we're not going to pick it up. But is now switched the word process for proceedings, so to fit this particular case. Mr. Tinodi never did anything of the sort. He simply said, let's halt the process. Whatever.
And he advised the Constitutional Court of the fact that they've done that.
Yes, and the reasons, which is important. And one of the reasons was that even if we can continue, if the lawyer is not there, we'll just be wasting our time.
I think it's paragraph 77.
97 and 98.
97
yes,
and 98 of that affidavit.
Yes. And we will go, if you go, I think particularly 98, Justice Erasmus, you will see, you will find this 1038.
You don't have to read it.
Yes.
We know we can find it.
You know what to find it, yes. And Mr. Judge's affidavit is quite short. Yeah. You will definitely find it. But you will see it's amazing. Even I have been reading this, I only picked it up maybe 3 days ago, and was startled that the word process has simply been swapped and put the word proceedings. That's the kind of thing we're dealing with here. The last one, just to know, the last said about Mr. Mkhwebane, the president says to this court, and Ms. Pillay said it this morning, no, Mr. Pofu is wrong because the 96.2b doesn't apply because we're only dealing with the official function and not In other words, there's no private interest. Firstly, that's wrong for two reasons. Section 196(2)(b) doesn't just talk about the public-private thing. It also talks about fighting against your office, your own office. But they conveniently want to forget that. But let's even go to this private thing. The president says to this court under oath that, and Mr. confirmed it. But you must go to the sealing of documents, pleadings. I think it's paragraph 26. You'll be shocked. The president says there that, no, I don't understand why these people have cited me there as the president, because this is about my private dealings as the ANC. He even says, I even went to the integrity committee and so on. In other words, in my private capacity. But this morning, his advocate was saying the exact opposite. And again, we're not blaming the advocate. It's because that's what is in the president's affidavit, that there's no private element. But that's just untrue. It's simply untrue. It can be, one of those statements, both made under oath, is false. When you put it that way. So, and then we're told that we're making this so-called conspiracies up. But that's exactly what we're dealing with. Those are the kinds of litigants that you have before you. The last point I want to make is about the bogeyman outer. I was defamed myself, fortunately, in my presence, because I was accused of having considered that outer applies, and I think I was saved by Justice Erasmus. I never made any such concession. I simply said, my argument is very simple. A, outer does not apply to both 1 and 2. Both prayers 1 and 2. And then I say 2. It secondly doesn't apply to the second prayer because of what Chapter J said in 113 of EFF Goda. But then I say, if I am wrong in relation to prayer 1, which is the normal interdict, then the argument is that we have in any event complied with outer because we're likely to succeed. And so it's a very simple argument. I don't know how anyone can misunderstand. And then lastly, I say that outer does not apply because if you go to, I think it's paragraph 50 of outer itself, Musaneke J says, one of the exceptions, and so does Froneman J, is that if you are invoking other rights other than Rule 33. In other words, you're not just saying to court, I'm here to assert my right to review. If I'm here to assert my right to dignity, my other rights and so on, then outer cannot apply to that. Both Justice Froneman and Justice Musaneke made that point. But Justice Froneman makes it so easily. He says that if you are here to assert any fundamental rights other than the right to review, then you can't apply outer. Secondly, he says what you are dealing with is not a polycentric policy decision where separation of powers might be involved, then you must use the normal Sekukhailo test. That's all we're saying. It's very simple. So, it's paragraph 50 of outer, and that's the Musaneke judgment. And the other one, but again, the Froneman J judgment is maybe 10 paragraphs. I'm sure the lordships will be able to pick it up. I don't think I need to dignify Mr. Barlander's thing about. He says his client cannot be expected to pay the cost for having to defend, I don't know what. Nobody, they brought themselves here, nobody brought them here. So I don't know what it is that they must not be expected.
Just to make that point, I mean, it's clear from paragraph 7 of the founding affidavit.
Of our, yes, of the affidavit. Finally, the Rule 28, we would like the amendments to be made to include the what we call taxi, so to speak, or the new.
But that will come in at paragraph 2.
Yes.
For now.
Yes.
Just to include the so-called, let's call it rescission 2.
Let's go. We'll call it yes. The decision instituted on
the 11th
of May. Yes. And that's really, I never thought anyone was going to go to those lengths of technicality. But let's do it like that. And as far as your question, we should legitimately ask Justice Erasmus whether that can be done without affidavit. The answer is this. That is actually the purpose for us to have instituted the Rule 65E proceedings. So it's all there. The affidavit is already there. What maybe we didn't do is then to say, therefore, do that amendment. But the justification for the amendment is what the Rule 65E was all about. Because we were saying that effectively, we are therefore back to square one. That was that whole story in that affidavit is about that, is to say because of that, of the institution of those proceedings, therefore it means we have pending litigation, to summarize.
You see, the easiest way to prevent any confusion is your attorney, for example, tonight,
yes,
only tomorrow morning,
absolutely,
forward the proposed amendment to all the parties. And then they can respond by tomorrow afternoon, whether they just abide or oppose or whatever the case might be.
Can we make it by tomorrow? Just because
tomorrow afternoon.
Yes.
And then
lunchtime.
If anybody wants to file, and this applies to all the council, an additional note to share it with your colleagues, we would prefer to have it by Sunday.
Yes.
So that we don't duplicate the work.
Yes. Now, what we will then do, thank you, we will have a private arrangement. I'll speak to my colleagues. We will do the amended page by tomorrow, and then if anybody will give them a day or so, and then if anyone is objecting, then by Sunday, as you say, then we'll submit. So, and the reason for that is that this is a crucial thing. As I said, that was the purpose of doing the Rule 65E. It's crucial for two reasons. The fact that there are pending proceedings, and I cannot emphasize this point further. It does not matter what you think about the merits of that pending litigation. It's the law. You may not, for purposes of Rule 89A, you may not talk about pending litigation. It doesn't. You can't say, "Oh, I'll only apply Rule 89 when I think it's meritorious."
Well, the rule reads, no member may reflect upon the merits of any matter on which a judicial decision
is pending
in a court of law is pending.
Very simple. Thank you. So it's important for that purpose. It doesn't say, just like Rule 18, the examples I was making to Justice Delamo, it doesn't say it will be only suspended if you file a meritorious application for leave to appeal. Just by filing an application for leave to appeal, Rule 18 applies. And that is why, by the way, if you go to Rule 45A, I just want to clarify this for you, Justice Delamo, because you asked a question that worried me about whether we should await the Rule 45A application.
Yeah.
No, this is the Rule 45A application.
This is not going to be argued in the parliament.
Yes, no, prior to is indeed the 45A application and or 172. So it's already here. And that's why Rule 45A, if you remember, reads like this. I'm paraphrasing. A court may suspend any order, and then it says, provided.
This is phrased.
Oh, thank you.
In paragraph 2.
Yes. No. I'm just saying the rule itself, Justice Delamo. The rule itself reads. It says, and this is that. I'm just saying. Remember that debate we had yesterday about the comparison with Rule 18. I want to emphasize the point that I mean, with Section 18. Even the drafters of this thing actually do that. Because it says, the court may, on application, suspend the operation and execution of any order for such periods as it may deem fit, provided that in the case of an appeal, such suspension is in compliance with Section 18 of the Act. So the people who were drafting this knew that what they are really doing is to bring a pseudo Section 18, if you like, but only which applies to rescissions and other orders. The only difference, which is what we ask for the development of the common law, is that we are saying that distinction should not be there. It should actually, we should have the same situation as we have in Section 18. The only difference that here you must apply, which we have done now. Under Section 18, it's by operation of law. That's the only difference. But the suspension effect is exactly the same. The suspension effect of the thing is the same, except here you have to apply under Section 18. It happens automatically. Oh, delegation. No, Justice Erasmus. I was pained when you talk about the issue of delegation. No, it is not our case by any stretch of the imagination, and I'm not saying you were suggesting it is, but some of the answers suggested it was, that the president, because of the conflicts of interest, may not delegate the power. That's actually exactly what he must do. We say at paragraph 61, 67, I think. At page 28. We make this very clear. We make it very clear. It says, surely, the president, remember, said in the previous litigation, I'll give this to another cabinet member who's not tainted like me, something like that. So, and we say that in 67, the president's current participation in the removal process. And another fallacious argument is this thing that says, no, he's not yet suspending. No. The president has considered himself that by writing that letter, it was a trigger. That's what we said. We were triggering the suspension process. And he confirms that in his answering affidavit. So he can't say, no, I'm just triggering, even if I'm conflicted. But you're triggering a situation that says, show me a reason why I must not suspend you. So that by triggering that, the illegality already.
You've now given the part A of the answer, so to speak, and in that he's requested to recuse himself.
Yes, no.
By implication.
The issue, and thank you very much. That's why we said if the relief that you're going to give, let's say you're going to reserve judgment for a month or whatever, then we're going to ask this court to give us interim protection. Why? Because remember, all things being equal, we have to respond on the 26th to the president, to the wrong president, in our version at least, to the wrong person. So that's what we're interdicting. We're not interdicting.
I saw it in the affidavit, the latest affidavit, that the interim relief pending the judgment here. It hasn't been fully argued. There's no, and I'm sure that there's going to be opposition to any amendment in that regard, and then we'll have to deal with it.
Okay, no, but I accept that.
You would have noticed that I was giving you tight deadlines for the advocates. We understand the urgency of the matter. We understand the national importance of the matter. And we will try our best, because what people see here is but part of the matter. We still have boxes behind us. It's thousands of pages. So we will have to attempt amongst ourselves in our own way to see how expeditiously we can get at least an order.
So
Yes.
any party can feel free to bring any.
Yes, to bring anything. And let me just assure you, Justice Erasmus, we'd rather we have more interest in a proper outcome than avoiding to write some letter. So
because the 26th, I think, is the current deadline.
Yes.
That's Tuesday, Wednesday.
That's Thursday.
Yeah. For Thursday next week.
Yeah. And quite frankly, we don't care if
but
we have
I am sure that the President might agree that I won't take any action
until there's an order.
But that's not for him taking action, that is deadline.
Yes, that's only deadline. No, we'll discuss that. Let me just say this for the record. Ms. Pillay has been the best opponent to deal with. So on those kinds of things, I'm quite sure we'll be able to find each other. Particularly now that we know that the court is not going to sit here for 6 months. So I'm sure we will find each other. But what I'm saying, worst case scenario, even if they say no, we'll just give them the letter. Because we might be giving it to the wrong person, but so what? The point that that we're making is that that we were making about the 26th is that the reason we only gave him the part that says you are conflicted was so that he must stop and step aside. We were hoping he would do it voluntarily without having to come here, and then we would then give the reasons to whoever, to the real sustaining authority at a particular time. But if he wants it now, that's God pleases.
Mr. Mpofu.
I'm sorry. No, I'll prioritize the judge. Junior can read.
I must say I mislocated your rule 45A in the sentence in which it was used.
Yes.
So you're right.
Thank you. Thank you, Justice Talon. That way I'll be able to sleep at night. I was worried when you asked that question in the morning.
Well, the fact that you put in between commas in terms of Rule 45A
yes.
it's easy to miss.
Yes. Res judicata, red herring. There's no such thing. Res judicata issue a stopper. Res judicata cannot be raised against a judgment that is not final. Okay? So we kind of res judicata of the Saldanha judgment, number one. Res judicata must also be raised with or the one who raises it must bring all the pleadings and all the, not just the judgment. I heard you, Justice Fatma, saying a judgment. Doesn't work like that.
Well, the judgment's in the bundle of authorities.
Yes.
But it happens to be one of our internal cases where the court records are public.
No, it doesn't work like that. That would be illegal if you did that. You can't go and grab pleadings from the archives. Yeah. No, the onus is on the party that is pleading res judicata to give you all the pleadings, to give you the thing. It's a very simple principle. Sorry.
Yes.
And whether it's issue a stopper or res judicata, it only applies to final judgments. It would be ridiculous. I mean, this is all, I explained this yesterday. If you say, I want interim order because you didn't pay me my salary this month, and then the court says no, go jump, and then you don't pay my salary next month, then I can't bring another interim order because it's res judicata. What is that? But if it's a final order about the rights between the parties, then obviously res judicata applies. But in any event, the Saldanha judgment had a review. It was about constitutionality, unlike here, and then it also was wrongly decided. We said it was clearly wrong because it found for one mark that is technical. I almost forgot that. That's very positive. It's just a red flag that is being used again to try and bamboozle the court with all sorts of technicalities.
Thank you, Mr. Mpofu. we will take time. I've given an indication that the parties can file documents insofar as it relates to the amendment sought of paragraph 2 of the notice of motion in terms of Rule 28, and then any further submissions that the parties want to submit to us by Sunday evening coming. I need to thank the parties for their cooperation in the fact that we had to slot in by rescheduling other matters. So both my colleagues had to step out of other cases, and we could only have the 2 days, so we sat double days. And we intruded on private time of court staff. In their absence, but I know that they will look at some of the recordings tomorrow. The IT staff, don't know whether any of them is still here, for facilitating the setup of the court with the basic stuff that we had in-house. And we could do it without glitches. I indicated to the court manager that, speaking for the bench, we must express our appreciation to the support staff of the judiciary in the division and the manner in which they conducted themselves. Speaking for myself, because I haven't canvassed it with my colleagues, I'm very proud in the manner in which our support staff in this division have conducted themselves in order to make things happen. Mr. Engels, thank you, because you're the only one left. And don't forget to take my textbook from Mr. Mpofu before he leaves.
I may try to underline anything to bring it to your attention. My Lord, I really also wanted to say, and I know that I speak for all my colleagues who are not here, to say that cooperation from this particular bench has been really unmatched. Because this matter, as you say, thousands of pages and pleadings have been coming literally until the day we started.
Until the morning.
Until the morning of the day, not after the morning. And we were really grateful to the bench and to the court, all my colleagues.
Just before we adjourn, I could see Mr. Similani unmuted himself. Yes, Mr. Similani.
Yes, I'm sorry to disturb Judge and my learned colleagues. Judge, if you'd recall, I know it's late in the night. We're scheduled to reply after Advocate Mpofu, even if it's for a few minutes. But looking at the time, I've contacted with my learned senior, and with your permission, would request to rather maybe put a note to the court, which we'll share with our colleagues, and then raise the issues we wanted to raise in reply.
That will be fine with me, Mr. Similani, as long as you just copy in your colleagues, and it can come to us. You all have contact with my register, and we will distribute from my office. So thank you, Mr. Similani. Any of the other advocates want to raise anything before I adjourn? Mr. Breitenbach? Nothing. Ms. Pillay?
Nothing, thank you, judges.
And Mr. Budlinder, I saw you.
Nothing, thank you.
Thank you. All right, then the court will adjourn.